inquiry. Is everyone here who needs to be here? I can see various people appearing on my screen, and including the three advocates. So good morning, everyone.
Good morning, sir.
Good morning, sir.
Thank you. So for the benefit of everyone in the room, this is the resumption, day 4 of the inquiry into the decision of Hertsmere Borough Council to refuse planning permission for the development of a film and TV production studio at land to the north of Sky Street Studios Elstree in Boreham Wood. So obviously we are on Teams this morning. This is also being live streamed through the council's webpage, I believe. I've seen the link on there. I haven't checked if it's up and running, but I'm sure I'll be told if it isn't. Is it not running? So thank you. So just a few housekeeping rules. Make sure that mobile phones and other devices not in use are switched to silent, please. And if you're unless you're speaking, please ensure your microphone is muted, and cameras do not have to be on unless you're sort of taking part in a session this morning or later on with the closings. In Teams, there are various functions depending on the version you're using. It is possible to raise your hand using the toolbar at the top, and we can do that if anyone has questions. The chat function it's been turned off, so that's okay. So we won't be using that, and that's fine. I didn't want it active, as it can be distracting. And obviously just shout if there's any technical problems or if you can't hear somebody or see them. So I think everyone is here who we're expecting, but let me know if we're missing anyone or we're expecting someone who hasn't turned up yet. But I think we'll continue with the opening remarks. So today we'll be hearing a roundtable discussion on conditions and obligations. That will be the first session. That will take an hour or so. We'll then have a break and then begin to hear closing submissions from the main parties, with the Rule 6 party going first, followed by the council and then the appellant. Last week, we obviously heard from interested parties and had a Q&A session with technical consultants. We heard from all of the parties' witnesses over the course of the 3 days we sat last week. And then on the Friday morning and lunchtime, we had a site visit to Sky Studios itself, and then onto the appeal site, and then to the wider area, including going up as far as Strangeways Farm. So thank you. That's what we'll be doing today. And obviously we'll hear if there's any cost applications, we'll hear those today. I've not been notified of any, but if there are, we'll hear those today. And then finish the inquiry at some point this afternoon. Any questions before we move on? Ms. Dunsford, you have your hand raised.
Hi, yes. I just wanted to raise a procedural point before we went into the conditions session, if that's okay.
That's fine.
Okay.
I have a few of my own anyway, so we're not starting yet. But what was the point, Ms. Dunsford?
Well, I saw yesterday that Rotham Park Estates has sent a letter in to Legal and General about the Well End walking fields. The letter states that there's no public access across those fields. And you'll remember, sir, that we freely entered the fields across one of the 2 access styles and walked across the well-trodden path through those fields. The public's been walking those fields for as long as anyone can remember, and the styles allow both dogs and walkers through. So I shared this letter yesterday with the residents of Well End's 2 main roads. And I've got more than 20 residents who've been walking these fields for over 20 years. One stated 70 years, one 50 years, one 37 years, and so on. So Rotham Park's well aware of the public use of these fields. We had a tree fall over the stile last year, and when it was reported by a resident who walks the fields, they came to clear it. So I just wanted to make a point that although it's not a public footpath, it is a public right of way by prescription. I'm not quite sure why the document has been submitted, because it's not part of the site that is under the expansion. But I just wondered, so whether you'd like me to submit evidence to the appeal to support this long-term use by residents.
Let me turn to the parties first, Ms. Dunsford, but thank you for raising it. I was going to come. I've been received this morning. I know it was sent last night, but I only saw it this morning. So Mr. Tucker, this is a note, I think, from as Ms Dunsford explains, a note from Rotham Park Estate about that piece of land. Anything you want to say by way of introduction?
Yes, sir, by all means. You'll recall that Mr. Williams said that he wasn't sure what rights were being exercised in relation to that, and that we undertook, you'll recall, last week to see if we could find out. The question was asked of the landowner, and that's why the letter was sent to us, and we forwarded the letter on to your case officer, sir. So that's how the letter has come about, no more than Mr. Williams questioning that he didn't know what the rights were. In relation to that, I've certainly no objection to additional information being provided to you about a prescriptive right, although I have to say I'm slightly nervous about going into legal niceties about matters, about the nature of any such right. One can have a prescriptive right as a result of 20 years uninterrupted user without challenge, without fraud, without force, etc., across a defined route. My understanding is that it's not suggested that there are defined routes, it's the use of the field. There are also ways of securing prescriptive rights in relation to an area of land through the village and town greens process. Although you'll be aware, once a planning application has been submitted, that doesn't apply, but there is no application in relation to this site. So there may be a future town or village green application in relation to it. I think the easiest thing to move matters forward, sir, is simply to say that we have clarified matters from the landowner from their perspective, but that the position of the landowner is disputed by the Rule 6 party and members of the public who contend that they have been using the field for a significant amount of time. Obviously, if an application is made, it will take a long time to process, and it's unlikely to be determined prior to the consideration of the Secretary of State in this matter. So I'm happy that you treat it as essentially a disputed issue, but so you'll recall we sought to do this simply to follow up from Mr. Williams' lack of knowledge as to what rights there were, and it would seem that the landowner has a particular position that's set out in that letter. I'm happy to deal with it in submissions, but it's really a matter for you, sir, whether you want to hear additional information beyond the fact it's disputed. Certainly. Okay. Certainly, you'll note, sir, that we have not invited you to ignore views from the walking field.
Okay. Thank you, Mr. Tucker. Ms. Dunsford, do you want to say anything in response, or anybody else from the Rule 6 party?
Just one thing that occurred to me when you were talking there, Mr. Tucker, is that I think you remember, Mr. Aldridge, that there was defined paths you could see across the fields, the routes that people had been walking on. I think you said on your first visit you followed the tracks that people had walked on before. So, you know, happy to provide the routes that people walk. Completely happy that you're agreeing we're disputing that, and I'm happy to provide more evidence with names and addresses of residents with over 20 years use. I can get that this afternoon.
Okay. Anybody else want to say anything on this point? Mr. Tucker?
Yeah, as I said, there's two routes to acquire prescriptive rights of the type being described, one of which is across a defined route, and one would need evidence of 20 years uninterrupted user across the defined route, or via the town or village green application approach. I'm not sure you do need the evidence, and I'm slightly nervous about the notion of evidence being submitted after closing submissions, when it goes to a point where essentially, sir, you can note that there is a dispute as between the landowner and the public about the nature of the rights in relation to that. As I say, sir, we invite you to have regard to views from that field, but noting the nature of the position as between the landowner and the residents. I'm not sure you need additional information. As I say, I'm slightly nervous about evidence coming in after closing submissions, because that would necessarily require all the parties to respond to that evidence if it raised anything new. But I don't mind details of that being noted down from the exchange that you've just had this morning, sir. Certainly, I'm not challenging that the residents believe that they have the right to use the field based on 20 years uninterrupted user.
Okay. Thank you, Mr. Tucker. And I also noted your point that you're not inviting me to ignore those views from the field either.
No, sir, that's correct.
Thank you. Ms. Dunsford, in terms of the evidence that you were thinking of providing, is it largely just the testimonies of residents that was that the main source of evidence?
Yes, I've got names, addresses, and how long they've been using the fields. Happy to go whichever way we want to go with this. It's fine.
I mean, thank you. I mean, I don't get the impression that the appellant's going to challenge the testimonies of residents, in the sense of that if they say they've used it for 20 years, the appellant's not going to say, we disagree, you've used it for 20 years or whatever, or plus years. I think it does sound like there is a bit of a dispute here, and obviously the appellant's not inviting me to ignore the views from that field. So I think
that's fine.
With all those caveats, I think it's probably not something that's going to be resolved quickly, I think, unfortunately. So not before closing today. But thank you for raising it. Obviously, I was aware that letter had come in, and I was going to ask parties for their views. But I think we're in a position where we kind of agree to disagree, and I will make sure that's clear in my report to the Secretary of State.
Thank you, sir.
Thank you, Ms. Tunsford. Anything else on that matter? If not, then just in terms of other procedural points, and we will come to other documents. So I've not been made aware of anybody else wishing to speak. I think we are pretty much at the end of the opportunity for any new speakers to come along to the inquiry anyway, but just to make you aware, I've not been told. I have received another written representation in support of the appeal. It was received last week from a J. Olberg, a very similar letter, I believe, to the other letters we've had in support. To be consistent with the others, it's sort of been added to the folder for the Secretary of State to read. It's not been formally accepted as a document for the inquiry. Happy for it to be shared with the parties so you see it if you haven't seen it already. But it's a sort of, just to make you aware that that's coming. And obviously, after today, and particularly after the inquiry is closed, I won't even be in a position to kind of add anything. It will be for the Secretary of State to decide whether or not any very late representations can be considered or not. But has anybody seen that representation or aware of it? Shakes of heads from most people. Okay, well we'll share that. As I say, I believe it's in support, and I don't think it adds anything new to any point. So I'm not certainly seeking evidence or response to it, but I'll make sure that gets shared just for completeness, and we'll obviously make sure that goes in the folder for the Secretary of State to see. Then in terms of documents, since we adjourned on Thursday, we had I think we were up to inquiry document 10 was what the first thing received since adjourning on Thursday. I think ID 10 is the legal note on biodiversity net gain, which will no doubt come to in due course as needed. ID 11 was the site visit map. Obviously, we use that for our visits, and it's now in the public domain, so people can see where we went to or where I've been to. And then ID 12 came in as a traffic note, and so this was a response from Ms. Balboa to the evidence provided with Mr. Morris's statement last week, and obviously this was something that was intended to be presented to committee, and I'm not sure if it ever was seen by committee. Certainly, I know the statement wasn't read out as planned, but there was the diagram at the end showing the sort of traffic distribution. So, Mr. Tucker, anything to add to that?
Nothing to add, sir. You'll recall that when it came in, we hadn't seen the note before, and that section 1.3 of what is a very short document, Mrs. Balboa deals with Mr. Morris's position with regard to the 3 or 4 points that are made within that letter. I'm happy that you take that as a written document of our final position. Essentially, it's a cross-reference to documentation that's already before you in any event, sir. So I can't imagine it caused any problems.
Okay. Does anybody else have any comments on that document? No. Okay, thank you. So we'll obviously that's added as ID 12, and thank you.
So sorry to interrupt. I tried to raise my hand and that doesn't seem to be working. So.
Oh, sorry, Mr. Morris. Yeah, sorry.
Yeah, no, I'm sorry. It may be that I hadn't actually seen that document. I had asked Mr. Taylor if it was available, and I think he'd queried it, but it doesn't seem to have been disseminated. However, rather than discuss it now, you will see I had requested a traffic condition, and so perhaps that's the time to bring it in rather than have two separate discussions, if I could suggest that.
Happy to leave that for the conditions discussion. I don't know if that condition's been shared, Mr. Morris. I don't think I've seen it.
So I sent it to Mr. Legg, and
right.
When did I sent it on the 31st of March.
Oh, okay, right. Maybe need to check that and see.
And luckily, I did copy in, I think, the other parties as well. So that's rather unfortunate that you haven't seen it. I did use the addresses that he had provided in a message. So I'm not quite sure why it hasn't come through.
No, don't worry. I think sometimes things slip through the crack if there's a number of emails all coming in at once. But that's that's not an excuse, but it's just a reality sometimes that things get missed. But obviously I can chase that up and it can be shared again, I'm sure. Mr. Tucker, you have your hand raised.
Yes, so just to help you finding it, it was sent at 27 minutes past 3 on the 31st of March, and I'm grateful we were copied into that email. So we've seen the comments in that regard.
Okay, well, I'll chase that up and hope to have that before me when we come to the discussions. And I think all the inquiry documents up to inquiry document 13 are both on the Google Drive and also on the council's planning portal. So hopefully anyone wanting to find them can find them. So we'll come back to anything to do with traffic in the conditions session. Then updates to the condition schedule were provided yesterday. That's been added as inquiry document 13. I know that there's an email this morning clarifying plan numbers for condition 28. So thank you for that, and we'll come to that when we get to that relevant condition, just to double check we're all content with the numbering. And then obviously in terms of documents that have arrived in the last sort of 12 hours or so, or certainly in my inbox, so we have a note from Mr. Williams on the public right of way from Strangeways Farm and Rowley Lane down to the A1, which takes in view 4. Hopefully that's been, I think it has been shared with all of the main parties. Essentially, Mr. Tucker, I think this just sets out Mr. Williams's understanding and observations on that route. Is that correct?
That's exactly right, sir. So I think it was more overgrown at the times that Mr. Williams had visited that, and that he said that it had been impassable at the time that he'd been there, although he'd seen both sides of the A1 fence, as it were, and he'd assessed it on that basis. It just clarifies that he'd assessed it on a robust basis rather than a non-existent right-of-way basis, if there was any doubt about that. So that's all.
Okay. I note he says that he questions the amount of use of this footpath, but for the avoidance of doubt, both the LBIA and my evidence is based on this route being publicly accessible. Is his conclusion. Exactly that, sir. Yes. Okay. Thank you. I just wanted to point out, because my understanding from the hearing last week, sorry, the inquiry last week, was that that you couldn't, in theory, there was no route beyond the field towards the A1, and obviously, just wanted to point out the style and just wanted to make sure that was clear before closings.
Yes, sir.
And
that's understood and accepted, sir. Okay,
thank you. Anyone wants to say on that note? So everyone had a chance to see it and digest it.
So I think it's been sent to the principal parties. It's not yet being uploaded onto the core documents list. So Mrs. Balboa's note was uploaded yesterday. That's ID 12 on the list that I'm looking at. But that hasn't been uploaded, nor has the Rotham's letter.
No, that's fine. I think I was waiting to see what comments were made this morning. Yes, and are there any objections to that being added? Mr. Sheikh, I see your hands raised.
So no objections, but I haven't seen that. It might have made its way to the council, but it certainly hasn't made its way to me yet. So I don't anticipate any objections from what's been described in terms of the contents of both of those letters, but I personally haven't seen them yet.
Okay, but hopefully that'll be on its way to you if Mr. Faulkner or somebody else can forward copy.
Yes,
thank you. And any comments from the Royal Six Party, Mr. Ronan, on that letter, the Mr. Williams letter?
No, sir, thank you. I'm in the same position as my learned friend. not seen it personally. Don't anticipate there being an objection, but I'll be told otherwise if I'm wrong.
Okay, well, hopefully both of you will get a copy shortly from your respective teams. Thank you. Then there, obviously, yes, you had the letter, the Rothman Park estate letter. We've discussed that one already. Obviously, I'm happy. Well, I don't get the impression that anyone's objecting to its inclusion. I just double check that first. Any objections to it being added as an inquiry document? Anyone? No. Okay, so if that can be added as ID 15, then we'll have that on record. And then had an email with the clarifications, the differences between the version 14 of the unilateral undertaking and version 16, which is the one we'll be looking at today, the version. That I haven't looked at this in detail. I only unfortunately received it this morning, and obviously was requested a week ago, so I'm not apologising too much for having not read it yet. I did actually spend some time yesterday. I kind of given up on getting the notes, in fact, almost. So I went through the version 14 and 16 and used the track changes version 15 to work out what had changed. So we may be worth having a shorter German before we get into the obligation, just so I can have a read through and make sure there's nothing that leaps out at me. But hopefully everyone's seen that, and hopefully it's nothing too major, Mr. Tucker, or anything else.
You'll be surprised, sir, how not major the changes were between 14 and 15. So of course, and you have our profound apologies on behalf of the solicitors who hadn't produced it at an earlier stage. So apologies for that, and that may have interfered with your preparation. However, I don't think so. You'll see it will make much of a difference in any event, even had you had it.
Okay, thank you. Well, I'll say we'll have an adjournment before we get into obligations, just a short one. Just so I can go through it. Does anybody else have any comments, anything from the council or the Rule 6 party on that? Okay, so we can have that note as ID 16, and I think the kind of track changes documents that go with it can be added under the same number. If so ID 16 is the note, and then maybe ABC is the three attachments that show the differences, just so that's on the core document library for clarity. And then I've had closing submissions come through from Mr. Sheikh on behalf of the council. Thank you for that. Obviously, we won't be coming to those yet, but I've just to acknowledge I've received those, and obviously we'll look out for the closing submissions from the Rule 6 party and the appellant in due course. One thing that has just popped into my inbox literally a minute after opening, and it was only sent, I think, 5 minutes before we resumed this morning. There was a letter from Oliver Dowden MP, the MP for Hertsmere, which I wasn't aware was coming. I don't know, if anyone else was aware that it's coming, and obviously I've not even looked at it yet. So, Mr. Tucker, anything you can clarify here?
Yes, so it's a bit odd. It's coming via us. It's a letter which when you see it is obviously publicly facing, and it doesn't actually say very much. But nonetheless, it was received by the appellant on the 26th of March, and we immediately clarified as to whether or not the MP wanted it drawn to the attention of the inquiry, which is what we assumed was the purpose of it being sent to us, but it doesn't say that, and it's not addressed to the Planning Inspectorate. We haven't had any response back from the MP or the MP's various assistants to say that it shouldn't be provided to the inquiry. So we've left it to the last minute, just in case we got a response to the contrary. So it's neither supportive nor unhelpful in relation to, I think, any party's case, because it doesn't say very much. But nonetheless, we think it's appropriate to draw it to your attention. So apologies, it's come late, sir, but it's come in rather odd circumstances. To us, it's very short, and I'm sure the parties will get an opportunity to have a look at it during the course of the day. And we have worked on the assumption that we'd rather draw it to your attention in case the MP wanted it drawn to your attention, rather than the other way around, if you see what I mean.
Okay. Thank you, Mr. Tucker. I appreciate that the other parties may not have. I think it's been sent to the other parties. Yes, it has, but we may not have seen it yet. But any initial response from the council, Mr. Sheikh?
Nothing particular. So I'll have a look at it once I've received it. if it doesn't say anything particularly strong either way, I don't anticipate any objection to it.
Okay, thank you. Mr. Ronan, any comments for Rule 6 party?
Again, I echo that, sir. Thank you.
Okay, well, we'll kind of, yes, well, maybe part that one for now. It will nominally be given an ID number of 17, or we can sort out the numbering later. But yes, I think if during a break we can sort of all have a look at it, and then when we come back, we can just double check nobody has anything they wish to say or object to or anything like that. So that would be good. Thank you. I think that's it then in terms of outstanding documents. I think we have everything covered. Anything else from anyone else in terms of documents?
Not from our side, sir. Thank you.
Any other procedural points, Mr. Tucker, before we start?
Nothing else from our side, sir. Thank you.
Okay, Mr. Sheikh, any other documents or procedural points?
Nothing from me, thank you, sir.
Mr. Ronan, Rule 6?
No, sir. Thank you.
Okay, thank you. Okay, so what we'll do next is I think we'll probably turn on to the conditions first of all, and then maybe have a short break and then look at obligations, unless there's a burning desire to do it the other way around, or any availability of participants to do it the other way around. So we will just get the conditions list up on my screen in front of me. And in terms of participants in this session, is it largely going to be the planners, as it were, for the three parties, so doing most of the talking, and then barristers chipping in as needed? I think nods, Mr. Tucker and Mr. Sheikh and Mr. Ronan too. So fine, we'll work on that basis then. And as this is a roundtable discussion, just to explain, obviously we've not had one of these sessions yet in the inquiry. It's open to anyone if they wish to sort of make a comment as we go along. Just indicate if you wish to by raising your hand on the toolbar. Obviously, I've also already explained. Obviously, my report will include conditions because that's for the Secretary of State. But obviously, the discussion is without prejudice to any report or recommendation that I may make. But obviously, it's a necessary part of the process. Mr. Taylor, you have your hand raised.
Thank you, sir. Just to confirm that I'll be making comments, for very few, rather than Mr. Dingle on behalf of the Rule 6 party for the conditions session.
Fine, thank you. Yes, I see Mr. Dingle doesn't appear to be in the call anyway, so that's fine. Thank you, Mr. Taylor. Otherwise, I think Mr. Faulkner and Mr. Goldsmith are representing the council and the appellant. Okay, thank you. So we'll go through then the conditions based on the updated version provided yesterday. So hopefully everyone's got a copy of that in front of them. There's been various changes that I know that now have sort of resulted in conditions being pre-commencement. This is just an overarching point. I think only condition 34 explains why it's a pre-commencement condition. So I think as we go through the other ones, we'll need just to sort of clarify why they're pre-commencement, and obviously consider whether or not we need anything further in writing from the appellant agreeing to any pre-commencement conditions. I think there are only 6 other conditions where they are pre-commencement. I think that's 3, 6, 16, 18, 30 and 32. So that's 3, 6, 16, 18, 30 and 32, as well as 34, which is always pre-commencement. But we'll stop at each one as we go along. And obviously I'm not seeking this to be changed now, but the ordering of conditions is slightly random in terms of where things appear. We have lighting and drainage conditions sort of popping up in different places, and pre-commencement conditions all jumbled up. But in order to save everyone's sanity, I'm not proposing we change that numbering now. But I think in my report, I may well attempt to order them in a more logical way, just so you're aware. And it's probably something I should have raised at the CMC, but there we go, not to worry. And I think once we've concluded this discussion, it probably would be helpful to see a clean and updated version of the schedule, including any explanations for pre-commencement conditions, and if we need further agreement in writing from the appellant on any pre-commencement conditions, we can obviously cover that as well. So that's all the kind of general overview points I wanted to make. Anything by way of overview from anyone else? If not, we'll go through conditions. Hopefully, most of them will be quite swift, and we'll kind of stop at anything that needs more discussion. So condition 1 sets out the time limit to begin within 3 years from the permission. That's a standard condition, so I've not got any comments on that. Condition 2 now has just plans listed, which again is, I think, is a clearer approach to the process in terms of documents that may not be relevant or may have been superseded. So unless anyone considers plans are missing from that amended condition, I'm happy to leave that condition as amended. Then condition 3, which is to do with unexploded ordnance, has the wording in brackets has now been removed. So this is now the pre-commencement condition, and I'm assuming, well, I don't think there's anything controversial to say that it's probably sensible to check the site first for unexploded ordnance before you do any work on it. So I don't think there's much reasoning, much justification needed for being pre-commencement. I think the clarifications, obviously, that the report is needed to be approved before development commences. I just wanted to ask, in terms of measures that might need to be carried out, there's reference to mitigation measures strategy. Is that something that would be within the validation report, Mr. Goldsmith or Mr. Faulkner?
It would be, sir. It was also, there was a mitigation measures section within the report that was submitted with the planning application.
Is that what, for the whole scheme, or just for this issue?
Well, for this issue, effectively.
Okay. Right. Okay. I don't. That's probably something I haven't looked at recently, but I can double check that. Do you agree that there needs to be some additional wording to say that the measures need to be carried out by a certain time? Because at the moment it just seems to require the report to be submitted and approved before commencement, but then nothing else after that, unless I've misread it.
Yes, I think there should be a time limit on that.
Yeah,
any thoughts on that?
Trying to think where would fit that, but yeah.
It would probably come at the end of the
end.
Yeah.
But it's just when would it be required? I mean, again, without labelling the point, if there are things that need to be removed from the site, is that really something that needs to be done before works commence? I mean, it depends on the scale of unexploded ordnance, if there is anything there, and how much it affects the rest of the site. But I suppose we don't really know, do we, at this stage?
No.
So would a kind of trigger saying the measures should be carried out before development commences? Would that sound reasonable?
Yeah, I mean, obviously the validation report is prior to commencement of any development. I assume the measures, as you say, sir, will be in there.
Well, that's true. I mean,
so perhaps that also sets the timescales in terms of when they need to be done. I would think.
What do you think, Mr. Faulkner?
Perhaps we could add that into the bullet points, the timing of removal or mediation.
Yeah, so bullet point about timings of any
included within the report. Yeah.
Yeah, and then perhaps just a final line that says the development should be in accordance with the approved report. So then it's clear that means the timeframes and anything else.
Yep.
Okay. Thank you. Anything else on condition 3? Anyone? If not, then
no, sir.
Thank you. Condition 4 on land contamination. So there's now wording's been added requiring work to cease immediately if in the relevant area until an investigation and risk assessment has been undertaken in accordance with details to be agreed with the council. And then obviously remediation then is required. I think, again, does this probably need at the end of the penultimate sentence, so when it talks about remediation, do we need wording that says development must be in accordance with the approved scheme, so as in the remediation scheme?
Yes.
Would you agree, Mr. Faulkner?
I agree. Yeah.
Okay. Thank you. So then that just makes it clear that what's required. Thank you. Anything else on 4?
Nope.
Not. Then 5 has been amended just to clarify that any report on soil, any verification of soil needs to be done before it's imported onto site. I think the wording previously was a bit sort of back to front, as it were. So nothing else I was going to say on 5, and then 6 again. Oops. Apologies, I've just managed to somehow lose everything on my screen. Only one moment. There we go. Sorry, I'm back again. Right. So yes, condition 6 on archaeology has removed the wording in brackets, which wasn't relevant to this site, and also removed the word demolition under B. I think otherwise the condition is logical, and I don't have anything else to say on it. Condition 7 is the landscape and ecological management plan. So this I pointed out about the kind of overlap with condition 17 as was, in terms of both requiring an LEMP, and I think the approach now appears to be it's being merged.
Yes, sir.
Mr. Faulkner and Mr. Gosling.
Agreed.
That's great.
Yeah. That. Yeah. And it now refers to pond 1 only, in terms of retention of, which I think clarifies the point I had about P1 and P2. So that's, I think, all okay as far as the reading goes. Any comments from anyone else on condition 7? If not, then we'll move on to condition 8, which is one of the drainage or surface water conditions. So this now has been merged with condition 33 as was, in terms of surface water runoff. So it includes reference to A1 matters and National Highways consultation as appropriate. So again, I think parties are happy with this, or certainly the council and the panels are happy with this. But Mr. Taylor, anything you want to say?
Yes, so thank you. I noted what you said earlier about pre-commencement conditions. The point here, and we're not surface water experts, is the Rule 6 party is unclear why it is limited to no above ground development shall take place and why it's not a pre-commencement condition, given that there may be a risk, I don't know what that risk would be, of there being impacts on surface water as a result of any subterranean works that are taking place on the site. We've got a similar comment to make in a couple of the other conditions, but it'd be useful to know why this isn't a pre-commencement condition.
I'm not trying to remember. There's other conditions that deal with the sort of construction phase and drainage, but any comments from Mr. Faulkner or Mr. Goldsmith?
Trevor, I'm not sure if you want to say, but our view was obviously this is to do with on-site storage post construction. So it's a surface water scheme once it's been developed effectively. So we were happy with no above ground development, which was suggested by the council.
So sorry, just to clarify, so you see condition 8 as being referring to the development itself rather than well, it's
as it is a scheme for on-site storage. So it's a discharge of surface water once the development's in place, I think, is what the council is trying to achieve here.
Any comments, Mr. Faulkner?
No, I tend to agree with that hypothesis.
There is a later condition that we'll come to. I think it's 13 now. Oh no, sorry, 14, which talks about no above ground development shall take place before details and a method statement for interim and temporary drainage measures during the construction phases have been submitted to and approved in writing by the local authority. So that condition 14, I think, is dealing with the kind of construction stage. Does that need to be pre-commencement, perhaps?
I think that might need to be pre-commencement.
Yeah, yes. So I have the same point there. So okay. Maybe that's where it should go.
Okay, so maybe Mr. Taylor, the point is best addressed in condition 14, then, that we make that pre-commencement condition, and yes, the other conditions are for the actual development itself.
Yeah.
Okay. Thank you. Anything else on condition 8? not, then condition 9 deals with noise. Sorry, no, it doesn't deal with noise. It deals with drainage impact study and the surface water drainage scheme for the development. So the difference between this condition and the previous condition is what exactly? How does this differ from the previous condition, Mr. Faulkner or Mr. Goldsmith?
I mean, our view is this condition relates to sort of flood risk and watercourse modelling, as there was a comment attached to the agreed conditions there. So we thought it should still be a standalone or a separate condition compared with the previous one.
Okay. Any comments on that, Mr. Faulkner?
No, that's my take on that one as well.
Okay, and Mr. Taylor, you have a hand raised again.
Yes, sir. I was also confused by this. I think the word drainage is different to surface water, but the condition doesn't seem to go there. But it's a similar point to the last time. I mean, here we've got an express reference to hydrogeological, which is below ground level. So again, same point. Why is this sort of pre-commencement condition?
Any comments, Mr. Goldsmith or Mr. Faulkner?
From our point of view, similar points to the previous condition. We think above ground works is we're happy with that in this context.
Mr. Faulkner.
Agreed, and this condition was obviously recommended by the specialists with regard to a list of conditions in terms of conditions put before us, and they were content those agencies for it to be worded that way.
Okay. I mean, in reality, what sort of work could take place before this condition was discharged? Would it be, it could involve, excavation work and so on, couldn't it?
Yes, it could do. Yes.
Okay. Mr. Taylor, do you have anything else to say? Or was your hand still raised?
No. Well, it sort of was, and it came down, but it went up again.
Okay.
So yeah, I hear what the other parties are saying, but as you say, sir, foundations, it goes to watercourse modelling. It affects the substrata. I don't think all 6 parties persuaded this shouldn't be pre-commencement.
Okay. So something, Mr. Goldsmith, for the appellants, would it be content with it being pre-commencement, or is there a strong reason against it? Or
I don't think we would have a. I mean, we've got to agree it.
Of course, you have to agree the pricing.
So I don't think we'd have a huge objection into it being pre-commencement, sir.
Okay. Well, something I maybe have a think about, reflect on, and I can always advise later on if I think it needs to be. But anything else from the parties on that? Okay, so then moving on to condition 10, which is noise and from plant and equipment. This didn't have any comments previously, and there's been no changes to the condition. So this deals with the effect of noise on residential properties and the levels that need to be adhered to. So happy to move on to the next condition unless anyone wants to raise anything here. Then condition 11, clarification, another noise policy. This is specifically to do with external site activities and filming, whereas the previous condition was to do with plant and equipment. So this has provided some additional clarification as to any studio operational noise from work activities such as fabrication and filming carried out externally shall not exceed background noise level LA 90 at the nearest noise sensitive receptor. And now it also then clarifies the requirement for studio management to carry out to check if there's going to be any exceedance of the noise, and then to put in place a noise mitigation management plan for the council to agree first before the activity takes place. So this is a little bit more information and clarity provided in the amended condition than previously. But Mr. Taylor, you have your hand up.
Yes, sir. It's just a clarification here. Just comparing conditions 10 to condition 11. Condition 10 has a requirement for the background noise level to be 10 dB less as a result of noise from plant and equipment, whereas condition 11 says that it must not exceed the background noise level. And I will see the passage is not clear why there isn't a similar requirement for it to be 10 dB less in condition 11 as in condition 10.
Okay, any comments, Mr. Goldsmith? Or Mr. Bolton, do you understand why that's different?
I'm assuming that the point about the background noise level, if it wouldn't be discernible unless it goes above that noise level. So that I think that's why that's in there from our point of view.
Mr. Tucker, you have your hand up as well.
Yes, sir. I suspect it probably derives from the approach that's taken in BS 4142 about constant noise from plant and equipment, which can be impulsive, and therefore there's a correction factor which is then applied so that what is taking account of that impulsivity. It's a common correction. The issue about exceedance over background is not just exceeding background equals nuisance. You have to exceed it by a particular level. So 11 is robust. I think that 10 is trying to equate to what's in 11, subject to those correction factors from BS 4142. What we'll do, sir, is we'll seek to check from our noise consultant behind the scenes, so we can give you the chapter and verse on that, so you're not just listening to a barrister giving you his vague recollection from previous cases, if that's acceptable, sir.
Okay, thank you, Mr. Tucker. That would be helpful just to have that can be done behind the scenes. Mr. Taylor, anything you want to add?
Yeah, just on that, I've both with Mr. Tucker, I've done a lot of work on music noise in particular, and what I've taken away from all those cases is that noise is very much a matter of personal perception. Film use could be consistent in the same way that plant and equipment could be consistent. It'll be interesting to know from the noise consultant why there isn't a benefit to having a further reduction below the background noise levels in 11 as there is in 10, just in order to provide that gap to avoid any noise harm.
Okay. Well, how soon do you think, Mr. Tucker, we could have a note on that? I'm conscious that we are on the final day of the inquiry.
Knowing how efficient Mr. Goldsmith's team is, I suspect an email's already gone asking the noise consultant to revert back. So we'll try our best. I mean, the point about whether 11 should be different is different from the point that there's a distinction between 10 and 11, and it's why there's a distinction between the two. The latter was what I was addressing, and that's the impulsivity correction factor, which I think may feed into 10, unless there is some other reason. We'll ask the question as to whether or not there's justification to require the same correction in relation to external size and activities from filming. Given that it's not proposed, I suspect I know the answer to that question, but I would observe that not exceeding the background noise at all, which is what 11 seeks to do by LAEQ, is a very robust basis, because one has to exceed it by 5 and then 10 for that nuisance to be likely. But so we'll seek to get an answer as soon as practicable, and perhaps report back towards the end of the morning.
Yeah. Okay. Well, I made a note to come back to that.
Thank you, sir. Maybe in the form of an email rather than the formal note, but we'll do our best.
Okay. Thank you. Anything else on noise from anyone? If not, then we'll move on to lighting. And so I'm aware that we still have. So this is we're on to condition 12 now. So lighting, there are still 3 separate conditions. I think I understand the reasoning for that, certainly in relation to the bat mitigation. I can see the logic of wanting to keep that separate. I think condition 12 obviously deals with sort of impact on residential properties, and I think the third condition on lighting deals with the impact on the A1, I think it is.
That's
okay.
We took
advice.
So yeah, just on that, sir, we took advice from our lighting consultant, who was very keen, because the receptors are different, that it was dealt with in 3 separate conditions, which I think the council has now accepted.
We're
Trevor.
content with that.
Yep.
Okay, fine. Okay, so we'll proceed on that basis then. And then I think in terms of condition 12, I think the wording is reverted back to the original. I think my only suggestion would be, rather than saying the applicant shall submit, I think that's not quite correct, and also it's not consistent with the other wording. I think it could simply say prior to installation of external lighting, details relating to the external lighting scheme, including vertical lux diagrams, etc., in the brackets, shall be submitted to and approved in writing by the local authority. And then I think so. We just effectively eliminate the reference to the applicant, and then just correct the grammar accordingly. And
Yes,
then I
we're
think
happy
we
with
just
that.
need an extra sentence. Thank you. And then just an extra sentence that says the development shall be carried out in accordance with the approved scheme, and also meet the requirements of the guidance notes.
Yes, agreed.
Okay, Mr. Talkin, are you happy with that?
I'm content. Yes, thank you.
Okay, thank you. Okay, if there's nothing else on lighting, we'll move on. So the condition that followed it originally in the schedule has been, which was surface water drainage condition 1 and 3, that's been deleted. I think we obviously don't need to dwell on that one. Then the next condition, which is now condition 13, this covers the sort of survey and verification stage of the process. Is that correct, Mr. Faulkner?
Correct. Yes.
Yeah, and hence why it's kept separately from other conditions. Okay, so this is so deals with completion work, deals with anything to be done. I think is reference to condition 14 and this condition the next. Is that referring to the next condition or not, Mr. Faulkner? Do you know? I mean, numerically it seems to, but I don't know whether if that's
Yeah,
what
just
condition
checking
14.
myself now.
Given the number of conditions that we have, particularly as condition 14 is to do with the construction phase only. So I'm wondering whether that condition 14 is intended to probably be something else, and therefore maybe we just need to check whether that it needs to refer to a specific condition or not. But maybe if we just make a note to check that.
We'll check on that, sir, because you're right. 14 is more construction.
Yes.
Condition.
I'm conscious with the number of conditions changing, and the fact that this wording hasn't changed, that it may just be a happy coincidence that the next condition is to do with drainage or.
Although I'd say within that it does say survey and report shall demonstrate surface water drainage system has been constructed in accordance with condition 14. So it is talking about the construction phase, isn't it?
Yes, true. Although I think condition 14 is more about the temporary measures for construction rather than the actual.
Right. Yes.
So this may refer perhaps to the earlier condition number 7 or 8, 8 or 9, probably 8 or 9, to do with surface water stuff. I think maybe we need to clarify that perhaps with reference to the drainage consultant or just common sense reading of the conditions.
Okay.
So we'll make a note that we'll check that as well. Anything else on that condition? If not, then condition 14 is the surface water drainage matters at the construction phase, and I think we've all agreed already that should be pre-commencement, given that it's required at that stage. Mr. Taylor, do you have anything else to say?
No, so I was just going to make that point, but if it's pre-commencement, then I think that's sensible.
Okay, thank you. And then we move on then to condition 15. This is to do with the maintenance and management of the sustainable drainage scheme. Again, this is a separate phase of the whole drainage process, as it were. So this requires details of management and maintenance to be approved before any occupation takes place of the development. So I think that's all logical as far as I read it, unless anyone has anything to say on that. Then condition 17, as was, there was a separate LEMP condition on biodiversity that's been deleted because of the overlap with the earlier condition. So we are now up to new condition 16, construction environmental management plan on biodiversity. The only thing that's changed there is the removal of the wording about investigatory hard service removal. So this becomes a pre-commencement condition. There's no doubt that it's a pre-commencement condition now, Mr. Goldsmith. So I think there's no objection to that from the appellant.
No, that's not, sir. No.
Thank you. Anything else to say on condition 16 from anyone? If not, then moving on to new condition 17, which is the external lighting strategy for bats. And this is consistent with the earlier condition 12, and sets out the trigger points and the need to carry it out in accordance with the plan. So I think that is all okay. I don't know if there's anything anyone wants to add. Mr. Taylor?
It's the tiniest point, sir, but the first word is it's got a typo.
Oh yes, prior, yes. Not been picked up by the spell check. I'm sure prior is a word. There we go. Maybe it's something to do with the track changes. Okay, yes, that's fine. We'll note that. Anything else from anyone on that condition? If not, we'll move on to condition. Well, the following condition that comes after it has been. Oh, this was the one that was, I think, previously referred to as condition 20.
Yeah.
And the problems that condition presented with reference to a specific scheme or specific land, and also trigger points. So we now have condition 18 has been redrafted, and I note now that it doesn't refer to the Rothman Park estate. It just refers to the provision of a minimum amount of units. Mr. Goldsmith, is that?
That's correct.
Attention, yeah. And then I think it has now point H. I think that was in the condition previously, but it's now clear that it's part of the plan about the legal and funding mechanisms. So that's presumably, we'll come on to that a little bit in the obligation session, but that's setting out the plan needs to set out how it's all going to be implemented and secured. Mr. Goldsmith, is that correct?
That's correct. Yeah.
Okay. Anything else to add, Mr. Taylor? I think you had your hand up first. Do you have anything else to say?
Yes, just one small point. I'm confused about the brackets in the first line of event which will take place, brackets including groundworks and vegetation clearance. It seems to be superfluous, the brackets.
In terms of, because we're not on site here, or
exactly.
Yes, although the trigger has to be tied to the site in terms of plan being produced at a certain stage. Obviously, this. I suppose the other point is also that if this is a biodiversity net gain management plan, do we want to be having groundworks and vegetation clearance before a plan is?
Yeah, I think that's the point, sir. Yeah.
But is the wording in? Sorry, Mr. Taylor.
No, it's just, maybe it's me misunderstanding it, but no development would include groundworks. So I'm not sure why we've got including groundworks.
That's the superfluous point. Sorry, I'm misreading the brackets. Yes, it is a pre-commencement condition, isn't it? Effectively, yeah, because saying, no doubt, and that doesn't seem to be controversial as far as Mr. Goldsmith is concerned, I assume.
No, it's not, sir.
Mr. Tucker, you did have your hand raised. Did you have a point here?
Yes, sir. I think it's for some reason it's lowered again. Yeah, on the groundworks point, I think it is sensible to include groundworks still, because you wouldn't want de minimis groundworks or an argument about limited extent of groundworks. You essentially want the site in its pristine form before the biodiversity net gain management plan is in place. So I can see that there is sense in relation to that. And in relation to vegetation clearance, that's not development of itself, but nonetheless, it's sensible to have it in there to make it clear to future, that those who look at the condition in future, to ensure that it is ensuring that there isn't a degradation of the site before the management plan is agreed and implemented. And then, so you did make an observation, which is what prompted my my hand to be raised, about we'll turn to the unilateral undertaking in due course. It's right to say, sir, that the UU is certainly our first stab in terms of how you would discharge Part H of this condition, but Part H requires a further approval from the authority. So, for example, it covers anything which might be an eventuality which we think may not be covered by the UU. And I'm not saying there isn't one, but there may be one in due course that arises that could be covered by Part H, and it can also include reviews, given that the UU has, if you will, a cascade approach that's taken. So we certainly see this condition as being the primary means by which the off-site biodiversity net gain is achieved. Really, in response to your note that we had circulated in relation to the UU earlier on, sir. So, sir, if there are any perceived deficiencies in the UU, which we don't think there are, but if there are, and if a different way of achieving this, once we are underway in terms of securing the surrogate site, could be achieved, then this is the condition to ensure that it takes place in a manner which doesn't leave there being a deficit in terms of BNG, which is obviously weighed in the balance by all parties. So that's why we've added H into this condition, to make sure that this is, if you will, the primary means of control before the local planning authority in enforcing BNG.
And that was the enforceability in drug point that you were referring to last week.
Exactly that, sir. And that's why we certainly the condition in its original form didn't have that in, and that's why we've tweaked it, notwithstanding the previous agreement.
Okay, thank you, Mr. Tucker.
Thank you, sir.
Taylor?
Yeah, so just coming back to the point about including groundworks in the de minimis point, Mr. Tucker and I could have a lot of fun discussing what de minimis and implementation is, but it's just how those three words may be contrasted with other expressions in the conditions which talks about no development taking place, but doesn't include those words, and I don't want it to be a disconnect between how it's defined here and how it's defined elsewhere. I understand the reason for it. It makes a lot of sense. De minimis should not be, but de minimis works would not actually be development, arguably.
Right.
So, yeah, it's a problem for you, sir.
Thanks.
Yes. If I can be blunt, sir, it's sending a message to both the developer and also the authority that what's expected by this specific condition is leave the site alone until you've got your agreement. Now, it's hard to shoehorn that into the Secretary of State's tests of what's appropriate for a condition, but in terms of good practice, I think it is sensible. But happy to leave it to you as to whether you delete the words in the parenthesis. I mean, for example, you could say vegetation clearance takes place before commencement anyway, because it's not development, and that causes the problem, and that you've then got to revert back to the surveys to see the extent of habitats units which need to be replaced, which is why we've specified them. But I think on the good sense points, the words in parentheses are sensible, but Mr. Taylor does have a point about consistency throughout the document, so happy to leave it to you, sir.
Okay, thank you, Mr. Faulkner. Also, Mr. Morris, you had your hand up first, but did you want?
Yes, if it does help, and whilst I'm contradicting Mr. Taylor, the reality was that there was some ground clearance for surveying and other matters before, which would have affected the biodiversity. One of the features of this site is the very long established grasslands and hedgerows, etc. So actually, I think sort of on the thing of how long is a piece of string, the sort of for absence of doubt, don't do anything until this is sorted out, might gel with local experience, which did cause some issues. Just the fact that there was complete, when you saw the site, you saw that it wasn't the quality of permanent grassland as compared to the site north.
Okay, thank you, Mr. Morris. Mr. Faulkner.
Yes, just from the council's point of view, just wanted to clarify, we would want that wording in condition 18. I think probably what Mr. Taylor was saying, there's other conditions that have been put forward that don't include that wording. But my take would be the fact you have condition 18 that clearly has it in it. It would just be a breach of that particular condition in any regard. So you could add it to all the other conditions, but you would be breaching condition 18 in any regard if that wording is included there, because there's obviously other conditions. There's no pre-commencement development as well.
Okay.
So I'm assuming, Mr. Taylor, that's what you were saying. It should be, if you should really have it in all those other conditions as well. But I guess the point is condition 18 would be breached with that wording being in there anyway.
Yeah, so sorry, my point actually was I think the reverse, that it shouldn't be in any of the conditions, but equally it's very important that it is here because it needs, for the reasons Mr. Tucker has said. So I think it's a wording point. I think everyone understands nothing should be done to the site at all whatsoever. It's just a wording point.
Okay. Thank you. Well, I'll take that away and give that some thought. Thank you, everyone. So moving on then to condition 19, this is clarifying that there is there to be no change of use under permitted development regulations. So it is for permission would be for film and television studios and nothing else, even if it fell within the same use class EG. It would not be able to change without an application for planning permission, as I understand it. So I have no comments on that wording unless anyone else wishes to raise anything. If not, then condition 20, this is the to do with external surfacing and carbon reductions. It has all the same wording. It removes the ability to make changes later on. Just that issue that sometimes crops up in conditions, that things can be changed sort of outside the conditions discharge process without it being properly assessed. So it's not to say it can't be changed, it's just that it would probably have to be a variation of condition approach rather than just a kind of email exchange or whatever. So any comments on condition 20? Nope. Okay, and then condition 21 is the training, employment, community use and outreach management strategy, requiring that to be submitted and approved before the development is brought into use. I didn't have any comments on this previously. Any comments from anyone else on this? No. If not, okay, that's fine. Condition where are we at now? 22. Yeah, 22 on the new access. This has now been amended only in respect of the revision number to make clear that we're dealing with revision F rather than revision D. I think that's hopefully fine with everybody. That nothing to add on that. And then condition 23 is to do with the obsolete access, and there's no change to the condition, but there's a note from the appellant explaining that the existing access will be used for construction and then closed once the site is operational and the new access is in place. So that helps to sort of clarify the reason for that condition. Does anyone have any comments on that? So are we happy to move on? Okay, we'll move on. Condition 24 is the off-site highway works for the Elstree Way cycle scheme. There's revisions have now been added to just clarify which plans we're looking at. Those are all in the evidence before me, so hopefully that helps clarify matters and nothing else to add. Then condition 25 on the travel plan. So we have an obligation regarding the travel plan, but also a condition as well. And I think it would just be helpful to understand, Mr. Faulkner, you say you would prefer this to stay in as a condition, and presumably as well as the obligation as well? Is that the council's approach?
That would be our preference, yes.
And what's the reason for that?
I think it just gives us more comfort that we actually get to live. I appreciate the Section 106 does do that as well. If the inspector believes there isn't a requirement for it to be covered by both, and you think that's overkill on the part of the local planning authority, I guess we would be content. It could be dealt with just through the Section 106.
So, sorry.
Okay. Yes, Mr. Goldsmith.
Yeah, I was going to say that we have raised this with the council before, and we think there is a duplication between the obligation and the condition, because often within the obligation, it's more to do with any financial monitoring contribution that goes in there, but there is a duplication. We think it would be better if it was dealt with predominantly by the condition.
So you said the 106 would normally, in your experience, be to deal with the sort of financial aspects of monitoring and so on.
Yes.
And so your preference would be for a condition?
Our preference would be a condition.
Okay. Mr. Taylor, anything to add?
Yes, so the Water Department doesn't really have a view on this, but if it helps you, just looking at the obligation is given to the county council, whereas the condition would be with the council, and maybe that's the reason for the distinction. Add anything to the debate, Mr. Goldsmith, or Mr. Tucker? You have your hand up as well.
I'm not sure it does, because you have to work on the assumption that public authorities will act responsibly in the discharge of obligations and conditions. And one might argue actually the county council is better placed to consider issues of transportation. However, the Secretary of State also tells us in the conditions section of PPG that if something can be dealt with by condition, that it should be dealt with by way of condition. And you, sir, obviously have the blue pencil clause at clause 3.3, I think it is, of the obligation, which would allow you to strike out those elements of the travel plan if they're unnecessary. Equally, I'm not asking you to do that, sir. You can have it in as belt and braces if that will make Mr. Falconer happy, which I think is essentially the point that's being raised. So not pushing back at all, but so there is a preference by both us and the Secretary of State that it should be in a condition.
And the blue pencil clause, you say, could strike out superfluous or duplication rather than the entire obligation.
Oh yeah, absolutely. You'd still want the monitoring fees, etc., in there.
Yes.
Yeah. Okay. Mr. Falconer, anything you want to say in response to the various comments?
No, I'm content with that approach, as long as it's fully covered. If it's dealt with by condition and it's struck out in the Section 106, as long as it's covered. But either way, so yes, content for it to be a condition, and to look at the Section 106 is necessary to strike out the reference there as well.
Okay. Any duplication at least? Yeah. Not yeah. In the obligation.
Yeah.
Okay. Thank you. Anything else to say on the travel plan condition? If not, we'll move on to condition 26, which is car park management plan. This now has some additional text to say that it should be adhered to for the lifetime of the development. So previously it was just required the plan to be approved and nothing else. So this now ensures it's implemented. So that seems reasonable. Anything else to say on that?
No.
Not. We'll move on to 27 on cycle parking. This has the final wording removed, again consistent with other conditions, to prevent cycle parking being kind of amended without sort of due process being followed through the planning system. So that seems reasonable as well, unless there's anything anyone wants to add. Okay, then condition 28 on the A1A5135 combined junction mitigation. So this, I think I previously queried the plan reference here, and obviously I think the previous plan reference was that the general arrangement plan, which showed the whole junction and the gave reference to the other smaller, more detailed plans. So now we have reference to the Newark Green roundabout junction and the Rowley Lane junction. I raised yesterday I thought to do this in advance of the session, given it would require people to scurry around looking at plans and so on. Raised yesterday the plan provision number, and I've seen this morning that the parties have come back and agreed that it should be PO3 for the Newark Green roundabout and PO4 for the Rowley Lane junction. So that makes sense because those are the most up-to-date plans, and those are the ones that were assessed as part of the road safety audit. So that seemed logical. So unless anyone thinks we're missing a plan or the wrong revision number, I'm happy to carry on that basis.
We're happy with that, sir.
Okay.
Yes, council as well.
Okay, thank you. And then condition 29 deals with the southbound off-slip from the A1 separately. The reference number there is correct as far as I can tell from looking at all the evidence. This, unlike the previous condition, this one allows sort of it needs to be in accordance with the drawing, or such other scheme of works or variations substantially to the same effect that is agreed by the local planning authority in consultation with National Highways. Any reason why there is this kind of variation clause in this condition but not the previous condition? Is that a National Highways matter, or
So if it was just those were wordings from National Highways in terms of their consultation response?
Yes, regarding the variation, but I mean, did they suggest the previous condition as well? Or just
they would have done, so I can't say why. It hasn't been taken out.
It's been taken out of the previous condition in terms of the variation clause, but it's still in the condition 29 on the slip road. And I suppose it's just a question of,
because from the council's perspective, we're content for it to stay in with the variation. We would think that was the benefit of the applicant in terms of allowing for that flexibility, but they're suggesting they prefer that word to be taken out.
Okay, I'll ask Mr. Goldsmith any views on that.
No, so we did notice it was recommended by National Highways for that condition. I don't think we're happy with the condition as it's drafted.
And would you want both conditions to be the same? Would you think both conditions should be the same then? The previous condition.
I think the point about the previous condition is that they are happy because the plans and the proposals are agreed through the road safety audit. I think they're happy with those. So I'm not sure if you need in the previous condition the alternative.
Oh, so the slip road hasn't been subject to an RSA at this stage.
No, I think it has, but I think that I think they just wanted that as a belt and braces point from the National Highways point of view.
In terms of the slip road.
Yeah.
But Mr. Feldman, did you have something else?
No, sorry.
Okay, so there is a reason for the difference then between the two. It would seem. Okay, so anything else to say about that or the previous condition? Okay, well, thank you. I'll bear those comments in mind then. Condition 30 is the construction traffic management plan. Makes reference to the plan that's in the evidence before us. I think there's probably just some tweaking needed to. I can see why this is obviously pre-commencement, and the previous wording was above ground development, but obviously we're dealing with construction, it would make sense for it to be pre-commencement. I think it may just be needed slight tweaking to say, at the moment it's slightly clunkily worded. So it said no development shall take place before an updated CTMP with the reference in brackets, reflecting SRN requirements, has been submitted to and approved in writing by the local planning authority in consultation with National Highways, where the detail is relevant to the SRN even, and then go on and list all the things that it requires. I think it's just it's a kind of reordering of that first sentence, just because it's quite long-winded. Anything to say, Mr. Faulkner, on that?
No, happy and content with that revision.
And obviously, I just wanted to ask why this is only relevant for the strategic road network. Would this cover anything? Because obviously the reasoning is given is for the A1 trunk road, but I don't believe there's a separate condition or requirement for sort of local roads under the county council's control, Mr. Faulkner.
It's not something that was requested by the county council, hence the reason we haven't actually imposed or sought to impose that or recommend it.
Okay. I mean, essentially, it's the local planning authority could choose to consult with the county council on this
That's
condition
correct.
if it
Yes.
wanted to. It only specifies national highways, but yeah, it doesn't rule out. So yes, it could, and obviously the roads are going to be used, and so if the local roads are going to get used, so if the county council wasn't content, it would have the opportunity to say so. Okay, Mr. Morris, you have your hand raised. Is this the point you wanted to come in on the sort of traffic matters? If you want to say something now, then Mr. Morris, please do.
Yes, it would have probably been helpful on this very point if you'd seen the message I'd sent, because this is exactly the point it covers and more. So I wonder if we could defer this until you've had time to see that.
Can do. I mean, we could, once we've got through the remaining conditions, we can have an adjournment and I can try and chase up the missing condition. Perhaps if it can be resent to Mr. Legg, just so it's at the top of his inbox rather than.
Yeah, I'll send it with a map as well, because having seen the information now supplied by the appellant, I think a map would just be helpful for the discussion. So I'll send that straight through if that's okay by you.
Happy for that to be sent through, and obviously for us to have a discussion about that, and obviously time to reflect on it if we need it. Thank you. So we'll maybe come back to condition 30 then, unless there's anyone else wants to raise at this point. Then moving, if not, we'll move on then to what was drainage condition that has now been deleted, merged. This was to do with the drainage relating to the strategic road network. That's now been merged with condition 8. Then condition 31 on lighting deals with lighting effects on the strategic road network. I don't have any comments on the wording unless anyone else does. Mr. Taylor.
Yes, so just a small point. The third line, but where this could impact the A1, this would be national highways, just seems to be slightly unclear. And I'm also just wondering if it's necessary, because in consultation with the relevant highway authorities would cover national highways in any event. And it looks like if it's to the A1, it's to the exclusion of everyone else that it will be national highways. It just seems a bit clunky, sir. Just not sure that wording is necessary.
Okay. Thank you for that, Mr. Taylor. Any thoughts, Mr. Faulkner?
I kind of tend to agree, because it does say relevant highway authorities. A relevant highway authority would be national highways in any respect. I suppose it's a little bit more clarification, but I think it is covered by that anyway.
Okay, thank you. Mr. Goldsmith, any comments?
No, we're happy with that, sir.
Okay, fine. Well, I'll certainly bear that point in mind. Thank you, Mr. Taylor. If there's nothing else on condition 31, then condition 32 on geotechnical assets removes the investigatory hard surface removal point, and so makes it clear that we're dealing with pre-commencement condition, and given that this deals with geotechnical matters, I can see why this is being requested as pre-commencement. Interestingly, this does also include the groundworks and vegetation clearance clarification in brackets afterwards. So I don't know, Mr. Taylor, you have a similar point here, or in terms of consistency.
There is a similar point. There's also a separate point, which
okay.
just very briefly, it's the reference to the CD 622, and whether or not they should be or any updated document replacing that.
It could be. I mean, any comments on that, Mr. Faulkner, Mr. Goldsmith?
I'm content with that additional word, and that often happens with permitted development rights. You add that additional wording.
Mr. Goldsmith?
Yes, no objection.
Okay. And then your previous point, Mr. Taylor, about the wording in brackets, it's the same here.
It's the same point, so it remains something for you to think about.
Okay, fine.
Thank you.
We'll yeah, add that to my list. Thank you. Then condition 33 on site waste construction management plan. Didn't have any comments previously, I don't think. It's something that, again, it's this pre-commencement, and here there is reason given for that, and there doesn't seem to be any disagreement on it being pre-commencement. So I don't have anything more to say on this, unless anyone has anything they want to raise.
No, sir.
Okay.
No,
Thank you.
yes, sir.
And then condition 34, the final condition, maximum height of structures on the back lot. So this, I assume this is on the basis that the structures on back lot won't be permanent features, Mr. Goldsmith. Is that?
That's correct. Yes.
The permission will be for a back lot, which will be this large area of space, like similar to what we saw on site, and then structures will come and go.
Yes.
Over time, and the clarity here is that nothing should be more than 15 metres if it is going to be erected.
That's correct.
Okay, Mr. Taylor.
Just a small point here. So I'm wondering if it'd be helpful to add the words at the end above ground level, just so that there isn't a 10-metre structure and then a 10-metre structure on top of that, and each structure being treated separately as being not above 15 metres.
Any comments on that, Mr. Goldsmith or Mr. Faulkner?
No, if that helps clarify matters, I'm happy for that additional wording.
I think above ground level from our point of view is fine.
Okay. Fine, thank you. I think that's the last condition then. Are there any other conditions, any other necessary conditions that we haven't already seen apart from Mr. Morris's, which we will come back to? If not, then what we'll probably do then is we will take an adjournment now in order to have a look at the condition that's been circulated by Mr. Morris, and I will also look at the note from the solicitors on the changes to the 106. So we'll maybe take a sort of 20-minute break to allow that to be done. Is that enough time for everybody to do that? Okay. So thank you. So I'll chase up the email now, and maybe if we come back at 20 past 11 to conclude on conditions and go straight into the 106. Okay. Thank you. There's nothing else from anyone else. We'll adjourn for now and resume at 11:20. Thank you.
Thank you, sir.
Thank you, sir.
Hello everyone, it's 11:20 and the inquiry is resumed. Firstly, can I check, has everyone been able to see Mr. Morris's email and the map that's now attached to that as well? All relevant parties, Mr. Goldsmith, Mr. Faulkner, Mr. Taylor in particular, but everybody else as well who needs to be involved.
Yes, sir.
Thank you. So, Mr. Morris, so I've received that now. Thank you. And so, as I understand it, you're looking for some additional wording. Well, actually, a separate condition now. I think previously you've used wording that was suggested before by the council, before the committee, and then you kind of tweaked it, in particular the second bullet point. Do you just want to explain the rationale behind it?
Yes, thanks very much.
Thank you.
So there was at the time of the planning determination process, there was this additional condition on construction proposed. So I think the first point of saying if it was seen as necessary then, why not now? But actually, I think moving on from that, the construction traffic will be less than the operation traffic. We've also got the situation where we're now in the world of paragraph 155, which talks about sustainability, and transport is a crucial element of that, and also the difference between rural and other roads. And I, having had the chance now to look at the further explanation which I supplied on traffic, which I recognise sort of draws together what was already presented, I think the map is probably then the most helpful to look at, which is that north of the site is an area of restricted rural and residential roads. Most of them, except probably Studio Way, are bounded by existing restrictions on over 7.5 tonnes to reflect the constraints of the roads that are in them. There's one unsuitable for heavy goods vehicle, but it's exactly the same. And so we have a network of roads around here that are very unsuitable for extra traffic. And then finally, that it's not just about Shenley, it's about traffic coming down Watling Street, which is the straight road just off the centre to the left, coming down the A1, cutting through the single track Rowley Lane, which goes past Strangeways Farm, for example, cutting through roads in Ridge and South Mims. These are all diversion routes from a Rowley Lane A1 junction, which is near capacity, and that's, I'm not saying this in a negative way. You know, I think the Highways Authority realised that there was a lot of work to do to it, and there's still potential for congestion. So really, what I'm suggesting to you in the context of your comments about local highway impacts, this is a very unsuitable route for cut-throughs. It's already recognised there are limitations on the roads in terms of size, residential restrictions. And before, the applicant seemed quite happy to put in some control measures which seemed quite reasonable, proportionate, and able to be delivered. So I'm simply requesting that is done, but extended to operation as well. And these routes, not just the narrow route. In one sense, I'd be more worried about the single track Rowley Lane that you've all walked down. So that's really the condition I'd like you to consider, if you would, sir. Okay, thank you, Mr. Morris, for setting that out. Any comments from the parties on that? I mean, Mr. Faulkner, from the council's point of view, there was obviously some of this wording did appear in that update note to committee before the committee was held, and I assume that the intention would have been that wording would have been added to condition 32 as it's described, I think, in that note.
I agree. Yes, it's always a difficulty where you have update sheets before committee, obviously the conditions that have been pulled through were the ones on the agenda itself in terms of the officer reports. This was in the update sheet. But I think that's probably an omission on my part, that these additional 3 bullet points would be our recommendation. They are added to that particular condition. Obviously, going beyond that in terms of what's being suggested by Mr. Morris, that's really at the inspector's discretion, and for yourself to actually decide if that's appropriate in this particular case. That
any view from the council on that?
Ultimately, the county highways haven't suggested that that's required. There's a commitment on the part of the applicant to provide these 3 additional points in terms of the control of the construction traffic on the site. What's obviously now being alluded to goes beyond that in terms of both the construction and the operational stages. In terms of mitigation, yes, that would be an improvement and provides more certainty. I think that's really a case of whether the appellant is content to agree to that additional wording or those commitments.
Okay. And in terms of the second bullet point, and obviously the update sheet referred to London Road through Shenley. Mr. Morris has referred to other sort of routes and connections. If it was just the construction condition that we're dealing with, rather than operation for the moment, any comments on those additional kind of reference points that are being included in bullet 2?
From the council's point of view, yes, I think we would agree to those additional provisions. Again, really, I think we need to hear from the appellant side whether they're content with that as well, or if there's any operational or construction issues with that.
Okay, thank you, Mr. Faulkner. So, Mr. Goldsmith, your views on behalf of the appellant, please. You're on mute, Mr. Goldsmith.
Yes, Mr. Morris is correct. This was discussed in advance of committee, but it was, with my recollection, only relates to construction traffic, is the first point. So I think some of these issues can be dealt with through the condition dealing with the construction traffic management plan.
Okay, so those bullet points that were in the update report could be added to condition 30 as it is now, without the appellant having any concerns. Is that a fair summary of that first point?
Yeah, I think so. I mean, obviously, there is an issue about how some of this is actually enforced. I mean, you can obviously have an agreement with contractors that they use certain routes, but whether they actually choose to use those routes or not is perhaps more difficult. So I think the detail would need to be in the construction management plan how this will be dealt with. So I think it's something that there are some of these can be added in, but I would have a concern that obviously not all of this is at the can actually be enforced by Sky or L&G is my concern.
Okay, and then in terms of it dealing with operational matters, obviously condition 32 as was and 30 as it is now deals with construction traffic. What's your view on dealing with operational traffic condition?
My understanding of these issues have never come out from discussions from an operational sense in terms of from the county council, Hertsmere or National Highway. So, and I don't think that was ever a the commitment. I think was also only related to construction traffic.
Okay. And from the appellant's point of view, do you think a condition is necessary for operational traffic?
No, well, not from my understanding of the position. No, it wasn't something that was required by any of the relevant highway authorities.
Okay. And in terms of those extra locations noted in the bullet point 2, obviously because the update report refers to London Road only, in terms of some of those other points and connections, any comment on that from a construction point of view, or obviously not necessarily operational. I've heard your point on the operation.
Sorry, say again, sir.
So sorry, that was. I'll say it again. So any. I asked Mr. Faulkner the same question about bullet point 2, because in the update report to committee it just refers to London Road through Shenley, whereas in Mr. Morris's suggested changes he refers to not just that route but some other connections to M25, A1, etc. Obviously he's saying for both construction and operation, but any comments on referring to those extra routes for construction?
Yeah, I think if it's in the construction traffic management plan, rather than be definitive at this stage, I would have thought it's something that needs to be agreed as part of the plan. It's difficult to say whether or not all those connections need to be dealt with as part of the construction management plan. So I think it'd be better if they were agreed as part of the plan rather than explicit in the condition.
Okay. I mean, the update sheet just referred. It says it talks about monitoring traffic on the London Road through Shenley as a kind of that is required. You're saying that you're not sure whether other connections would be also definitely required to be addressed or not.
Yes, and I would have thought the right forum to do that is through the construction traffic management plan.
I suppose you could have a sort of caveat that says another route as necessary or something.
Yes, you could do. Yes.
Okay. Thank you, Mr. Cole. So, anything from the Rule 6 party, Mr. Taylor, on this?
Well, so it's a point being taken by Mr. Morris rather than Rule 6 party, but in answer to the point made by Mr. Goldsmith, I understand his point about enforceability, but lorry routing plans, for example, are often used. There's a way for a local authority to check whether or not a contract between Sky and its supplier includes the lorry routing plan. So I think there's a way in which it can be enforceable. And there's a general point as well about if it's necessary for construction, that the Rule 6 party does have some sympathy with the need to extend it to operational use as well. This is going to be a 24/7 intensive use, which will last for the lifetime of the development if granted. And although it is said that the Highway Authority didn't ask for it, there's also nothing for the inquiry that says they considered it and decided it wasn't necessary. And I think just the fact that they didn't put it forward doesn't mean they've actually applied their minds to it in the same way that Mr. Morris has.
Thank you. Mr. Morris, do you have anything else to say in response to what you've heard from the parties?
I think what I would say is Mr. Taylor's probably being polite. I used in my interested parties submission right at the beginning the word dereliction from I don't think the highways authorities have considered this. What I would say about the issue of all routes is that they all do apply for traffic because any of those can be used. They are all covered by weight restrictions. So actually the construction management plan would then, restrictions would then apply to vans and cars. And we're told in the planning statement that there will be the order of 500 to 600 people involved in construction, but many more in employment. So I'm struggling to see why the operational bit can't be included. And then I also reiterate in terms of rat running, you know, this is from, and I think I actually said it in my speech, north, east and west. The bit in the highways plan is predominantly around the junction with the A1, and the area considered in the traffic planning was very clearly circumscribed around the site and didn't go northwards. So one of the real questions I probably ask you to consider is why not? Why not put this in where the applicant has said that traffic will come through either a travel plan involving public transport or the A1? And the final point I made is I think there is new ground because of 155 and then referring back to paragraph 110, which is that it illustrates the importance that issues around transport have for consideration of sustainability. And whilst it's a very general paragraph, there's a very explicit bit in paragraph 110 which recognise solutions will vary between urban and rural areas, and that's one of the things about this. We move very swiftly from an urban area into a northern rural area, and issues like the lanes north of there, several of them are single track, and as well as the residential components. So I'm really asking why it was there already. Why not? Why doesn't it still apply? And why doesn't it apply to operation as well? And I'm not suggesting that an answer now. That's what I would be respectfully putting forward.
Okay, thank you, Mr. Morris. Mr. Goldsmith, you have your hand raised.
Yes. Thank you, sir. It's an important point on enforceability. But going back to what Mr. Morris has said, just to reiterate that this has never been required by either the council or any relevant highway authority. But the other point that is very important, I think, in terms of enforceability in the context of the operation of the site is how you'd ever distinguish between the existing studios, which has got no restriction, and Sky North. You wouldn't be able to enforce it. I just don't see how this condition is justified when it hasn't been required by any of the relevant highway authorities, and it is impossible to enforce it given what's on the site to the south.
This is referring to the operation stage.
The operation, yeah. The construction point we have accepted before, and I think details can be contained within construction traffic management plan. But it's not required, and no one has asked for it from a. I understand Mr. Morris's point, but from a highway or the authority viewpoint or the council, and it's impossible. It would be impossible to enforce.
Okay.
Sir, could I just make just a couple of points? Part of the genesis of this was actually, which you may well heard of, the Segro rail freight terminal, which is just north of this site, and they put in, and it's been accepted by the neighbouring planning authority, this approach to enforcement through contractual. And then what happened was that, seeing that seemed to be an accepted practice by Hertfordshire County Council, local residents suggested this with various meetings with Sky. We were disappointed then that it applied only to construction at the last minute, given the fact that, as I say, large vehicles shouldn't be travelling there anyway. And if carefully placed, I think the issue of enforcement, which I think the precedent has been accepted by Hertfordshire, is that it can act as a deterrent. I don't think anybody is suggesting every car would have to tick a box, but with modern automation, it could considerably reduce the impact. And whilst this, I don't think is a planning consideration, help meet Sky's community objectives in terms of local impact or lack of negative impact. So I think it's quite a broad consideration for you to take into account these various factors, which I hope we've all explained, the plus and the minuses.
Thank you, Mr. Morris. Mr. Goldsmith again.
Yeah, sorry, I don't want to labour the point, sir, but this issue about where vehicles travel from was dealt with in the transport assessment submitted by PELS as part of the planning application, and the increase in traffic along those routes, and no one from a highway authority point of view has considered that any such condition is necessary.
Okay. So, sir, I don't want to prolong it too much, but I think the key point I'd make is the complete lack of confidence with local residents, as highlighted in my speech and the speech which we hope to give to the councillors about the usefulness of our local highways authority in reflecting conditions on the ground. I'm reluctant to say it, but perhaps to close off, our planning portfolio holder has described them as being in la-la land. In other words, there is not a lot of local confidence. So I just ask you to consider it in terms of the local representations, and finally that this is not just me, it was a key factor in the very large number of responses put in under the template approach.
Okay, thank you, Mr. Morris. Anything more to say on this condition? Obviously, I think I will give it some thought. Obviously, I will definitely do that. I suspect if I consider something is necessary, that it may make more sense to have a separate condition on operation and construction, just because we already have a construction management condition. And you'd have to think about the wording of an operational condition that included these bullet points, but obviously set out the kind of tops and tails it with the relevant kind of trigger points and so on. But that's something for me to take away and consider. Thank you for all the discussion on that. So is there anything else anyone wants to say on this point, Mr. Tucker?
Yes, so just on that last observation, so yes, it would be better to have, if you did think operational matters needs to be controlled, although you have a very firm view to the contrary. Obviously, you would also have to consider the extent to which operational use of the highway, particularly by smaller vehicles, is controlled by other legislation and the availability of other legislation. And picking up Mr. Morris's perspective, whilst it may not be the lived experience of residents of Hertfordshire, and I don't doubt that from what Mr. Morris has to say, you, sir, have to approach the matter on the assumption that the public authorities will do their job properly, because there are other means to secure that approach. So the first point, sir, is you have to consider whether there are other means of control, such as introduction of TROs, etc. And the second point, apart from forcibility, is the assumption that you, sir, are obliged to apply to other public bodies and whether they'll do their job properly.
Okay. Thank you. Okay, if we're happy to move on then, that was the final condition we had to discuss. So I think just by means of wrapping up on the conditions session, yes, as I said at the outset, it would be helpful to have a tidied up, clean version of the schedule with track changes removed, and that can be provided in Word. I think obviously there are hopefully most of what we discussed has been straightforward, but if there are any points of clarification needed, I'm happy to sort of do that by exchange of email after today. And obviously if the appellant wishes to confirm, thinks it's necessary to confirm any pre-commencement conditions, obviously that can be done as well through a separate email or note. Mr. Tucker.
Yes, so just asking about timescales. So when it comes to the 106, I will be asking, if possible, for your leeway to have a 2-week period beyond the close of the inquiry for the submission of the signed, sealed, delivered version of the obligation. So I wonder if the same timetable would be sensible in relation to the conditions, or whether you want a shorter timetable for conditions, given that we've gone through matters quite thoroughly.
I think looking where we are, yeah, I think certainly if I could oblige the parties to say by the end of next week, that would help, if that is possible. So by so effectively I have it for sort of the very start of the week commencing the 14th of
yes, sir.
April. So that gives you sort of 10 days, 10 working days ish. Not 10 working days, sorry, 10 calendar days almost, to go through that. So, but certainly, if it can be received by us by close of play on Friday, the 11th of April.
Thank you, sir.
And then, yes, I'll can look at it then on the 14th. And then, if there are any final queries, I should say because of the nature of Secretary of State cases, I will keep the inquiry open until we've finished with conditions of 106, and then obviously close in writing. That's my intention. So yeah, that does allow for a little bit more discussion if needed by email.
Thank you, sir.
Thank you. Anything else on conditions from anyone? If not, then we'll move on to looking at the planning obligations in the unilateral undertaking. So for that, am I presumably looking at the same individuals for discussion on that, or do we have anybody else joining us for discussion on obligations? Mr. Tucker, anybody else?
I think it's the same team from our side, sir.
Okay. Mr. Faulkner, are you dealing with it from the council?
I will be, sir.
Yeah. And Mr. Taylor for Rule 6?
Yes, sir.
Okay, thank you. Okay, so during the break, I went through the notes from the appellant solicitors setting out the changes between versions 14 and 15, and I went through the track changes documents as well. So that was helpful, because although I tried my best with my spot the difference exercise, there were a few things that I'd missed. So that was helpful to see it sort of set out clearly in track changes. So nothing significant, but thank you for providing those clarifications. By means of overarching points, we now have copies of the title plans and register office copy register. Thank you for that. So as I understand it, then there are two parcels of land. There's a parcel of land that ends with a reference number 836, and that's the westernmost field next to Rowley Lane. And then the other parcel of land in land registry terms, which ends 353, covers the remainder of the site, but includes Sky as the leaseholder on part of that land, the southernmost field. So that's how it works in terms of land ownership. I think, if I understand correctly, the westernmost field is sort of now its own separate land parcel, and the remainder of the land, which forms part of the current development, is now a separate land parcel. I think that's how I understand it. I don't think it can take us anywhere or makes a difference, but I think that's how I understand it. Mr. Tucker or anybody else in the call might be able to clarify.
Well, so that's certainly my understanding too, unless anybody tells me to the contrary. But I think you're right.
Okay, and the reason why Sky Studios is only the leaseholder on part of the site is presumably that because that's where the back lot is located, and therefore it's a sort of temporary lease that they have.
That's correct, sir. That's why they have a land interest.
I see. Otherwise, as soon as that lease expires, they wouldn't presumably have any land interest.
That's right, sir. Subject to any holdover rights or whatever. But yes, you're right.
Okay. Anything else from anyone on that? And then obviously the freehold owner is Reassure Limited, and obviously they're not one of the appellants, but just to understand their relationship to the appellant. So is there anything to note, Mr. Tucker, or anyone else?
My understanding is that they're a part of the same family of companies as the appellants, but I'll double check that behind the scenes and report back.
Okay.
I have to say that's the assumption I've been working upon, but I haven't confirmed that.
Okay.
No doubt the magic WhatsApp will tell me in a moment.
If there's anything to the contrary, yes. Okay. Yes, that's fine. I think again in the title register I can see reference to their position in relation to this land.
Yes, sir.
Thank you. And then obviously the Bentley Heath receptor site, which is shown at Plan 2 of the obligation of the unilateral, that's owned by the Rotham Park Estates.
Yes, sir.
Yeah, thank you. And I think obviously it's land that's they're not signatory to this agreement because it's a unilateral undertaking. We have the legal agreement process that we'll come to in a moment.
Yes, sir. That there are triggers which would result in there having to be an obligation if that becomes the surrogate site. But so they're not bound by the 106 in that respect. The appellants are, rather the landowners from whom title would derive are bound.
Okay.
And sir, Reassure are part of L&G, I'm told. Sir, I'm happy to say we have a mandate to speak on their behalf.
Okay. Thank you.
Which is reassuring.
At this late stage in the process.
Exactly.
Thank you. Okay, so to go through the obligations, the unilateral undertaking. So obviously ID4 is the version that we're working to. That's the draft 16, the 25th of March version. So I don't have any comments in terms of the definitions at the start and all the various clauses that follow. Going into the schedule itself, so Schedule 1. So we have the first part of that is biodiversity net gain, and I've had the notes which sets out how this will be secured. So I just wanted to double check with the council by Mr. Shaker or Mr. Faulkner whether whether you have any comments following that note and any kind of residual concerns. Mr. Shaker, perhaps.
Both waiting for each other to speak. So nothing from me. I think the BNG note clarifies and aligns with the view that I'd taken in terms of how the UU works. So nothing from me.
Okay, Mr. Faulkner, anything else?
No, in terms of the wording within this, it's been clearly looked through our legal team as well and through myself to that cascade mechanism and how it works. So we're content that we're satisfied with that and the triggers as well to actually reach those conclusions.
Okay, thank you. Anything from the Rule 6 party, Mr. Taylor?
Yes, so there's one point. Obviously, the purpose of this is to try and prioritise the Bentley Heath BNG receptor site above the others. So a suggestion would be that in well, it actually says 1.2, but it should be 1.1. So subject to paragraph. Oh no, it's not. So it's subject to paragraph 1.2. To use first line, to use all reasonable endeavours to secure the Bentley Heath BNG receptor site, and then again in 1.2. where despite having used all reasonable endeavours, and in the penultimate line before A of 1.2, again of 4 months use all reasonable endeavours. And the reason why that is desirable is clear, but also it's not something that the parties to the UU have an issue with anyway, because they are happy to commit to all reasonable endeavours at paragraph 2.9 of Schedule 1. So they don't have an in-principle objection to using all reasonable endeavours. So I think that should be added here.
Okay, I'll seek the views of the parties. Any comments from the appellant on that additional word being used?
I'm struggling to see how you would interpret that schedule when reading paragraph 2.9 of the schedule as all reasonable endeavours, as my clients being able to get away with only using some reasonable endeavours, to be blunt. So I'm not sure that the text is necessary. I do know there's an awful lot of litigation that's sitting out there in the contractual world about reasonable endeavours and how you should interpret matters. So I would certainly need to take instructions upon that. We think that the current text is fine, and we're happy with that, and the authority are happy with that. And I would just simply add that this isn't the only means by which the BNG will be secured, and so our strong emphasis is upon the condition and the discharge of that condition, which provides any reassurance in the event that my client, although quite why they would seek to do this, only use some reasonable endeavours rather than all reasonable endeavours, and then try to get away with that, which I suspect would be a brave thing to do. So yeah, not necessary. Obviously, I'll take instructions upon it. But on the basis that it's agreed and that we have been comfortable with that, and a fair reading of the schedule would suggest it's all reasonable endeavours anyway, as Mr. Taylor's rightly pointed out, I don't think it's necessary.
Okay. Any comments from the council first before I go back to Mr. Taylor?
So,
not from myself, sorry. Go on, Cheryl.
Thank you, sir. No, just saying, as Mr. Faulkner's indicated, this is obviously an agreed UU from our perspective, so we don't consider it necessary either. But I don't think we'd have any particularly strong objection to it. But it is an agreed position.
Okay, thank you, Mr. Taylor.
Yes, sir. I've heard what Mr. Tucker has said. I don't agree. 2.9 is just an example of the parties being prepared to give a greater obligation to use all reasonable endeavours. That was the point there. There is a world of difference, and we're planning lawyers, we're not contract lawyers, but there's a world of difference between reasonable endeavours, all reasonable endeavours, and best endeavours. All reasonable endeavours is a much more onerous obligation, and we would say is more appropriate given the importance of securing the primary site being the Bentley Heath BNG receptor site. I don't see why it is being resisted. If it hasn't been noted by the local authority, then that's one thing, but I haven't heard an answer as to why it's not better to have all reasonable endeavours than just reasonable endeavours. It suggests that, yeah.
Okay,
well, I made the point.
Thank you, Mr. Taylor. Mr. Tucker.
Yeah, I mean to be clear, sir, I said I think twice I'd take instructions upon it, so I'm not resisting it. This is the first time the point's been made. I've not had the chance to take instructions in relation to that point. My submission is that it's not necessary. The authority doesn't think it's necessary. I will take instructions upon it. I know there's a lot of jurisprudence in relation to that which falls outside of the ken of any good planning lawyer, and is the realm of a contractual lawyer. So obviously they would want to have a thought in respect of that. If we'd known about the point before, I could have taken instructions before, but I'm sure that we can take instructions upon it. And in the event that between now and the point at which it's submitted, my clients accede to that request, we'll obviously notify all the parties. But at the moment, I don't see how it is necessary or why it's necessary, particularly given all the points that we talked about in relation to condition 17, I think it is now. This is only one part of securing the BNG requirement.
Thank you. I think it's 18, but
18. I'm so sorry.
I appreciate which one you're referring to.
Yes, sir.
Thank you. Anything else on this point, Mr. Taylor?
So just one final point, and then I'm sure we'll all like to move on. The reason why I think it is necessary, although it's unilateral and it's not within anyone's gift other than the appellant to provide it, is because of the point we made earlier, which is that the landowner is not a party to this. So it puts an extra obligation on the parties to the UU to try and ensure that the third-party landowner does actually do its best to facilitate this, or at least that the parties have done their best to facilitate the third-party landowner entering into it. That's another reason why I think it's necessary.
Okay, thank you. Anything else to say on this? Obviously, Mr. Tucker, you'll, as you said, take instruction and then come back as necessary.
Yes, sir. I'll take instructions. It almost certainly won't be today that we'll be able to come back, but so when we ask for time, as we will do in a few moments in relation to this, to complete the document, so I'm taking it, you will be happy for it to be signed, sealed and delivered in this form, subject to, if it's thought appropriate, the addition of the word all, and if so, we'll notify all the parties that we're adding the word all before that. As I said, I can't see it's necessary because I can't see how anybody would remotely seek to get away with using some reasonable endeavours, but not all reasonable endeavours, and expect not to have enforcement. But I'll take instructions upon it, and so if we change it, we'll notify the parties.
Okay, obviously, it needs to be changed before it's signed. And
exactly. Yeah. Yes, of course.
Because obviously, I can't add words. I can only take words out.
No,
well, the Secretary of State in this case can only do that. Okay, thank you. So the only other points just to raise on this first obligation under Barda Sinet Gain. Obviously, it's in 1.2, it sets out the cascade as we've described it, and that is that over a period of 4 months to complete all of those steps rather than 4 months for each step? Is that how it should be read?
I think it's 4 months for each, sir.
Okay. So if not be able to secure within 4 months, then the owner shall for a further period of 4 months in the following order of priority. So yes, I suppose it's whether some thought might be given to clarifying that, because it could be you could demonstrate over 4 months that you've looked at all of them, and obviously
so,
4 months. Sorry, Mr. Tucker.
No, sorry, sir. That's just me jumping in.
Sorry, Mr. Shake. Sorry.
My understanding, having read it without I don't think this is clarified in the BNG clarification note, but my understanding, just reading and interpret it in plain language, was that 4 months was required or was permitted using and looking at all of the available options and going down the cascade mechanism rather than 4 months for each, because obviously otherwise that would add quite a significant amount of time on before you then get to the payment being made. So my understanding was it was number one, 4 months to look at the BNG receptor site at Bentley Heath, and then number two, a further 4 months if that couldn't be secured to look at an alternative site, and then a cascade approach would be taken, but it would be a totality of 4 months for that second consideration. If I'm wrong on that, perhaps clarity ought to be provided in the UU.
Okay. Mr. Tucker.
No, that's exactly my understanding. So for the first 4 months, then the second 4 months,
okay.
And then it's not a totality of 4 months, which I thought so was your question. Forgive me.
No, I wasn't sure whether it's 4 months for A, 4 months for B, 4 months for C. That it's 4 months for A to E. Is what the intention is.
Yes, 4 months for A, 4 months for yes. So yes.
Oh yes. So I suppose A, yes, A, because A is obviously an alternative site in Hertsmere. So it's so just to be clear for the whole thing, it's 4 months to secure the Bentley Heath site, and then another 4 months to try and secure something from A to E.
Yes, sir.
So
That's
8 months
exactly
in
right.
total. Yeah.
Yes,
okay.
sir.
And just the other sort of small point, maybe it's a pedantic one, I don't know, but the definition of southeast of England, obviously we have everything else quite clearly defined in terms of counties and the whole of England. Southeast of England, do we need to define that in a more coherent way? I mean, one person's southeast is another person's something else, I don't know, but are we using government area, government office, old school area, or that kind of thing? I don't know if it needs to be clarified or not.
Again, I'll take instructions in relation to that. I suspect it's probably obvious. If this was proposed in County Durham, I think we'd lose. If it's proposed in Bedfordshire, we'd probably win in relation to the argument. But so I'll happily take instructions upon whether that requires any specific definition.
Okay. And obviously we have the neighbouring counties, which are all, I think, arguably southeast or east.
Yeah.
It's yes, whether or not obviously I assume the intention there is somewhere like Surrey or Kent or that kind of thing is what's meant by that, but it's just clarity. Mr. Taylor?
Yes, I was just going to suggest actually that rather than having the southeast, you actually just define the counties other than those counties that are in the sea, which would be within the southeast.
Yeah, that's possible. One possible approach for that. I mean, obviously, the key thing here is to try and get it as close as possible to the site. So, yes, somewhere at the very bottom of Kent is potentially quite a long way away compared to somewhere that's in North Surrey. I don't know, but yeah, I think it'd be useful just to provide that clarity, because the key thing here is obviously to try and get it as close to the site as possible.
Yes, so as I said, I'll take instructions in relation to it. The easiest thing might just be a map.
Possibly, yes, or something in the definition schedule. Actually, I mean, to be honest, you could just set out Southeast England means X, and then there's no doubt then as to what it is.
Exactly, sir.
Yeah,
but I'll take instructions again. I can't imagine that's problematical behind the scenes.
Yeah. Okay, just for clarity, thank you.
Yeah.
Okay, nothing else on B&G from my perspective. Anything from anyone else on that schedule? If not, Schedule 1, Part 2 is the carbon offsetting. So there's been some various changes. That was the principal change between version 14 through to 16. So I've seen all that now. I don't have any specific comments on carbon offsetting obligations unless anybody else does. If not, we can move on to Part 3, which is the travel plan. I think we've covered this already. I think it's really for me to go and look at and consider any overlap and whether that's necessary or should be removed. So does anyone else have anything else to say on Part 3, the travel plan?
No, sir, thank you.
Nothing from anyone else. Okay, thank you. Then Part 4 is the film and TV heritage centre contribution. So as I understand it, this is being put forward as part of the package of benefits rather than as a mitigation. Is that a fair sort of way to characterise it, Mr. Faulkner?
So that's correct. Originally in the application, what was being offered by the applicant was a space within the actual studios itself. Following discussions, because the council had a motion to support the provision of a heritage centre within Boreham Wood, it was very much a view that should be within more the heart of Boreham Wood, which the applicant was content for it to actually be pulled into that kind of mitigation, or not mitigation, or that benefit in terms of scheme for Boreham Wood itself, which would obviously have a wider community benefit and support the wider town centre as well. So that was the reason for that.
So from your perspective, from the council's perspective, it's part of the.
It's a benefit, yes.
Yeah, to be weighed in. Yeah. I'll come to Mr. Taylor then. I'll see if the appellant has anything to say. Mr. Taylor, do you want to add?
Yes. So I think just a few points on this. The first point being that the Baltic Party doesn't think it's Reg 122 compliant. It's not necessary to make the development acceptable in planning terms. It's a benefit. It's not for mitigation. This is an aspiration by the council, but it doesn't have any policy support. Even after the contribution will be mostly unfunded anyway, with no other sites being identified or mentioned to the inquiry who will be contributing the balance. No contributions were sought from Sky for the existing studios for this. Basically, it's a generic wish. It's not a site-specific requirement. The Rule 6 party noted when Mr. Tucker said that Sky's position is neutral. I think that was the words Mr. Tucker used, as to its, and I think that he meant as to its lawfulness. The Rule 6 party is quite clear that it wouldn't be lawful as a planning obligation. Obviously, so following the decision in Derwent, it's still something that the appellants can offer, but it can't be so that you can have regard to it as a reason for granting planning permission. But it can still be offered, but that doesn't seem to be the basis on which it's being proposed. So in terms of the weight to be given to it, Rule 6 party maintains that no weight should be given to it because it is not a lawful planning obligation.
So were you referring to the Derwent judgment? Was that the reference?
Derwent, yes. Sorry, I could tell you the reference there if that would help.
Well, maybe. Well, we'll see what Mr. Tucker says in response, and we'll come back to that if needed. Mr. Tucker.
Yeah, I certainly don't accept it's not a lawful obligation. The question is whether or not it's a reason for the grant of permission and or a material consideration before you, sir. So on our case, as you heard from Mr. Goldsmith, our case is that we don't think it's necessary on the basis of the planning balance that's struck. It's not mitigation. It could only ever slot in terms of benefits. Where does it slot in relation to benefits? Well, sir, we think very special circumstances would occur in any event if you get to that point in the decision tree. However, it's conceivable, sir, you could think that we get to the point where one is finely balanced at the do the benefits clearly outweigh the harms, and that another benefit which is otherwise capable of being taken into consideration gets weighed in the planning balance. So at that point, sir, you, sir, and the Secretary of State could conclude that it's necessary because it's a benefit which then does allow the triggering of the very special circumstances test. Now, that's a whole series of ifs before you get to that point. Our fundamental stance in respect of our case is, as Mr. Goldsmith set out in his evidence when asked, we don't think it is necessary to outweigh harms or tip the balance from outweighing into clearly outweighing on our case. It's conceivable that you, sir, and or the Secretary of State may do. If that's the case, then one could have regard to it as a material consideration and reason for the granting of permission. But, sir, I'm not advocating a case that, based on the case that's been put before you by my clients, that it's necessary, and I'm not arguing that it's falling within Reg 122. We are essentially neutral on the point, as Mr. Taylor rightly says. It is, nonetheless, if you did get to that point, a consideration which would then become a material consideration. But that's subject to a series of ifs and buts on a decision tree that I think you need to go nowhere near that particular branch. Okay. Hope that helps.
Thanks, Mr. Tucker. Any response from Mr. Taylor? Or
no. I think what Mr. Tucker said is quite fair. There is a provision, as you know, to blue pencil this. It's slightly an unusual position for the Rule 6 party to be arguing that Sky should save £587,000, but it's our position that it's not necessary and that no weight should be given to it.
Okay, thank you, Mr. Fulton. Did you have anything else to say for the council?
No, I don't believe we do. Our position still stands. Obviously, it's an aspiration of the council, and we'd like to see that contribution. As I said, as part of the original application, space was being offered on the site, and through negotiations, the financial contribution to an off-site facility or contribution towards it would be a better use of that resource.
Okay, thank you. Thank you. I think I have all the parties' positions on that. Thank you. Moving on then to part 5, the bicycle hire contribution. I don't have any comments on this, and so happy to skip through that unless anyone does have anything to say. Part 6, the air quality management monitoring contribution. This is to contribute towards a monitoring station. Is this monitoring station already in place, do we know, or is this to provide a new one? I mean, the definition means the roadside air quality monitoring station located in Elstree Way. Is that your understanding, Mr. Faulkner?
Yes, I believe it is. I can't confirm that's the case. I don't think it changes anything in terms of what's being required here. I'm assuming there is a facility by the nature of that corridor, that there is air quality done along that corridor already, and this is obviously helping towards that over a 5-year period during the construction operational stage of this development.
Okay, so the contribution is towards the monitoring of towards the management of this monitoring station for 5 years. That's what's being sought.
That's correct, sir.
Yeah. Any comments on that from the appellants?
No.
Any
Not
knowledge
from
of
me,
whether there's a
no.
monitoring station? Sorry, Mr. Cosgrove.
I don't. Sorry, I'm not sure actually whether it's there or not.
Does that make a difference in
Not
your?
to not to us, no, I don't think.
Okay. Okay, fine. Well, we'll leave that there. Thank you. Part 7 is the town centre transport facility study. I asked that on the first day, I think, and as I understand it, that's for the funding of a study towards the continuation of pedestrian cycle routes through to the station. So it is, in terms of it being a benefit or mitigation, Mr. Faulkner, how would you classify it? Would you say it's more mitigation or benefit?
I would suggest it's somewhere in between the two, actually. It is an additional benefit. What's being offered by the appellant is already an upgrade of the cycle facility or segregated cycle facilities between the site and the Tesco roundabout. This is the aspiration to take that further than that, from the Tesco roundabout to Elstree and Bournemouth station. But it is, in terms of the sustainability of the site, providing that that additional or missing link would be clear benefit to the development, to the wider community, but also to the scheme itself in terms of modal shift, enhancing or seeing people move from car to cycle.
Okay, thank you. Mr. Tucker, you have a comment?
Yes, sir. So what I would suggest, for the reasons that were set out on day 1 of the inquiry, is that one shouldn't look at this in a binary way, i.e. does this achieve something or not? And if it doesn't achieve anything physically on the ground, then it should be disregarded. What it actually does is it seeks to identify whether something could be achieved to improve those linkages, both for existing and future development around the site, and make them more likely if because it's seeking to identify them. So if there are things that can be done, it makes those things which can be done more likely. So in that sort of wider, and I hate the word, but I'll use it, that wider, more holistic approach, it is a relevant land use consideration because it makes those improvements more likely to come forward. What it doesn't do is identify them or fund them. So the weight you need to give to that, sir, has to be tempered accordingly. So I don't invite you to take the binary approach of saying, does it do something physical? And it's quite different from the sort of cases that the courts have grappled with of, here's a sum of money just for some unspecified town centre improvements. It is for the feasibility study. And so the feasibility study is achieving what it says on the tin, assessing whether improvements are feasible, but not actually delivering them. I hope that helps, sir.
Yep, thank you, Mr. Tucker. Anything else to say on this obligation? If not, we'll move on then. Nearly there. Part 8 is a bus contribution. This is towards the 398 or similar. And then part 9 is an additional bus contribution, which is for local services. So obviously the first contribution is targeted towards the 398 or something similar to be determined. And then the additional contribution is for a more local service. It refers to things like the on-demand service, like the Hertfordshire Hoppers, which I believe is a kind of hail and ride kind of service. So these kind of work together, Mr. Faulkner, as a kind of, improving bus facilities, both in a specific way and a kind of more sort of local demand way.
That's correct, sir.
Okay, understood. Anything else anybody wants to say on those two obligations? Mr. Tucker.
Yes, sir. Just one point. Both aspects of this, both aspects are seeking to add flexibility rather than just saying here's a sum of money to this service 398. So it's being a little bit more sophisticated than just dealing with 398 in the event the bus services change over time and to give that flexibility to achieve the objective that the contributions are seeking to achieve.
Okay, and the 398 is a to county services. No, it's you know, the county council have jurisdiction for it, because I know there's the TfL buses that go to Bournemouth, but it's the 398
right.
County service.
It is a county service between Bournemouth and Potters Bar, I believe. It goes slightly beyond Potters Bar, but that's the central route. Yeah,
because we're in that slight overlap area where TfL has some services go into, and obviously other which are Hertfordshire only. Okay, thank you. And then part 10 is the shuttle bus contribution. I don't have any comments on that unless anybody else does. And I think that kind of deals with all of Schedule 1, and then remaining there is no other sort of schedule of comments, because this is obviously unilateral, and there's already the provisions for what the councils are required to do, or in terms of spending and demonstrating monitoring, etc. So anything else on the nuts and bolts of the unilateral undertaking? If not, then just in terms of signing and signatories, so Mr. Tucker, you were referring to 2 weeks for that. Is that still the case?
It is, sir. And the reason for 2 weeks rather than 1 week is I'm reminded that we're about to hit the Easter period, though goodness knows what's happened to 2025 so far. And that may cause issues in terms of the identification of people to sign matters. I can also throw in, if I may, the 2 points upon which we need to take instructions, i.e. the addition of the word all before reasonable endeavours, and the second of which is the issue of adding a definition for South East, which will obviously we'll have to, on the latter, agree that with the authority before we add that into the UU. So there's a couple of good reasons as to why 2 weeks may be sensible in this instance, sir.
Okay, fine. And it's obviously being signed by the two owners of the land. So we'll see that those signatures and so on at the end. Mr. Taylor, do you have a point on this?
Sorry, so yes, so it's just one fine point, and I should have made it before, and it's apologies, it's 1.15 forward 1.15. So page 7 of the track change version, which says all payments contributions made onto the deed are on condition that, and then B and C talks about the county council being required to repay. It is a legal point, so I'm just not sure that's actually effective. I don't know if you can unilaterally require a third party who isn't a party to the agreement to pay back money, notwithstanding that it has been provided to them conditionally. I'm not sure it works. It may not be something you want to turn your mind to, so it might be one for the appellants, but I'm just not sure it's effective.
Okay, any comments, Mr. Tucker?
Yeah, the answer is Mr. Taylor's quite right with regards to the terms of the obligation itself, that it doesn't create an obligation upon a non-party to pay sums of money that have been paid over. The question is whether it gives rise to a resulting trust for repayment if it's not repaid, if the intentions within the document are clear that it was intended to be paid only for a specific purpose and to be spent within that period of time. There is already first instance litigation to say that it doesn't give rise to a resulting trust. Ironically, I think there is actually litigation that's heading to the courts to discuss that issue. I have no idea what the outcome of that litigation is, nor am I in a position to provide any details of it, but it may change over the next 10 years. And if that's the case, then that does specify the intentions. I think that may be what may be behind the inclusion of clause 1.5b, 1.15b. I don't know. Again, I'll take instructions upon it. If it's not the intention and it's an oversight from a copy and paste error from a bilateral, then we'll notify the parties and I'll take instructions upon that as well. But I'm giving the benefit of the doubt to the solicitors that they're being very clever about it and putting that into 1.15b, and that's the reason, sir. But thank you, Mr. Taylor.
Thank you. Well, that can be clarified along with the other couple of points from on the elsewhere in the obligations, and then obviously update us as necessary.
Yes, sir.
Thank you, Mr. Tucker. And then yes, so I'm still happy obviously with that all that to agree to 2 weeks for executing the unilateral undertaking. So that would take us to the 16th of April. So that's just before the very late Easter break.
Yes, sir.
Easter weekend we're looking forward to, no doubt. So 16th of April.
Thank you, sir. And obviously, if it's completed earlier than that, we'll make sure it's sent to the case officer and as soon as it's completed. Oh, sorry,
Yes,
we'll send a certified copy to the case officer.
Yeah, and I should say, yes, the certified copy will suffice. I don't necessarily need to see a hard copy of it, or a physically wet signed copy of it. A certified copy will be fine for my purposes.
Thank you, sir.
Thank you. Okay, thank you. So that covers everything to the obligation, and the obligations and the unilateral. Are there any updates on the 2 points we were discussing on the conditions in terms of the noise levels and whether or not the condition 13 should refer to 14? Is there any update on that now, or do we need to come back to that maybe later?
So yes, on the referencing, I think we do have an answer in relation to that, which I'll defer to Mr. Goldsmith. In regard to the noise issue, so I've seen an email that's been written in discursive form to explain, I think, pretty much what I said. I've asked for that to be put in into a more formal way in an email. As soon as that's to hand, sir, then we should have that with you. We're obviously going over lunchtime, sir, so if we may submit that before the inquiry closes today, but it essentially picks up the point that I said.
Okay. Thank you. And so the point, Mr. Goldsmith, about the reference.
Yes, sir, might be one for Mr. Faulkner to add to as well, sir. But yeah, the condition 14 was actually included when the surface water drainage condition was condition 14. So I suspect it was at the wrong point anyway. It seems to be that it would, if it's going to refer to another condition, it should be what is now condition 8,
yeah,
which is the surface water runoff condition. But I'd like Mr. Faulkner to say he's happy with that.
That's what I was going to come back to say as well. I wasn't quite clear if it covered condition 9 as well. It seemed to overlap to a certain extent, so whether it should be 8 and 9. It's definitely
Possibly.
8, but I think possibly for clarity, it probably should cover both 8 and 9.
Okay. Any comments on that, Mr. Goldsmith?
No.
Okay, thank you. Well, I'll look at that all in the round when putting those conditions into my report, and then make sure the references are correct. But thank you for clarifying that. Okay, and then one other thing, I did have a quick look at the MP letter during the break. I don't know if there's anything. Have the other party had the opportunity to look at it? Anything that we need to say about it? Are we happy to add it as an inquiry document, Mr. Sheikh or Mr. Faulkner?
I'm content for it to be added as a document. I don't think I have any. It's noted. I don't have anything else to say on it though, in terms of what's the contents of the letter.
So I've also seen it quite happy for it to go in as an ID.
Okay. Anything from the Rule 6 party on that being added, Mr. Ronan?
No, perfectly content for that to go in, sir. Thank you.
Okay. Ms. Dunsford, you have your hand raised.
Oh, sorry, it's fine. I was just going to say we haven't seen it yet, so.
Okay, but I think it's probably because we haven't been added as an inquiry document yet. So
okay.
Yes, essentially it says what it says in terms of the inquiry and the MP's Sir Oliver Dowden's position on that. But yes, if it sounds like the three main parties are happy for it to be added, Mr. Tucker, I assume the opponent's still happy.
Yes, sir. I mean, we will add it to the core documents as soon as you tell us that you're happy for it to be added to the core documents. As I said, it's a bit of a curate's egg because it says some things which are helpful, frankly, to both party sides, but says them quite lightly. So I'm not sure how it take matters very much further. But Ms. Dunsford, I'm sure will enjoy it when she sees it, hopefully momentarily.
Okay. Well, if we can add that, I think it's inquiry document 17. We said so that can be uploaded. Thank you. Okay, thank you. So that brings us then to closing submissions for the parties. So I've just received an email with the Rule 6 parties closing submissions, but I think probably it'd be sensible to have a break before those are delivered. Mr. Ronan, are you happy to if we take a break and then come back to hear the Rule 6 parties?
Yes, certainly, sir. If it helps you with timetabling, I think I said I was going to be about 45 minutes, probably close to an hour, I'm afraid, but I'll do my best to bridge it where I can by not reading out quotes and things like that. So yes, entirely up to you. If you want to have a break now or a lunch break now, even, I'm in your hands.
Yeah, we could take a lunch break now and then come back. And Mr. Sheikh, obviously, have your closings, your timings similar or shorter?
Yes, 45 minutes, I'd expect.
Okay. Fine. And then Mr. Tucker, obviously your closing, I think we're around an hour, but depending on what's said in the closings of the other two parties.
Yes, sir. I'd be amazed if I resist the temptation to make comments in relation to my learner friends closing. So if you budget for an hour and a quarter, at 1.5 space paragraphs, mine is 27 pages. So that should be about an hour and 5 minutes in terms of delivery. But I think you should probably budget for an hour and 15.
Okay.
I don't think I've yet seen Mr. Ronan's closing. I don't think that's yet landed in my inbox.
No, sorry. I'm sorry. I sent it preemptively to the case officer just in case we were going to go straight into closings because it would have to take its time to get there. But I'll send it over shortly to you, Miss Hall, and to Mr. Shake, of course.
Thank you, Mr. Ronan.
Thank you. Mr. Morris, you have your hand raised. So you have
Yes, I just wanted to say that if it's appropriate, I'm happy for my submission on an additional condition to go in the inquiry documents. I just ask if you could just pull out others' emails as well as mine, and also in the signature, and if that could go up so people can see what's being proposed. Thank you.
Yes, thank you. I don't see there's a problem with that being added as an inquiry documents, but we can add that. Is up inquiry document 18. So your email or maybe just email plus attachment, and we can make sure that any personal information is redacted.
Thank you.
Yes, sir.
Okay, thank you. So add that as ID 18. Okay, we'll take a break now. Shall we say half an hour break? Come back at 1 o'clock. So this will be the lunch break effectively, if everyone's content with that, and then we'll come back at 1 o'clock and hear from Mr. Ronan and give all six parties closings.
Certainly.
Thank you all. So there's nothing else. We'll adjourn then until 1 o'clock. Thanks.
Thank you, sir.
Thank you.
Thank you.
Hello everyone, it's 1 o'clock and the inquiry is resumed. Are there any procedural points or notes that anything wants to raise before we hear the closing submissions of the Rule 6 party? Anything from anyone?
Not as yet, sir, in terms of the noise consultant's response. Hopefully we'll have that by the end of the day, sir.
Okay, thank you.
There's nothing from us, sir, if you're waiting for a positive response. Forgive me.
Sorry, I can hear myself being repeated.
I was saying there's nothing from us, sir. I don't know if you can perhaps try again.
So is anybody else getting feedback?
No, sir, I'm not. I can hear Mr. Ronan perfectly. Sorry.
That's okay. I can hear myself and then Mr. Tucker speaking to me. No, it's all. No. I'm going to just maybe leave this and come back in again, see if that helps.
Yes, of course.
Okay, thank you. I'll adjourn for a moment. Thank you. Hello everyone, I think I know what the problem was. The inquiry is resumed, obviously. I had the YouTube channel on over lunch just to see if it was working, and then I hadn't realised it was live, and so I could then hear myself and everybody else being played back a few moments later. So yes, we'll do a take 2 and start again. So Mr. Tucker, you said you had no update from the appellant over lunch. Thank you. And then Mr. Shake, anything from the council?
No, thanks, sir.
Yeah, and Mr. Ronan, obviously you're about to deliver your closings, but anything from the Rule 6 party before you do so?
No, nothing, sir. Thank you.
Okay, so hopefully everyone now has sight of Mr. Ronan's closings. So if we're happy to make a start, please begin, Mr. Ronan.
Thank you, sir. And as I said earlier, I'll try and take this reasonably quickly if I can, because you obviously have hopefully the benefit of a very long and full document. But beginning at paragraph 1, sir, we say that the evidence heard by this inquiry has not shown there to be a compelling planning case to justify the proposed large-scale harmful development of more than 15 hectares of greenbelt land. And the site, as we set out in opening, is a substantial piece of open land, largely given over to arable fields, and is located entirely within the greenbelt immediately outside Boreham Wood. This scheme, sir, is presented as fulfilling a planning need, but in reality we say it is designed to further the appellant's commercial imperatives. There is said to be no alternative way of meeting the claimed planning need, yet there is no assessment of alternative less harmful sites. The scheme as drafted permits the site to be used as an independent site to Sky Studios Elstree, yet the planning case does not speak to the merits of that. There are, sir, we say overall, no very special circumstances to justify this inappropriate development in the green belt. And all of these factors, we respectfully submit, strongly suggest that the appeal should be dismissed. And these closings are developed as follows. Firstly, we deal with this issue as to the discrepancy between the extent of development proposed by the scheme and the case advanced by the appellants. And we say it's a significant issue, sir, for you and indeed for the entire case. The Secretary of State considering the merits of the proposal in planning terms. The appellant's planning case, however, does not speak in our submission to the merits of the full extent of what is actually proposed. And we then, sir, in these submissions take the main issues as you identify in the CMC. I set them out in paragraph 4. I won't read them out, concluding with the overall conclusion and the planning balance. So turning to paragraph 5, what is the proposal before the Secretary of State? As I've said, this issue is fundamental to the Secretary of State's determination of the appeal. Self-evidently, the application for planning permission and now this appeal seek authorisation to carry out development as defined by Section 55 of the 1990 Act. And the Secretary of State, in assessing the merits of the proposal before her, must obviously assess the planning merits of the development for which planning permission is sought. She's required by law to consider whether the development for which planning permission is sought is in accordance with the development plan or not, and to determine the application in accordance with the development plan unless material considerations indicate otherwise. And the NPPF, of course, is such a consideration. Its support or otherwise for development in the Greenbelt turns on assessing the development for which planning permission is sought against the provisions of Chapter 13. And in our submission, at the close of the inquiry, it does not appear to be disputed that the development for which planning permission is sought by this appeal encompasses the use of the appeal site as a freestanding studio development. In other words, a development which could be used independently of the existing Sky Studios Elstree site. And sir, with respect, that should not be surprising. There is little scope for argument. The meaning and extent of the development permitted by a planning permission is ultimately a question of law, and that question is approached by applying principles of interpretation as developed by the courts. And as the Supreme Court's emphasised, regardless of the legal character of the document, the starting point and usually the end point is to find the natural and ordinary meaning of the words actually used. In considering the meaning of the words in question, those words have to be viewed in context and, of course, with common sense. That, sir, is the Lambeth case, of course, and you have the reference in the footnote. In a different case, Barton Parks Estates Limited, the Court of Appeal observed that in construing a planning permission, the permission must be read in a straightforward way, together with the conditions regulating the grant, and it's essential to ascertain the real meaning and scope of the grant itself. The application of those principles of interpretation to the proposed description of development produces a clear and obvious answer to the question posed above. What is the proposal? The development for which planning permission is sought by the appeal scheme is the construction and subsequent use of land as a film and television studio complex, use class EG2, with no requirement that it be used in connection with or ancillary to the existing SSE development. As both Mr. Davis and Mr. Goldsmith rightly accepted, no reasonable reader could read the proposed description of development as proposing a studio complex to be used in connection with the existing SSE site. The scope of the proposed development, read straightforwardly, means what it says. There's no functional restriction in the proposed grant that it be limited to use as an extension of or ancillary to the existing SSE site. This restriction does not exist. And that analysis of the description of development, sir, is consistent with sections 75(2) and 3 of the 1990 Act. Set those out, paragraph 13, subsection 2 says where planning permission is granted for the erection of a building, the grant of permission may also specify the purposes for which the building may be used. If no purpose is so specified, the permission shall be construed as including permission to use the building for the purpose for which it is designed. And in this appeal, sir, of course, the proposed description of development does specify the purposes for which the building may be used, namely use class EG Roman 2. And that use class is the research and development of products or processes. That purpose does not in any way limit the development to be used as an extension to the existing site. Further, sir, the proposed conditions do not seek to limit the scope of the grant so that the appeal scheme may only be used as an extension to SSE. Mr. Goldsmith rightly accepted that if the appeal were allowed, it would not be a breach of planning control for the appeal scheme to be used independently of SSE. If it would not be a breach of planning control, he must consider that as a matter of judgment, independent use is within the scope of the proposed development and not a breach of the proposed conditions. And again, with respect, that is plainly right. Proposed condition 21, I think that's now 20, given the amendment to the agreed list of conditions between the appellants and the LPA. Proposed condition 20 prevents a change of use via the use classes order, but it does not limit the use of this site as an extension of SSE. And critically, I've underlined the key words in that condition. It says the development hereby permitted shall not be used for any purpose other than as film and television studios. Turning to paragraph 17, sir, the approved plans and documents proposed in condition 2 do not require that the use of the scheme is limited to an extension of SSE. So the appellant's opening submissions record that, and I quote, "It cannot be stressed strongly enough that this is not a speculative proposal for a new footlight studio. Rather, it is a proposal for the extension of an existing operating studio. And with the greatest of respect, sir, that submission does not reflect the correct interpretation of the terms of the proposed development actually before you and the Secretary of State. The correct analysis of the proposal in planning land use terms is that the appellants seek permission for a film and television studio complex in the Greenbelt with no restriction on that use being in connection with or as an extension of the existing site." And so we set out at paragraph 19 why this matters. It matters because, as we've already said, the legal framework governing the decision requires the Secretary of State to engage with the merits of what, in land use planning terms, is actually proposed. The planning considerations in play for an extended site versus a standalone site are materially different. And indeed, Mr. Goldsmith initially accepted that in cross-examination, but seemed to later change that position. The need case for an extended site at this location versus a freestanding complex in the Greenbelt is materially different, and the appellant's case only speaks to the former. So it's for the appellants, forgive me, it's only the appellants who have led evidence at the inquiry with a view to inviting the Secretary of State to allow their appeal. The proposal, properly understood, would permit use of the appeal site as a studio complex independently of the SSE. And critically, in our submission, there is no planning case seeking to justify that development. The appellant's VSC case does not seek to justify the development of a studio complex in the Greenbelt, which may be used independently by any operator. The planning case does not seek to explain why the proposed development, properly understood, needs to be on this site with all the significant planning harm that entails. But in short, sir, the case overall does not seek, in our submission, to justify a grant of planning permission for the true scope of development actually sought. And you'll remember that Mr. Goldsmith, when asked whether he thought that it did, chose not to answer the question and again said independent use wouldn't happen. And this answer, sir, misses the point. The case presented to the inquiry by the appellants instead speaks to the merits of a particular user rather than the planning merits of the proposal itself. By presenting a case to the Secretary of State which does not engage with the full planning considerations inherent to the proposal, it is, with respect, difficult to see how the Secretary of State is in any position at all to perform the Section 36 duty or to allow the appeal. Even if the Secretary of State was persuaded of the merits of an extension to the existing site, in planning terms, she's being asked to grant a planning permission allowing this large Greenbelt site to be used as a freestanding studio. Any reasons given for granting such a permission must, with respect, be legally adequate and must engage with why a permission extending to independent use at this site is justified. And the planning reasons advanced by the appellants in our submission do not speak to the merits to the full extent of what is proposed. So in response, the appellants say that it's intended that the appeal scheme would be used by Sky Studios at the existing site. And with respect, that does not overcome the problem, essentially for three reasons. The first is that as a matter of law, the intentions of Sky Studios with respect to this appeal site in the event planning permission is granted do not determine the meaning or extent of the development for which planning permission is sought. Secondly, the intentions of Sky Studios do not control the application of 38.6 or national policy in assessing the proposed development. Section 38.6 of national policy requires the Secretary of State to assess the merits in planning land use terms of the scope of the development for which planning permission is sought, not, of course, the appellant's intentions. And finally, the intentions of Sky Studios do not empower or entitle the Secretary of State to assess the planning merits of the scheme through the lens of one particular user of the scheme. She is required to assess in planning terms the merits of the extent of development actually proposed. To do anything else with respect would be wrong in law. And that is why this point matters so much and is fundamental, sir, to your task and that of the Secretary of State. And just to deal with this point about future intention, sir, Mr. Goldsmith focused on the acceptability to Sky of an independent operator using the appeal site. But as we've heard today, Sky is not the owner of the site. and there's no evidence before the inquiry of what control, if any, Sky actually has over how the appeal site might be used in future should the appeal be allowed. Site owner, as we understand it, is a property investor, and it can reasonably be assumed that its interests ultimately lie in maximising value. Should the appeal be allowed, why could it not change its mind as to how to best make money from this site and lease the scheme to someone else if it considers that to be in its best interests? There's no evidential basis in our respectful submission on which the Secretary of State could reasonably conclude that the appeal site would not be used independently in future. It was also suggested by my learned friend that the Secretary of State is entitled to have regard to the probable consequences of granting planning permission by reference to the Scottish Widows case. And even if that proposition were correct as a matter of law, we respectfully say that case isn't authority for that proposition. There are two reasons why it does not overcome the issue. Firstly, the probable consequences of granting permission for the appeal scheme do not control the meaning of what properly interpreted the scheme would permit in planning terms. It's the planning merits of what is proposed that matter. And secondly, as a matter of fact, the evidence before you, sir, does not support the position that independent use of an adjacent site is unlikely to ever happen or cannot happen. Three reasons in particular for that we highlight at paragraph 27, sir. Firstly, the suggestion that operators would not operate cheek by jowl is directly contrary to the media quarter special policy area anticipated in the set-aside draft local plan. You'll remember, sir, the inquiry was taken to this, and the draft SPA contemplates a media quarter comprising, among other things, 3 contiguous studio production sites. And with respect, sir, the LPA, with their expertise of Boreham Wood's production heritage, contemplated contiguous independent sites as a realistic possibility in future. Secondly, sir, the design of the development does not in any way prevent the use of this scheme independently of the existing site. Mr. Davis confirmed that he was not aware of any functional reason why the site could not be used independently of SSE. Mr. Goldsmith, you'll remember, took issue with that suggestion and ultimately disagreed. Mr. Davis was right in his answer, however. The approved plans show a distinct site with its own access and all the infrastructure required to produce film and television content. That the existing site could be accessed from the appeal scheme via bridges does not change that, nor does the fact that the sites would share utilities. Thirdly, sir, third reason why there is no evidential basis on which to conclude there is no likelihood of independent use. Mr. Goldsmith relied on the backplot, as you'll remember, as a reason as to why independent use was unlikely. And with respect, this too misses the point. The existing site was not designed with a backlot. That SSE is without a permanent backlot does not mean the appeal site could not be used as an independent site. If anything, the backlot within the proposals is a further example of how the appeal site contains the infrastructure necessary for it to be used by a third party independently of SSE. And respectfully, it's irrelevant in planning terms that Sky, as Legal and General's tenant of the SSE site, would find it objectionable to not have access to a backlot on a neighbouring site controlled by its landlord. And finally, sir, notably, the appellant's approach to this issue at the inquiry is not consistent with their suggestion that independent use would never happen. The appellants could have proposed a description of development which expressly provided that this scheme was an extension of the existing site. As we say at paragraph 30, that would have been entirely lawful. It would have constituted a functional limitation within the grant of planning permission, such that if the appeal site was subsequently used as an independent studio complex, it would not be within the scope of the development permitted by the grant of planning permission. The appellants could, in the alternative or in addition, have proposed a condition limiting the grant so that the appeal scheme may only be used in extension of the existing site. And sir, it won't be lost on you, I'm sure, or the Secretary of State, that the appellants, via Mr. Goldsmith, accept that the proposal would permit the appeal site to be used independently of SSE. They contend that independent use would never happen, yet they resist a condition limiting the scheme to be used as an extension. In our respectful submission, the irresistible inference from this position is that one or both of the appellants are unwilling to shut out the possibility, in planning terms, of future independent of the use of the site, should planning permission be granted by this appeal. That's their choice, sir, and we suggest it's highly revealing. And for all those reasons, sir, alleged future intention as to the use of the scheme is not an answer. The appellants have proposed a wide description of development which would permit the appeal site to be used as an independent complex. That is the development which you and the Secretary of State must grapple with. On its own terms, the appellant's case does not seek to justify the planning merits of a site which can be used independently. And sir, with respect, that alone is reason enough to dismiss the appeal. And finally, sir, on this issue, there was, I think, an implied criticism of my clients that it did not raise this issue in its proofs of evidence. And with respect, sir, we reject that entirely. This is the appellant's appeal, and it's for them to ensure their evidence engages with and justifies the proposal they have put forward before the Secretary of State. Turning then, sir, to main issue 1, whether the proposal would be an appropriate development in the Green Belt. Our overall submission at paragraph 36 is that this is an appropriate development. The appellant's evidence does not show that the appeal scheme satisfies paragraphs 155A or B, and they are not accepted from the definition of inappropriate development and must therefore show VSC, and we address each of those paragraphs in turn. So in opening, the appellants set out that it cannot, and I quote, sensibly be suggested that release of what is a small proportion of the green belt of the green belt in the district could be said to fundamentally undermine the performance of the remainder of the green belt across the entirety of Hertsmere. And so at paragraph 38, we say that approach to paragraph 155A prioritises the size of the site relative to the total size of the remaining green belt land. It focuses on quantitative matters rather than qualitative matters. It's not the correct approach to paragraph 155A, and the council is entirely correct to submit that paragraph 155A calls for a holistic exercise of planning judgment. It is not a mathematical exercise of percentages and proportions. At the close of the inquiry, it appears to be common ground that paragraph 155A requires a qualitative planning judgment by the decision maker, and Mr. Williams confirmed that he was not suggesting that scale alone was the determining factor, and in fairness to him, he did have a caveat that he didn't think he'd taken that approach. In undertaking that judgment, sir, the PPGs and material consideration, we set that out there as that familiar passage on meaningful. I'm not going to read it out. And at paragraph 41, we say that Mr. Dingle has undertaken this approach required by the policy. He considers the site plays an important role in checking unrestricted sprawl in the plan area, and that in light of its size and location on the very edge of the built-up area of Boreham Wood, it contributes significantly to a clear visual and spatial distinction between the urban and the rural. And together with the countryside, along with the A1, the site helps create a strong greenbelt boundary and serves the purpose of checking unrestricted sprawl. And Mr. Dingle's evidence was that the site's development in the manner proposed would result in very significant harm to purpose A. And so that risk is brought into sharp relief when the scheme is viewed in the context of the existing site. That site was formerly greenbelt land, of course, and Boreham Wood has expanded as a result of it. It's now proposed to be expanded further. What next after that? The appellants say that the A1 is a barrier which prevents further development. That's not correct. As Mr. Dingle says, if anything, the A1 creates the risk of a conduit of development alongside it. And that is a risk which materially increases if the appeal site is developed. Incremental expansion becomes harder to resist. And so this is not an argument about precedent. It's a simple reflection that when the green belt is whittled down by the removal of large and important sites, the remaining greenbelt land becomes less effective at preventing sprawl, less able to do this meaningfully because the existing development is cited as a reason to justify further development. It's the thin end of the wedge. The site plays a very significant role in preventing unrestricted sprawl given its prominence. There is nothing in the surrounding greenbelt which plays a similar role. So we say at paragraph 45 that results in clear and significant conflict with purpose A. The remaining greenbelt's ability to restrict sprawl becomes materially weaker. It is less able to contribute to purpose A in a meaningful way, and that is a fundamental undermining of that central purpose. So similar concerns arise in respect of purpose C. As Mr. Dingle explains, Rowley Lane currently provides a well-defined edge to the built-up area of Boreham Wood. That edge assists in preventing encroachment and unrestricted sprawl. Post-development, this part of the greenbelt would no longer act as a substantial open site, preventing encroachment. So together with harm to purpose A, the ability of the remaining greenbelt land in our submission to resist further sprawl and encroachment in a meaningful way is undermined. There's also harm to purpose B, that's the prevention of neighbouring towns merging. Again, the site currently prevents this. prevents development and sprawl extending beyond Boreham Wood. The loss of the site from the Greenbelt would extend the built-up area with a weak northern barrier in the direction of Potter's Bar. It would be harder to resist proposals for the further northward expansion of this built-up area. The appeal scheme would bring neighbouring towns closer and would weaken the ability of the remaining Greenbelt to fulfil this purpose. The ability of this site to contribute to this purpose in a meaningful way is therefore undermined. And finally, sir, purpose E is harmed. The appellants say that there are no alternative sites on which this development, film and television studio development, could be accommodated. To allow the development to proceed without investigating whether the proposed development could be accommodated on non-Greenbelt land fundamentally undermines this purpose. By definition, the restrictive nature of Greenbelt policy encourages development elsewhere. To overcome that by a self-imposed commercial imperative fundamentally undermines the purpose of the Greenbelt in encouraging the use of derelict and other urban land. And so this all points to the conclusion that the development of this site would fundamentally undermine the purposes taken together of the remaining Greenbelt across the area of the plan. As Mr. Dingle puts it, the loss of the site would make it significantly harder for the remaining Greenbelt to resist further expansion. And so at paragraph 50, we say how this is consistent with the Greenbelt Stage 2 study. I won't read all of that out because I think my learned friend's probably going to cover that in some detail. In terms of what Mr. Williams does, and with the greatest of respect to him, we say it's difficult at paragraph 51 to see how his evidence on behalf of the appellants is really of any assistance to you. The cross-examination revealed that his approach to para 155A was essentially this. Firstly, he considered the Greenbelt assessments. He acknowledges they were prepared for different purposes. They do not consider paragraph 155A, of course. He does not consider those assessments in their methodology to be consistent with the PPG. He's not carried out his own site-specific assessment of how the site as developed impacts the remaining Greenbelt. He looks at the existing evidence base through the lens of the PPG. Mr. Williams has not sought to develop a methodology to analyse the impact of the development for the purposes of this policy. And where we end up, sir, is paragraph D here. Through analysing a document which was not prepared for the purposes of paragraph 155A, and which in any event is alleged to be inconsistent by him with the PPG, he concludes the proposed development does not fundamentally undermine the purposes taken together of the Greenbelt in the area of the plan. So in conclusion on paragraph 155A, we invite you and the Secretary of State to instead focus on the issues identified above, the extent to which the appeal scheme would affect the ability of all the remaining Greenbelt across the area of the plan, serving all five of the purposes in a meaningful way. Mr. Dingle's analysis respectfully clearly shows that, other than purpose D, the ability of the remaining Greenbelt in the plan area to contribute in a meaningful way has been affected. The loss of this site would make it harder for the remaining Greenbelt to resist expansion. If the Secretary of State reaches that conclusion, she should conclude the proposal would fundamentally undermine the purposes taken together of the remaining Greenbelt across the area of the plan, and on that basis, the proposal is inappropriate development for the purposes of Greenbelt policy. So turning to 155B at paragraph 54, in our submission, there can't reasonably be disagreement as to the meaning excuse me, and requirements of paragraph 155B. The language is clear and unambiguous. There has to be a demonstrable unmet need for the type of development proposed. A demonstrable need is one in which is either clearly apparent without more supply, such as a failure to demonstrate a 5-year housing land supply in the case of housing, or it's a need which is capable of being proven by evidence. An unmet need principally speaks to an existing need which has been proven, which is not currently being fulfilled. And that follows, we say, from the word unmet. It refers to the current position with respect to the need for the type of development. It logically entails, insofar as is possible, looking at what is objectively required and whether current provision is in fact meeting that need. The type of development proposed speaks for itself. The policy is directed at existing need for the type land use proposed, not the individual need of the applicant. The type of development proposed in this appeal, of course, is film and television production studios. And to be accepted from the definition of inappropriate development under 155B, you and the Secretary of State, sir, must be satisfied that there is a proven unmet need for film and television production studios. And sir, at paragraph 56, we say that all of the evidence before the inquiry, essentially for 5 reasons, which I'll now come on to, does not show there is an unmet need. Firstly, sir, there's no national or local shortfall of studio space. For the purposes of this appeal, sir, The appellants don't undertake any analysis to arrive at an objectively assessed figure of how much studio space is said to be needed in the UK. Nowhere in their evidence is there any analysis that the current total stock is in deficit against an objectively assessed figure. And we say that's important because when you drill into the detail, there is in fact a glut of studio space as opposed to any unmet demand. The Knight Frank, for the purposes of the Marlowe scheme, undertook a comprehensive analysis which involved looking at existing studio space and attempting to assess what might objectively be required in the future. They concluded that as of October 2024, there was almost 7.6 million square foot of stage space. They say that this spans across 107 studios and almost 490 stages. This total stage space has increased by 4.6% over the past year and by 53% since 2019. Excuse me. They also say that there was a great deal of new studio space added to the market in 2021 and 2022, with total stock rising by 36.1%, or an average of 16.7% over these 2 years. Knight Frank also say that over the past 5 years, stock has increased significantly faster than production spend. And Knight Frank estimated future demand for studio space by way of projected spend and capacity utilisation rates adjusted for inflation. And sir, nothing like this has been done by the appellants for the purposes of this appeal. In 2024, the Knight Frank report estimated that for 2025, 500,000 square foot of additional studio space was needed, and they considered that need would increase as follows. I've set that out in table form there. Looking forward to 2029 is 2.5 million square foot of stage space on their analysis. So turning to paragraph 63, there is, we say, on any view, more planned studio space than is required to meet this demand. Firstly, Knight Frank considered that as at the date of their report, 5.8 million square foot of planned sound stages was in existence, i.e. in the pipeline. The Hertsmere Film and Television Study suggested the pipeline to be even bigger at approximately 6.4 million square feet. Approximately 4.8 million of that pipeline is planned for London, South East and East regions, that is of England. 83% of the total pipeline, 3.6 million square foot, or 62%, is within the West London cluster. Of that total pipeline, 4.2 million square foot is Grade A and is located within the West London cluster. And that's consistent with SPI, and that, of course, there is the Film and Television Studio Study authors. They say the pipeline comprises 273 sound stages in more than 40 developments, with most taking place in or very close to the Metro London area and other existing production centres in the UK. Critically, sir, of the pipeline, 2.9 million square foot already has planning permission. Of those existing permissions, 2.3 million square foot of studio space is already approved for London, the South East and the East of England, and 1.2 million square foot, that should say, for the West London cluster. The reference there, 3.34, is to the report itself. Recalling, sir, that for 2025, Knight Frank estimated that demand was 0.5 million square foot of studio space. There is now, as we speak, more than 6 times that figure in existing planning permissions. The current demand manifestly is met. Looking forward to 2029, there are more than enough planning permissions to meet projected demand for the next 4 years. Even now, there is an excess against the need for 2029, 2.9 million square foot against an assessed need of 2.5 million square foot. And of course, further applications for studio development between now and then could come forward to add to the pipeline. So at paragraph 66, we suggest that the submission that demand is currently unmet or will be unmet is simply not credible. It is being met many times over. If the market is not using some of those planning permissions, as Mr. Davis suggests, that speaks to the demand waning. Developers operate in a market, they respond to demand. If some schemes are not being pursued, it can be inferred that developers do not see the demand to be particularly strong. And the same point can be made of Mr. Davis's criticisms of those schemes which are speculative. Notwithstanding that 2 of the Grade A studios identified in Mr. Davis's report are in fact speculative and are operating, Shinfield and Belfast, if the demand is, as the appellants claim, unmet, a speculative scheme cannot rationally be treated differently in assessing demand. If there is demand, the scheme will be used. If there is no demand for speculative schemes, that strongly suggests that the market does not want further studio space. Mr. Davis's attempt to discount certain developments from the pipeline is not based on any principles, and is in any event, of the 2 parameters he deploys to determine when a scheme has a reasonable prospect of delivery, planning consent and funding, he gives no explanation of what conversations, if any, he had with the promoters of each scheme to determine which did and did not have funding. Indeed, sir, there's no transparency at all as to how the database of potential schemes relied upon by Mr. Davis is compiled or updated. The Knight Frank data is inconsistent, sir, with the appellant's claim that there is an unmet demand for film and television production studios. On Knight Frank's analysis, both for this year and in the longer term, there are more planning permissions permitting studio development in excess of what Knight Frank say is objectively required. There is currently no unmet need, and the need for the future is currently more than adequately addressed. The appellants have not undertaken their own analysis to dispute these figures. So turning to the second of the 5 reasons why we say there's no unmet need, paragraph 70, local plan policy does not evidence an unmet need for film and television production space. Mr. Goldsmith suggests in his proof that it is the local need and case for expansion that are central to the appellant's case. And both he and Mr. Davis rely on local planning policy to support that case. Again, there is no analysis of the extent of studio space in the region or how that compares with what is objectively assessed as being required. Neither the local plan, the set-aside draft local plan, or its evidence base point to a demonstrable unmet need for film and television production studio space. And turning firstly to the local plan, as Mr. Dingle says in his evidence, given the history of film and television production in Boreham Wood, it's a type of development which the local planning authority could reasonably be taken to have been aware of and identify need as appropriate. We're still in the local plan period. Policy CS11 of the core strategy, together with its supporting text, offers no support at all to the claim that there is an unmet need for film and television production studios. If anything, it's equivocal, your Embassy noting uncertainty about demand for BBC Elstree studios in its supporting text. And we respectfully say that Mr. Davis is wrong to claim that by policy CS11, the council's local plan recognises a need for film and television studio development. That is not what the words in the policy say or indeed mean. The Hertsmere film and television study also does not offer any support to the claim that there is a demonstrable unmet need. This document was prepared to support the drafting of the local plan. If any document is likely to identify a shortfall in production space locally or a need for expansion of existing sites, sir, it would be this. Nowhere does that study say there is or will be a shortfall. In fact, it says precisely the opposite. I quote, "To date, Hertsmere's studio infrastructure has been most suitable for delivering broadcast television and some high-end TV features. However, the introduction of Sky Studios will expand the range of projects and competency significantly. With the presence of Elstree Studios, BBC Elstree and Sky Studios, Hertsmere has one of the highest concentrations of studio facilities in the UK. As is the case with the alleged national needs, this Hertsmere study at best speaks to an ambition to grow rather than an existing unmet need. And those are fundamentally different propositions. The appellants, with respect, conflate them. The documents do not show an unmet need at the local level for further film and television production studios. Finally, sir, Mr. Davis is wrong in our respectful submission in his claim that the listing as one of its strategic objectives in the set-aside local plan to ensure that an expanding film and television industry delivers social, environmental and economic benefits for local communities. That in doing so, the set-aside local plan provides an acknowledgement of local need for film and television studio space. Again, sir, that's simply not what the words mean and it's not what they say. Local plan policy overall does not demonstrate an unmet need. Turning to reason 3 of our 5 reasons, sir, excuse me, there's no evidence as a matter of fact showing that the existing site, the existing SSE site is at capacity, that other studios in the region are at capacity, or even that studios in the UK are at capacity. And so that is surprising. Unmet demand could reasonably manifest itself by existing facilities turning away productions. Mr. Davis accepted that. It's right because the capacity of existing studio space to accommodate demand is clearly a central consideration to whether or not demand is unmet. And despite being relevant to paragraph 155B, the extent or otherwise of existing capacity is simply not evidenced by the appellants. It's also surprising, sir, as the claim of no capacity at SSE is an important part of the appellant's case. However, there's no analysis anywhere in their evidence of the existing capacity of the existing site. The tenant's statement appended to Mr. Goldsmith's proof says that SSE is essentially working at full capacity. This document, i.e. the tenant statement, it's undated, its author or authors are not specified, and the appellants did not call them as a witness to give oral evidence. The weight you give to it, sir, must therefore reflect that. Mr. Davis has not taken any steps to independently analyse the claim that there is no capacity at the existing SSE site. Essentially, his evidence was that he's relied upon what he was told. It's entirely possible, sir, though, that Sky's understanding of his existing capacity does not reflect what the industry understands by that term. And for example, Mr. Davis says a studio should be considered at capacity when it's at 80%. Or indeed, whether the existing site, or the way the existing site works, forgive me, means that, in fact, it could quite easily accommodate more production. None of this work has been done by Mr. Davis or anyone else giving evidence for the appellants, or at least if it has, it's not in evidence. Mr. Davis then suggested that he did not take any further steps to assess what he was told by Sky because he was not independent of the appellants. And if Mr. Davis did not consider himself independent, then with respect to him, his evidence should not be given any weight at all. Against the claim of full capacity, sir, Miss Dunford's speech to the inquiry on day one stated that Tom Avison, Sky's operation director, was asked at a meeting whether Sky would appeal. His reply was, no, we have enough space at this time and we will see how the market moves in future. The appellants did not challenge that statement. Ms Dunford also said that in October 23, at the UK parliamentary inquiry to the BFI, to the British film industry, Adrian Watton, CEO of the British Film Commission, said that we have enough studio capacity to meet demand. What we are lacking is skills to meet that capacity. And again, sir, you'll remember this wasn't challenged. So all of this must be viewed against the context that, in respect of the existing development, there was no suggestion that it would not be big enough, that it would require further expansion, or that it constituted phase one of a bigger site. Moreover, sir, there is no evidence of even a single production being turned away from SSE or indeed any other facility. Mr. Davis agreed that this was a factor that might suggest unmet need. In respect of one production, Wicked, the appellants say that Wicked faced problems because the site was unfinished due to construction delays. It's not surprising, sir, that an unfinished site posed problems. Mr. Goldsmith explains how production was split across SSE and Warner Brothers Studios Leavesden. That Leavesden was able to accommodate Wicked does not speak to there being a demonstrable unmet need. On the contrary, it confirms that sufficient space exists. That a split site was achieved does not speak to a planning need for extension. Mr. Davis referred to Shinfield. That is the only site in respect of which Mr. Davis offers some data as to the capacity of an existing studio. He doesn't give a source, but he says that in respect of Shinfield, there is currently still a lot of vacant capacity to fill, but they have a large number of shows confirmed for shooting there in 2025. They are expecting to be 80% occupied this year. Shinfield is the type of state-of-the-art development which the appeal scheme is compared to. The appellant's own evidence suggests that it's not yet at capacity, and that too is inconsistent with there being an unmet need. So the evidence provided does not show that existing studios are at capacity, or even that the SSE site at capacity. There's no demonstrable unmet need on that basis. Turning to issue 4, or reason 4 of 5 as to why there's no unmet need on the evidence, at paragraph 91, sir, we say that Mr. Davis reports how in recent years the amount of money spent on production in the UK has increased. However, that increase in spend does not translate into current unmet need for studio space. And Mr. Davis, in fairness, doesn't suggest that it does. He suggests that the main factor behind the growth is an increase in spend per production, not as an increase in spend might imply that there are more productions taking place, which in turn increases the demand for studio space. Another factor is a general inflation in production costs, as explained by the Hertsmere Film and Television Study. And the appeal to growth of the growth of the sector, sir, tells us very little about the extent to which demand for studio space is unmet. And turning to our final reason as to why the evidence doesn't show an unmet need, national economic policy does not show a demonstrable unmet need in planning terms. Mr. Goldsmith, in his evidence on unmet need, draws attention to the government's ambition to grow the creative industries. And self-evidently, sir, a desire to grow an industry is not evidence in planning land use terms of a shortage of studio space. Indeed, Mr. Goldsmith does not ultimately claim that it does. Rather, he notes that the growth in the creative industries, including this sector, remains high on the government's agenda. And that may be so, sir, but there is a distinction between the government's ambition to grow a sector and the extent of demand within that sector for studio space. Finally, sir, Mr. Gunn-Jones does not speak to the commercial need for the development, and he expressly refers to Mr. Goldsmith's evidence for the unmet need. Mr. Gunn-Jones highlights what at best can be described as a government ambition for growth in the production sector. Again, that is not the same thing as need in planning terms for the type of development proposed. That the sector has significant potential for growth does not speak to an unmet need in planning land use terms. Creating the conditions in which businesses can invest, expand and adapt is fundamentally a different point to unmet need. His evidence does not speak to unmet need, and in fairness to Mr. Gunn-Jones, it doesn't purport to. At its highest, the national economic policy position, sir, might support an assumption that demand in future might grow if government is successful in growing the sector. That assumption, however, is plainly not enough to conclude that the evidence shows that current demand is currently unmet. So our overall conclusion at paragraph 96 is that there is no demonstrable unmet need for the type of development proposed. It's inappropriate development on that basis. The evidence does not come close to evidencing that demand is unmet. Overall, the existing stock and pipeline, we say at 97, shows a profound over-delivery of studio space in the short and medium term. The policy documents do not show unmet need, and the appellant's case in our respectful submission under paragraph 155B fails. So turning to your second of the main issues, openness. The proposed development causes substantial harm to openness and the purposes of the Greenbelt insofar as they relate to keeping land permanently open and free from sprawl. I've covered that to a large extent in 155A, and I'm not going to repeat them, but they apply with equal force here. Turning to paragraph 99, in respect of openness, we respectfully suggest there cannot seriously be any doubt that the impact to the openness of the site is substantial. 77% of the site will be covered in built form or hard surfaces. The extent and scale of this built form could not be further from the existing open and historic field pattern on the site. That pattern, of course, would be replaced with 8 densely packed industrial buildings between 21 metres and 27.5 metres tall. The degree of activity introduced by the scheme is also on any view substantial. There's provision for 1,000 car parking spaces and all the activity that entails. The new permanent backlot will be used for filming in addition to storage and set production. There would be a hive of activity on or around this site. A substantial base camp, we're told, will be present on site, presumably in and around the spaces between the buildings. And on a large film, the inquiry is told that this could consist of between 10, 15, sometimes more, trailers of around 35 to 55 feet in length, accommodating a range of services. Feature film unit base could easily exceed 40 separate vehicles. And the quote finishes that this would not include crew personal vehicles. The planning statement, turning to 102, states that this development will operate 24 hours a day, 7 days a week. There's also a shooting unit described as the collection of vehicles required to provide support to the shooting crew exclusively. That can comprise, we're told, between 15 and 20 plus vehicles, which carry the essential shoot-related equipment for the various departments. These vehicles range from 18-ton trucks down to 7.5-ton trucks, 3.5-ton vans, minibuses and private cars. All of these vehicles need to be located as close to the stage as possible to maximise efficiency and minimise time. Again, this activity will conceivably take place in and around the open space between the proposed buildings. So not only will there be more than 3/4 of the site be developed with buildings and hard surfaces, but what little open space remains between the buildings must house these further substantial activities, and the entire scheme, of course, is proposed to be permanent. Mr. Dingle concludes that given the location, size, character and appearance of the existing site, the scale of the proposals would cause substantial permanent harm visually and spatially to the openness of the green belt. Mr. Williams, on behalf of the appellants, reaches an overall judgment that the impact on openness is moderate, and that's principally because he considers the visual impact to be low. However, with respect, that approach fails to properly account for the introduction of a permanent backdrop and therefore the permanent harm that arises to openness from this. He also fails to properly account for other activity on site. Nowhere in his analysis do we expressly see any consideration of the true extent of the activity on site. Traffic is the only factor he mentions, but that's simply one example given in the PPG. And finally, we get no reference to the opening hours in Mr. Williams' evidence. As I've already said, this is a 24/7 development. So we invite you and the Secretary of State to prefer Mr. Dingle's evidence and conclude that the appeal scheme would result in substantial permanent harm to the openness of the green belt. Turning to your main issue 3, the need for the development, benefits of co-location, the availability of alternative sites. So I've already set out above why we say there is no unmet need. I'm not going to repeat that. It is in many respects, however, a complete answer to this issue. If the Secretary of State agrees there's no unmet need, logically there is no need for more space at this particular site. If the need is unmet, there is no planning justification providing space which is surplus to requirements. Turning to the substance of the point, in the first instance, there is no evidence as to the need for standalone studio space to be located at this particular site. The appeal scheme, for the reasons given above, would in planning terms permit the use of the site independently to SSE. The appellants may well intend to use the scheme in connection with SSE, but that does not change what the proposals are as a matter of fact or law. If in planning terms what is permitted is a standalone site, the appellants should evidence the need for a standalone site at this particular greenbelt location. They do not attempt to do so. Mr. Davis, the principal witness called to speak on the market need on behalf of the appellants, does not speak to the need for an independent site at this location. And indeed, sir, you'll remember that applying the definition of Grade A studio space to the Knight Frank report, which Mr. Davis shares, this scheme is not Grade A at all if used independently of SSE. That's because it does not have enough soundstage space to meet that definition. Mr. Davis's evidence at best speaks to the business case for an expansion to SSE as opposed to the need for what in planning terms would be secured by this scheme. Leaving aside that there is no unmet need for further film and television studios, no planning reasons are given as to why what is proposed, a planning permission for studio space which can be used independently, is required to be located in this particular harmful greenbelt location. And so the council appear to accept that when the scheme is viewed through the lens of meeting a need for further studio space, such a need does not necessarily need to be located on the appeal site. And in the update to members at application stage, officers noted the following, and I'll just read the underlined passage. Officers accept that broader space needs, as opposed to the expansion of the existing operation, may be capable of being accommodated elsewhere, potentially on land that might not be in the green belt. You'll read that quote in full in your own time, sir. Further studio space, as sought by this scheme, does not need to be located at this site. To the extent that the appellants rely upon the need for further premises to serve SSE as a justification for this scheme, sir, we say there are no compelling planning reasons to conclude that further premises must be located here on the adjoining site. There's essentially two reasons for that. First, the appellants rely solely on Mr. Davis to claim that modern productions require very extensive sites. Mr. Davis sets out his opinion on why that is. He provides an overview of his understanding of how modern high-end film and television productions operate, and he says, and I quote, there will be an increasing demand for state-of-the-art new studio facilities that can accommodate burgeoning high-end TV market and a reconstituted major film production industry. Notably, sir, his report does not review the relevant literature and nowhere in his analysis is he able to point to any independent confirmation that, as he puts it, we are seeing a reconstituted film industry with changing needs. If the changing needs are as extensive and as apparent as he claims, he ought to have been able to cite independent research confirming that, and he has not. Secondly, sir, to the extent that it's claimed that SSE is not sufficient in scale for certain productions, there is no in principle reason, no planning reason, why any shortfall in space must be located alongside the existing site. As the evidence shows, it's entirely possible to produce content across a split site. As Mr. Goldsmith rightly accepted, there is no locational imperative in planning terms for further premises to be located here. Further premises for SSE is not a development which, by definition, must be located in a particular site, such as a motorway service station might be. The appellant's objection to a split site is ultimately about cost savings and operational preference, rather than planning need. And so I don't need to tell you that the planning system does not exist to promote the preferences of particular landowners. An operational preference for further nearby premises is not a planning reason to justify the submission that there is a need to locate further premises at this site. So there is no planning need for the scheme to be located as proposed, and self-evidently a lack of planning need to be located at this particular site cannot outweigh the harm to the green belt. Turning to both alternative sites, paragraph 122, we say there are two distinct reasons why the Secretary of State must, as a matter of law, consider whether this development might more appropriately be located on a site which entails less planning harm. Firstly, sir, a rational assessment of the appellant's own case requires consideration of whether further studio space can be accommodated elsewhere. Firstly, the appellants say in their VSC case that there are no alternative sites on which further premises could be developed. But as Mr. Goldsmith accepted, there's no locational imperative for the development to be here. In planning terms, it does not have to be on this particular site, sir. If it doesn't have to be on this site, the Secretary of State cannot rationally accept the applicant's VSC argument that there are no alternatives without asking herself whether she agrees that there are indeed no alternative sites on which further space could be delivered. Consideration of whether there truly are no alternatives is therefore necessary to rationally and lawfully evaluate the appellant's case. It follows from both how the description of development has been framed, the justification given for the scheme, and the lack of locational imperative. A rational assessment of the case before you and the Secretary of State requires consideration of the extent to which the development might be accommodated elsewhere on a less harmful site. And secondly, sir, this is a distinct reason, whether development could be sited in a location which is less harmful in planning terms is, in our submission, a consideration which is so obviously material that it would be wrong in law to not consider it. We set out in 126 the starting point. The starting point is that a decision maker is not obliged to have regard to every possible consideration which might be relevant to his or her decision. But if a consideration is expressly or impliedly identified by statute or policy as a matter which must be taken into account, there'll be an error of law if the decision maker fails to have regard to it. If a consideration, however, is not mandated by the legislation, it must nonetheless be taken into account if it is obviously material to the decision. And the courts have established that a consideration is obviously material if a failure to take it into account would be irrational and would not accord with the intention of the legislation. Whether the development can be accommodated at an alternative site is, in principle, capable of constituting such a consideration. In the Trust House 40 case, the High Court emphasised that generally the fact that other land exists upon which the development would yet be more acceptable for planning purposes would not normally justify the refusal of planning permission upon the application site. That's the general position. The court emphasised, however, that where there are clear planning objections to development on the particular site, it may well be relevant and indeed necessary to consider whether there is a more appropriate alternative site elsewhere. This is particularly so when the development is bound to have significant adverse effects, and where the major argument advanced in support of the application is that the need for the development outweighs the planning disadvantages inherent in it. The consideration, sir, becomes necessary as opposed to relevant when it would be irrational to not consider it. And on the facts of this case, we submit that it would be irrational to not take alternatives into account, such that it is an obviously material consideration to the Secretary of State's decision. The proposal is a major development for over 15 hectares of inappropriate development in the Green Belt. It's contrary to the development plan. It gives rise to significant planning harm. That harm arises from the development of the particular site as opposed to anything inherent to the proposals. The appellants say the scheme meets a regional need, but there's no locational imperative for the proposed development to be on this particular site, no matter how you view it. In those circumstances, we say it would be irrational to not consider whether the claimed planning need, which does not have to be located at this particular site, could be met somewhere else in the region on a site which entails less planning harm should it be developed. The appellant's commercial preferences for development at an adjacent site do not change this analysis, nor does the suggestion that they would not, in light of their own imperatives, develop a different site. So planning is about meeting land use needs in the public interest. In considering whether the proposal might be accommodated on a site entailing less planning harm, the inquiry should be whether there is a more appropriate site elsewhere for the form of development proposed. That can't be avoided by the appellants praying in aid of their own commercial preferences for this adjacent site. And here, sir, there are analogies with the retail sequential test. In that context, suitable and available generally mean suitable and available for the broad type of development which is proposed in the application by approximate size, type, range of goods, so as to exclude the identity and personal or corporate attitudes of an individual retailer. I won't read the quote there, sir, but that quote from Aldgate Properties, you'll see in your own time, we say supports that analysis. 133, paragraph 133, sir, alternative sites in this context should be approached in the same way. Is there a more appropriate site elsewhere for the form of development proposed? Not, is there a more appropriate site elsewhere for the form of development proposed and which is acceptable to the appellants? And finally, sir, we set out in 134 why the lack of particular sites is not an answer to this point. I won't read the full quote there from Trust House Photo, but perhaps just orally just emphasise the last of those points from the court's judgment at paragraph 7 or bracket 7. The court said that as a matter of law, it's accordingly open to a planning authority to conclude on the facts that an accepted need can and should be met elsewhere upon the application or appeal site without reference to any specific alternative sites. Here, sir, the planning objections relate to the development of the application site itself. In those circumstances, the Secretary of State, if the Secretary of State accepts, contrary to our case, that there is a need for the proposed development, it is open to her to conclude that the proposal can and should be met elsewhere than upon the appeal site without reference to any specific alternative sites. In our respectful submission, that is plainly the correct judgment to arrive at if she concludes there is an accepted need. There is no planning justification for meeting that need at this particular site. As the Council acknowledges, broader studio space needs might be capable of being met on non-greenbelt land. An extended site, in planning terms, does not require this greenbelt site to be developed. Whether viewed as a permission for standalone site or an extension, there is no planning need for it to be here. And so we respectfully say the Secretary of State should conclude that any need for further studio space that she finds can and should be met on non-greenbelt land and dismiss the appeal for that reason. Finally, sir, the VSC case main issue 4, paragraph 137 sets out our essential position. We say it is inappropriate development. We say there must be VSC, and we say that there are no VSC here. Turning to paragraph 140, you will be familiar with the VSC test. I won't read it out, but turning there to my second sentence, although only 2 harms are identified by Mr. Goldsmith's summary table, it is now accepted that the harms to the greenbelt to go into the VSC balance consist of definitional harm, harm to purposes, and harm to openness, and national policy prescribes the weight to be given to all 3 of those harms to be substantial. Additionally, sir, the appellants accept 2 other harms exist: harm caused by loss of trees and harm caused by the landscape character changes. And at 143, sir, I've set out what I suggested a more accurate table now following cross-examination. Turning to paragraph 144, sir, we say that for the following reasons, the benefits of the scheme contended for by the appellants do not clearly outweigh the harms such that no VSC exist. Need for studio space. So this benefit is said to be meeting the identified need for new purpose-built film and TV studio space. If the Secretary of State is required to undertake the VSC balance because she does not consider there to be a demonstrable unmet need, this factor should, in our submission, not form part of the VSC balance. If the appellants are unsuccessful on 155B, that's because they have not established that there is a proven unmet need for this type of development. Meeting an identified need, which is in fact unmet, cannot rationally be a benefit at all if the 155B case fails, and indeed Mr. Goldsmith appeared to initially accept that. Separately, Mr. Goldsmith says that he gives substantial weight to the need case because the claimed lack of alternative sites. But as I've said, sir, he accepted there's no locational imperative in planning terms for the scheme to be located here. If it does not need to be located on this particular site, we say meeting a need cannot rationally be given substantial weight because there are no alternatives unless it's been established that there are truly no alternatives, and the appellants have not established that fact. So overall, sir, we say that this factor should be given no weight in the absence of that being established. And overall, it's either not a benefit at all, subject to 155B, or should not be given any weight unless the Secretary of State is satisfied that there are no alternative sites. Turning to the next benefits, economic and socio-economic benefits. There's no dispute between us that an expanded Sky Studios will bring economic benefits. However, the nature of the jobs created by the expansion must be recognised. 88 full-time staff would be employed at the development. That equates to an employment density of 1 employee per 815 square metres of floor space, and that is a modest return for the loss of a substantial area of green belt. And while the development will support other jobs, they will be related to high-end TV and films in production and will therefore be temporary and transient in nature. It's simply uncertain to what extent jobs will be created for those living in Hertsmere and Borough Council in particular. As Mr. Dingle explained to you, sir, the 10-mile radius in which those working at the site may come from encompasses most of central London, and you and both the Secretary of State will take your own view on whether the creation of jobs for those living in Notting Hill will be a benefit for Boreham Wood. Mr. Dingle therefore reduces the weight given to this matter to substantial. The appellants are wrong to claim that by itself it comes close to constituting VSC. So, socio-economic benefits, paragraph 152, Mr. Dingle identifies 3 fundamental problems to the socio-economic benefits said to arise from expansion. Firstly, the proposed community space on the first floor of the ancillary services building is described by the council as being quite small and would be in a less accessible area, a less accessible edge of town location with limited opportunities for visitors. That ought to limit the weight afforded to this aspect of the socio-economic benefit. Secondly, sir, while reliance is placed by the appellants on socio-economic measures that could be developed through the appeal scheme, the detail of what will actually be provided is left to condition. I won't read the condition, but the critical point is that the training and employment community use and outreach management strategy that will be submitted and approved. The details of the strategy, what happens if targets are not met, are unknown. Turning to paragraph 156, we say the socio-economic benefits should be given a moderate weight. However, that is subject to the contribution to the Heritage Centre. A contribution by the appellants to the Heritage Centre forms part of the reasons Mr. Goldsmith gives for affording the socio-economic benefit substantial weight. However, both Mr. Goldsmith and Mr. Dingle accept that there's no policy requirement for this contribution. This contribution is not necessary to make the development acceptable in planning terms. Mr. Goldsmith rightly accepted that it's not Reg 122 compliant. It cannot constitute a reason for granting planning permission. We discussed that already today. It should not be reflected in the weight afforded to this benefit. It should be afforded limited weight at most. The Secretary of State is invited to prepare his evidence. Finally, sir, importantly, the nature of these benefits, economic and socio-economic benefits, and the weight afforded to them by Mr. Goldsmith are premised on the appeal scheme operating as an extension to the existing site. As he puts it, it is clear that the appeal scheme presents an opportunity to significantly increase the level of economic benefits generated by Sky Studios Elstree. But as we set out above, the proposal is not limited in that way. In terms of the economic and socio-economic benefits of an independent site, there's no analysis of what those benefits might be. In the absence of a connection to the existing site, they could conceivably be far less significant. And the weight afforded to these matters by the Secretary of State rationally ought to reflect that uncertainty. Benefits of co-location and lack of alternative sites, sir. This is a matter which the appellants attach significant weight to. Mr. Goldsmith accepted at the inquiry, however, that there was no locational imperative in planning terms for the scheme to be located at this particular site. There's been no assessment of alternatives. As we have said already, it's an operational preference. Turning to 163, the appellants cannot rationally accept that the proposal in planning terms does not need to be located here, yet give the benefits of co-location significant weight. If in planning terms further studio space does not need to be at this particular site, how can lack of alternative sites attract any weight at all? It has not been established there are no suitable alternative sites on which new studio space could be developed. The precondition to the benefit of this thing does not exist, and Mr. Dingle was right to give it no weight. So turning penultimately to sustainability benefits and improved connections, we don't dispute that this site is in a sustainable location. Its development, however, entails environmental and planning harm. That harm arises in a context where there is no evidence of whether further studio space could be accommodated on a site which entails less harm. The use of renewable energy is really an example of a development consuming its own smoke. The reasons given by Mr. Dingle, the sustainability benefits of the development should be given limited weight. Again, no dispute that improved connections for pedestrians and cyclists would be a benefit. With respect, they are not major improvements to Boreham Wood Town Centre. Mr. Dingle is right to give this moderate weight. And finally, BNG. The scheme offers in excess of 10% BNG. There's a policy requirement, however, to enhance or restore biodiversity. It's not applicable to this scheme, but 10% BNG is a statutory minimum expected of all new major developments. The reasons given by Mr. Goldsmith as to why a modest increase justifies the second highest weighting in his scales are not articulated in writing, and the reasons given by him in cross-examination by my learned friend Mr. Sheikh were, with respect, not convincing. It's a benefit, but self-evidently a modest 10% gain does not justify weighting towards the very top of the scale. So our overall conclusion of 167, I won't read it out. We say there are no VSC for all the reasons I've given. Overall planning balance and conclusion. The proposed development is inappropriate development in the green belt. It's not accepted from that definition by paragraph 155 of the NPPF. We say there are no VSC which clearly outweigh the substantial harms to the green belt or the harms to landscape or tree loss. The scheme is plainly in breach of the development plan taken as a whole. It now appears to be common ground. There's non-compliance with policy CS12, SADN 12 and SADN 26. And there is, for the reasons given by Mr. Dingle, a breach of policies SB1, CS13 and CS30. No case has been articulated as to why independent use of the appeal site, which these proposals would permit, is justified in planning terms, or indeed as a benefit. The benefits of the use of the site by Sky Studios must be viewed through the lens that these benefits are contingent upon the site being used as an extension, but there is no requirement in the proposed permission for the scheme to be used in that way. In any event, for the reasons given above, they do not outweigh the extensive planning harm. In our submission, sir, the planning balance falls firmly against the appeal, and for all the reasons, we invite the Secretary of State in the public interest to dismiss this appeal. So, unless I can assist you any further, that's our closing submissions, and I've taken the liberty of putting our appearances on the back sheet of those submissions. The spectre looks to be frozen.
He was moving about a minute ago, so I think it's only the last bit he's lost, Harley. But
Really?
no doubt he'll log back on.
I'm going to read that all out again. My voice is just hanging on.
Yeah, if you just repeat the last 40 pages, that'd be great.
I guess we'll wait for him to rejoin.
Hello.
Hello, sir. We can hear you.
Hi. Yes, I think my Teams call crashed the penultimate paragraph of Mr. Owen's closings, and I haven't been able to get back in via my laptop. So I'm currently talking to you on my mobile phone, which thankfully has the app on it as well. So, Mr. Ronan, you'd be pleased to hear I did hear pretty much everything apart from the last paragraph, so I'm not asking you to repeat anything. I think what we'll do is I think we'll probably take a short adjournment, maybe till 2:30, just to see if I can get the IT working. And obviously, I can use my phone for the remainder of today, but if I can get it back onto the laptop, then that would be preferable. So, unless there's anything anyone else wants to raise now, shall we adjourn until 2:30?
Yes, sir.
Okay, thank you. So obviously, yes, the Rule 6 parties closing submissions have completed, and we'll adjourn until 2:30. Thank you.
Thank you, sir.
Hello everyone, it's 2:30. Can everyone hear and see me okay?
Yes, sir. Thank you.
Yes.
Perfect this time.
Okay, good. Hoping to switch it off and on again. Quick will do. If it happens again, obviously we'll deal with it, and let's hope it's okay for the remainder of today. So thank you again, Mr. Ronan, for delivering the closing. Sorry that I wasn't there at the very end, but thank you for delivering those. I think
Thank you, sir.
I think we didn't give it a number, but I think it's ID 19 for the inquiry document purposes. But, and I think you mentioned about a couple of conditions. I think you were paragraph 16. You referred to condition 21 for that use class. I think that's now condition 19.
Yes. Sorry. So when I was drafting these, completely escaped my mind that that numbers had changed. I was looking at the
numbers had changed a couple of places, yeah.
But you know in substance what I'm referring to.
Yeah, and likewise, paragraph 154, you referred to condition 23 for the film and TV studios.
That's now 20, I think.
That's now 21. Appreciate, yeah. These things change all the time, but just for the record. But thank you. So we'll move to the council's proposing submissions next. I have had an email in the last few minutes, last 10 minutes, about noise conditions. I don't know whether we want to discuss that now or later on. If anyone's had the chance to look at it yet, we may not have done. Because it's only come through from the appellant, I think, in the last 15 minutes. Mr. Tucker, I think that came from Lichfields.
That's exactly right, sir. So it's been sent, I think, circulated to the principal parties, and it's the issue of condition 10 and the reason for the 10 decimal below, and you having proper evidence from a noise consultant rather than the recollection of a planning KC, which is far better, and also comment upon the differential approach between 10 and 11. I'm also told Mr. Morris's redacted email has been added to the core document, as has the letter from the MP.
Okay, thank you. Mr. Sheikh, do you want, in terms of the, well, you may not have any comments on this from the council's perspective, with an open to Rule 6 query.
So I haven't seen it yet. It hasn't made it to me.
Okay, maybe we'll
yeah,
maybe Mr. Falcone can look at that during the next, we can come back to it later on. And likewise, Mr. Ronan, again, you and Mr. Taylor may not have had a chance to look at this email yet either. So maybe something we'll come back to later on if needed.
Yes, certainly. Thank you.
Okay, thank you. Well, if there's no other procedural points before we move on, then Mr. Sheikh, I have a copy of your closing submissions. I think this should be ID 20.
Yes.
Thank you. And then if you're ready, please begin.
Yes,
I don't think I've yet got a copy, Mr. Sheikh. I don't know if you could send one through, please.
I have emailed one, so hopefully it'll be with you if it's not already.
Thank you, Mr. Sheikh. Thank you. Sorry to interrupt, sir.
That's okay. Are we happy to begin then? Yeah. Mr. Tucker, you don't need it. Okay, fine. Okay, Mr. Sheikh, please, when you're ready.
Thank you, sir. I set out at the beginning, so glossary, and then at paragraph 1, the introduction. The NPPF is clear. The fundamental aim of Greenbelt policy is to prevent urban sprawl by keeping land permanently open. The essential characteristics of Greenbelt are their openness and their permanence. The introduction of Greybelt land in December 2024 therefore came with strict and clear requirements that development has to meet in order for a scheme to benefit from the policy shift of what would otherwise have been inappropriate development in the Greenbelt requiring very special circumstances. The fact that the site is Greybelt is therefore not the end of the matter in this appeal, and paragraph 155 of the NPPF ensures that development on Greybelt land is only considered not inappropriate development in the Greenbelt where all of a number of important criteria are met, including under A, where it would not fundamentally undermine the purposes taken together of the remaining Greenbelt across the area of the plan. If it fails to do that, the scheme reverts to be considered under the VSC test, and that is the test that we say must be applied to this development, and applying that test, it's firmly contended the outcome of this appeal should be dismissal. I set out paragraph 2. The appeal was made by Legal and General Investment Management Sky Studios against the council's decision and the description development and the site location. At paragraph 3, the appeal proposal was considered by the council's planning committee. It was recommended for approval by officers. However, members resolved to refuse the application for the reasons set out in the decision notice dated the 19th of April 2024. The main issues in this appeal identified by you, sir, which reflect that reason, are as follows, and I set that out at paragraph 4, and I've included the slightly amended first issue with reference specifically to paragraph 155 of the NPPF. At paragraph 5, I indicate that each of the issues will be taken in turn below, with the exception of the third issue, where for clarity the Council does not dispute that there is a need for the development, and therefore main issue C does not form part of the Council's case, other than as part of the planning balance. I turn then to inappropriate development in the Greenbelt. It is a matter of agreement between the appellant and Council that the site constitutes grey belt under the newest iteration of the NPPF. However, in order for development to be considered not inappropriate development in the Greenbelt, it must also meet all of the requirements of NPPF 155. 155 of the NPPF states the development of homes, commercial and other development in the Greenbelt should also not be regarded as inappropriate where all of the following apply, and that includes the development would utilise grey belt land and would not fundamentally undermine the purposes taken together the remaining grey belt across the area of the plan. The policy basis for this appeal has been continually evolving since the Council's decision, where the current NPPF was not in effect. At the time of statements of case and proofs of evidence, the new PPG had not been released, which was only published on the 27th of February of this year, 3 or so weeks before this inquiry commenced. Given the recentness of both the new NPPF and PPG, this inquiry relies on previous Greenbelt assessments carried out as part of the preparation of the Council's new local plan. Although the Regulation 18 draft local plan has been formally set aside, the evidence base comprises the most up-to-date assessments, and in many ways those assessments nevertheless reflect the 3-week-old PPG, which states that assessment areas should be sufficiently granular to enable the assessment of their variable contribution to Greenbelt purposes. It is a matter of agreement that Stage 2 GBA better reflects the PPG than Stage 1 because it is more granular, and indeed in comparing the Stage 2 GBA with the PPG methodology for assessing the contribution land makes to the Greenbelt purposes, Mr Williams expressly found that when cross-referencing this scoring to the PPG methodology, the Stage 2 GBA findings are robust and aligned with them. There is no dispute that Stage 2 GBA forms the relevant assessment for the purpose of this appeal. Indeed, that is why the appellant has not prepared a site-specific GBA for this inquiry, and any disagreement, therefore, with its final conclusions are wholly matters of professional opinion made in the absence of a separate independent assessment that can be properly evaluated, assessed or tested. Where the appellant has adopted the Stage 2 GBA but cherry-picked parts it disagrees with, caution ought to be taken where there is no alternative assessment. The recent PPG has also provided further detail on the interpretation and application of NPPF 155A, although it is fair to say that rather than providing clarity, it leaves much to be desired. It states a Greenbelt assessment should also consider the extent to which release or development of Greenbelt land, including but not limited to grey belt, would fundamentally undermine the purposes taken together of the remaining Greenbelt across the plan area as a whole. In reaching this judgment, authorities should consider whether, or the extent to which, the release or development of Greenbelt land would affect the ability of all the remaining Greenbelt across the area of the plan from serving all 5 of the Greenbelt purposes in a meaningful way. First, both the NPPF and PPG indicate that paragraph 155A requires considering all of the Greenbelt purposes under paragraph 143, not just A, B and D, which are considered when establishing whether a site is grey belt. That includes, therefore, purpose C, which is particularly relevant in this appeal and which we return to below. Second, the elephant in the room, what does meaningful actually mean? Mr Williams' attempt in cross-examination to equate it to significant does not reflect the plain language interpretation. A supporting actor might not be the star, but their role might still be meaningful in the context of the film. Similarly, a small-scale solar farm meaningfully contributes to the green energy agenda, even though it's not an NSIP. To that extent, a reasonable interpretation of the PPG would be that a Greenbelt parcel could meet one of the purposes in a meaningful way by moderately contributing to that purpose. In fact, it is quite reasonable to suggest that any contribution, even if it's low, is still a meaningful one. Mr Williams' attempt to sidestep the question in cross-examination by suggesting that we cannot consider meaningfulness against the low, moderate, strong contribution scale was evasive, especially given he had actually carried out that exercise in his rebuttal. Ultimately, Whether the scheme complies with paragraph 155A is therefore a holistic planning judgment applying the somewhat ambiguous test of meaningfulness in the context of the wider greenbelt across the plan area. There is, as such, a range of reasonable conclusions on the basis of planning judgment, and fundamentally, however, it's certainly not a mathematical exercise of percentages and proportions. Turning to the GBAs, the site sits in sub-area 47 in the Stage 2 GBA, which forms part of the wider Parcel 18 in the Stage 1 GBA. The methodology adopted in the Stage 2 GBA is described at Step 4B, Wider Impact Assessment, which states, in addition to assessment against the MPPF purposes 1 to 4, a qualitative assessment was undertaken to identify the roles of the sub-areas as part of the GBA parcel within which they're located, and the wider greenbelt. Where relevant, the impact of the cumulative loss of adjacent sub-areas was also considered. The qualitative assessments considered the following. At the first bullet, what is the role of the sub-area in the context of the GBA parcel within which the sub-area is located? How does that perform? How does the performance of these areas compare? How important is the sub-area to the performance of the parcel? The second bullet, would the potential release of sub-area impact on the assessment of the remaining parcel and adjacent sub-areas or parcels? For example, would the scores of the adjoining sub-areas or of GBA parcel within which the sub-area is located or adjacent to be likely to change as a result of the subdivision, and if so, to what extent? And the third bullet, would the potential release of a sub-area harm the long-term protection or integrity of the surrounding greenbelt? The Stage 2 GBA assessment therefore applies a sub-area analysis, assesses the relationship between the different sub-areas, considers the sub-area in the context of its wider parcel under the Stage 1 assessment, and importantly, the wider greenbelt. Whilst not necessarily in that order, it is in practice an incremental approach. That approach firmly aligns with the PPG requirement to consider the wider greenbelt across the area of the plan. Indeed, it adopts a logical methodology to do so. Next, considering the detail of the Stage 2 GBA, sub-area 47 is assessed as contributing moderately to purposes 1, scoring 3 out of 5, and 3, scoring 3 out of 5, and provides a low contribution to purpose 2, scoring 1 out of 5. Mr. Williams' conclusion that these findings are robust was reached following a site visit and on the basis of the existing Sky Studios having been constructed. No suggestion is made by Mr. Williams that the contribution results in the Stage 2 GBA should be reduced or amended following changes to the baseline. The contributions also ought to be seen in the context of the other sub-areas assessed. SA47 is one of 11 sub-areas out of a total of 72 that contributes moderately or strongly to Purpose 1 in the entire plan area, because Borehamwood is the only relevant large built-up area. In respective Purpose 3, it also scores higher than the sub-areas directly adjacent to Borehamwood to the west, which contribute weakly. The Step 4B assessment for sub-area 47 considers the removal, which would equally apply to development, of the sub-area in isolation and in combination with the neighbouring SA48. In relation to the latter, it concludes in combination with SA48, the release of the sub-area is likely to significantly alter the performance of the wider greenbelt by encroaching on the countryside in a visual sensitive part of the greenbelt, given its strong connections with the wider greenbelt. Whilst that obviously does not apply to the scheme, given the site sits in part of SA47 rather than the whole of SA47 and 48, that conclusion is consistent with the Step 4B assessment for SA48, which states the sub-area is directly adjacent to a small part of SA46 to the west and to SA47 along the southern edge, with which there are strong visual links in the eastmost part. If removed in its entirety, SA48 is likely to result in the unconstrained irregular outward sprawl of Borehamwood to the east and would diminish the performance of SA47 to the south against the MPPF purposes, in particular by physically enclosing this area, Purpose 1, and introducing urbanising influences along its northern edge, impacting upon its unspoilt rural character and visual openness, Purpose 3. This would also adversely impact upon the wider Greenbelt Parcel 18 to the east. The removal of SA48 in combination with SA47 to the south would result in significant encroachment due to the strong visual connections eastward to the wider countryside. In isolation, the Stage 2 GBA concludes the following in relation to the removal of development or development of SA47. The sub-area is directly adjoining to SA48 on its northern boundary. Built form already exists on this boundary, and so removal of SA47 is unlikely to significantly reduce the neighbouring sub-area's contribution to Purpose 3, given the existing urbanising influences. The A1 boundary to the southeast also serves as an additional barrier to sprawl and in maintaining the gap between settlements. Mr. Williams' recital of this conclusion in his proof does not reflect what it actually says. For example, Mr. Williams' proof of evidence states, "This confirms that the presence of built form on the SA47 northern boundary would lead to SA47's removal from the greenbelt being unlikely to reduce the neighbouring sub-area's contribution to Purpose 3. His proof also states the Stage 2 GBA therefore concludes that SA47 would not affect SA48's encroachment into the countryside. Neither reflect the presence of the word significantly. The word significantly is vital because the GBA concludes that although the development of SA47 is unlikely to significantly reduce the extent SA48 contributes to Purpose 3, it does not say that it will not have a reductive effect. Indeed, given SA48 contributes strongly to Purpose 3 in isolation, scoring 4 out of 5, there will patently be an inevitable reduction if even part of SA47 is developed. In short, the development will necessarily affect the neighbouring sub-area's contribution to greenbelt purposes, and it is entirely logical that reduction to this contribution could have a wider impact on the greenbelt. The final conclusion at step 4B in relation to SA47 is therefore wholly consistent with the assessment when it states, due to the openness of this area of the greenbelt, the release of the sub-area is likely to alter the performance of the wider greenbelt around Borehamwood. It is consistent both with the in-combination assessment with the neighbouring SA48 and the sub-area specific assessment contained in the Step 4B assessment of impacts on the wider greenbelt section in the SA47 analysis. Indeed, Mr. Williams quite rightly stated that he was happy to accept that the conclusion was not an error, as he had alleged in his rebuttal. His disagreement with the conclusion is his professional opinion, a judgment reached in the absence of his own independent assessment and in the context where he otherwise considers the Stage 2 GBA assessment robust. The outcome is that the Stage 2 GBA conclusion plainly applies to the site, and it therefore follows that paragraph 155A is not met. As such, the development is inappropriate in the greenbelt and requires BSC under paragraph 153 to seek consent. I turn then to the effect of the proposal on the openness and purposes of the greenbelt. As inappropriate development in the greenbelt, the scheme is by definition harmful, which attracts substantial weight in the planning balance. Moreover, there can be no dispute that there would be a very high level of spatial harm to the greenbelt openness as a result of the development's footprint and volume, either taken in isolation or within its context of neighbouring developments, on a site which is currently and otherwise devoid of development and laid to pasture. As a result of the level of site coverage, the spatial openness of the site would be in effect lost entirely. Indeed, Mr. Williams goes a step further and considers that there would be a high impact on the spatial openness of the entire sub-area, SA47, as a result of the development, which would introduce buildings and hard surfaces over some 11.86 hectares. In respect of visual openness, the development would be visible from a range of viewpoints. What is currently greenfield and internally open would become overwhelmingly suburban, including through the introduction of lighting, activity and intensification of the site. Given the development would be up to 27.5 metres in height, it would be visible from and around the site, particularly to the north, west and east, despite the boundary hedgerows and trees, and particularly in winter months. A further projection of this built form north will further erode the openness of the countryside setting to the north of Borehamwood and the west of the A1 corridor. Mr. Williams' conclusion that the effect on visual openness would be low is in part based on his conclusion that the LVIA confirms that there are no long-term visual effects higher than minor adverse. That conclusion is misplaced insofar as the LVIA actually concludes that there will be up to moderate adverse visual impacts, and it therefore ought to be shifted up the impact on openness scale and given more weight in the planning balance than that attributed to it by Mr. Goldsmith. Turning to the purposes of the Greenbelt, the site makes a moderate contribution to purpose A. It lies adjacent to a large built-up area, contains no permanent development, and has a strong sense of openness and rural character. The development would therefore abolish in full the site's contribution to purpose A. The development would also undermine purpose C, where the site makes a relatively strong contribution towards safeguarding the countryside from encroachment. The site forms part of the countryside in terms of both its intrinsic character and its spatial relationship to the surrounding Greenbelt land. It currently retains a distinctive sense of place that reflects its predominantly open pastoral appearance, vegetated boundaries, and visual relationship with the adjoining open countryside and settlement edge. The development comprising buildings, internal road infrastructure and parking would have an urbanising effect on the site which would wholly cease to form part of the countryside. There would also be some minimal conflict with purpose B, given the site currently weakly contributes to the purpose of preventing neighbouring towns from merging. In fact, Mr. Williams concludes that there would be wider impacts on the purpose of that SA 47 contributes to the Greenbelt by reducing purpose A from moderate to low, that's a score of 3 out of 5 to 2 out of 5, and purpose C from moderate to nil, i.e. 3 out of 5 to nil out of 5. That is significant because even on the appellant's case, the development obliterates the extent to which not only the site, but the wider sub-area contributes to assisting in safeguarding the countryside from encroachment. The irreversible impact on the openness of the Greenbelt in both a spatial and visual sense, and the conflict with at least 3 of the Greenbelt purposes, would be at odds with the fundamental aim of keeping the Greenbelt land permanently open and therefore carry substantial weight. I turn then to very special circumstances. The benefits of the development must clearly outweigh the potential harm to the Greenbelt by reason of its inappropriateness, together with any other harm to amount to VSC. As Mr. Faulkner explained in oral evidence, a failure to demonstrate VSC amounts to conflict with the most important policies in the development plan and therefore conflict with the development plan as a whole. Harm to the Greenbelt includes the definitional harm, harm to openness and harm to the purposes of the Greenbelt. However, for reasons which are still not clear, Mr. Goldsmith did not address or consider definitional harm or harm to the purposes of the Greenbelt as part of his planning balance. He simply required in cross-examination, they should be in there. Mr. Goldsmith's brave attempt in re-examination to suggest that definitional harm had been taken into account because he stated that there is no definitional harm to be weighed in the planning balance on the basis he argues development is not inappropriate, was a valiant attempt to explain away obvious omissions. Even then, there was still no consideration of the harm to Greenbelt purposes in his planning balance. His attempt to suggest that his opinion on VSC would remain the same was off the cuff in cross-examination and was not properly part of his proof of evidence planning balance. It also probably explains why Mr. Faulkner's view was that the very special circumstances balance was much more finely balanced than Mr. Goldsmith. In addition to the substantial definitional harm to the Greenbelt and substantial harm to openness and to the purposes of the Greenbelt, there is an agreed landscape harm attracting moderate weight. The importance of the landscape harm cannot be overlooked. It is a distinct harm that would arise as a result of the proposal. The ES addendum indicates that both during construction and operation, i.e. indefinitely, the residual effects, i.e. after mitigation, would be moderate and significant in EIA terms, effect on the landscape character of the site. There will also be a minor to moderate adverse effect on the Arkley Plains landscape character area within which the site sits. The visual impacts set out in the LVIA remain up to date, which include minor to moderate adverse impacts on pedestrians and cyclists along the A1, and pedestrians using the footpath to the north and east of Rowley Farm during both construction and operation. Context is provided in the visual assessment, particularly when considering viewpoints 4, 5 and 7. Moreover, it is evident that the site is visible from a number of viewpoints north, west and east, and that there will be a change and visual impact to varying degrees as represented by the viewpoints. That also includes the permanent loss of hedgerows considered important due to their historic interest, and the removal of 80 individual trees, including 25 Category A trees. Whilst Mr Faulkner accepts that very substantial weight should be attributed to the economic benefits of the development, which he explained in evidence in chief includes need and co-location, which is separately weighed and subdivided by Mr Goldsmith, substantial weight to socio-economic benefits and significant weight to improve connection for pedestrians and cyclists, he does not agree with Mr Goldsmith's significant attributions of weight to sustainability or biodiversity net gain. It is considered that many of the sustainable design and transport features are required to meet national and local policy requirements to make the scheme acceptable. In particular, the Fabric First approach merely conforms with the requirements of the Council's carbon offsetting draft SPD. There would also be a limited wider sustainable benefits, predominantly in the form of enhanced local bus services. Given the improved connection for pedestrians and cyclists has been separately attributed significant weight, sustainability ought to attract just moderate weight in line with Mr Faulkner's professional opinion. Similarly, the Council's recently adopted Biodiversity Net Gain SPD, which supports policy SADM 10, Biodiversity and Habitats, within the Council's local plan, site allocations and development management policies, requires a minimum net gain of 10%. That also reflects the new requirement under the Environment Act 2021. It cannot be said that simply achieving 10% BNG off-site is a significant benefit. That was, however, Mr Goldsmith's evidence, who indicated in cross-examination that he would attribute significant weight to any BNG at 10% or above. Whilst it is accepted that the fact that something is required by policy does not mean it is not a benefit, the policy expectation or minimum requirement sets a helpful contextual baseline where Mr Goldsmith rightly accepted that percentage level is relevant to weight. Mr Goldsmith's approach would fail to incentivise any developer to ever achieve more than 10%. That plainly cannot be right, and his starting point of attributing significant weight by achieving the bare minimum does not reflect that schemes can and do provide much greater levels of BNG than this scheme at circa 13%. Furthermore, Mr Goldsmith stated in cross-examination that he had taken into account the fact that off-site provision of BNG was going to be secured in the same borough as the development. However, that is not what the unilateral undertaking actually secures. The UU requires that reasonable endeavours are taken to secure BNG on Rotherham Estate. However, if that is not achieved, a further 4-month period is permitted to find any alternative site whereby a cascade mechanism requires it to be as close as possible. Ultimately, however, the BNG receptor site could be anywhere in England, i.e. on the other side of the country, or failing that, a biodiversity deficit contribution is paid to the council. In reality, there is no obligation for the BNG receptor site to be at Rotherham Estate, and the uncertainty under the UU must be relevant when attributing weight to BNG as a benefit. Mr Faulkner therefore attributes this limited or at most moderate weight, which must only be correct in light of all of the above. Accordingly, as Mr Faulkner explained, the benefits either individually or cumulatively do not outweigh the clear and substantial harm to the greenbelt and landscape palm. Mr Goldsmith's assessment overinflates the benefits and omits substantial harms. The consequence is that VSC do not exist and therefore planning permission should be refused. I turn then to my conclusion, sir. Whilst there are obvious substantial benefits associated with the proposal, the requirement to demonstrate VSC is not automatic and is a high threshold, a threshold that requires the planning considerations of the scheme to not just be special, but very special. The development would give rise to substantial harm to the greenbelt, comprising definitional harm, harm to the spatial openness, which is accepted as high, and visual openness, and harm to the purpose of the greenbelt, which is accepted to go beyond the site and impact the wider sub-area. It would also give rise to landscape and visual harm, the former being permanent and significant in EIA terms, in relation to the landscape character effect on the site. With that too comes the removal of high-quality trees and important historic hedgerows. The appellant's attribution of nothing less than significant weight to each and every benefit fails to reflect what is actually secured, and the council firmly submits that the benefits do not clearly outweigh the substantial harms, such that VSC do not exist and planning permission should be refused. Accordingly, therefore, the council respectfully invites you, sir, to recommend that the Secretary of State dismisses this appeal. So unless I can assist any further.
Thank you, Mr. Sheikh. Nothing further from me. No points of clarification. But thank you for delivering the council's closing submissions. Thank you. So we'll then move on to the appellant's closing submissions. I haven't received those yet by email, Mr. Tucker. I don't know if they've been sent.
I think they're about to be, sir.
Okay,
I did ask for them as soon as Mr. Sheikh has completed his, that they be sent, if that's okay, sir.
Shall we take a sort of 5-10 minute break just so they can be circulated?
A five-minute break before the next hour and a quarter of our lives of listening to me wittering on, sir, I think may be a wise thing, if I may say so.
Okay.
A cup of coffee may make it a little more palatable to you, sir.
Okay, thanks, noted. Thank you. Well, okay, then we'll adjourn for 5 minutes, come back at 3:05. Thank you.
Thank you, sir.
Hello everyone. It's just gone 5 past. The inquiry is resumed. Unfortunately, I haven't had the closing come through yet. I have alerted my case officer to them. I don't know if they've been uploaded to the Google Drive yet. I can always work off that.
Yeah, I think Miss Wheatley is the IT guru and puppet master behind the scenes for the appellant team. So hopefully, I think she's emailing me now. It has been sent to the case officer, and she will now upload it to the core document, sir.
Okay, well, we'll wait for a second just to check, Mr. Shake and Mr. Ronan. Do you have copies?
Yes, thank you.
Okay.
Yes, sir, thanks.
The problem of relying on emails, you think it would be instant, but not always. Let's keep an eye on the Google Drive, see if that's going to update. Whilst we're waiting, I suppose in the meantime, is there anything else to say on the condition, the noise condition? I don't know, Mr. Taylor's had a look at it, or anyone else, Mr. Faulkner, whilst we're waiting, whilst make some use of time. Mr. Taylor,
Yes.
have you had a chance to look at it?
I have, sir. I suppose our comments, and we're not acousticians, but I was struck by the fourth paragraph, where it says it was identified that the noise from backlots or outdoor filming would be likely to be at or just below the background. If anything, that suggests that the precautionary approach taken in relation to design of plant should equally be applied to noise from backlots, because it is at or just below. Now, I appreciate we don't have any other acoustic evidence, but since the local authority has accepted the 10 dB below the background noise level is the appropriate way to proceed, notwithstanding that doesn't seem to be the case for other local authorities. Rule 6 party is still not persuaded that a similar position should not apply where we are at or just below the background noise for what may be noisy outdoor activities, and there's no detail before the inquiry of what those outdoor activities might be.
Okay, thank you, Mr. Taylor. Anything in response from the appellant, Mr.
You have our position, sir, and the agreed position of the council's EHO that is the appropriate measure for the backlog. And as I intimated, sir, when one tests the issue of nuisance, what he's looking at the extent to which one is in excess of the backlog, not how far below the background one is. But so you'll form your own view in relation to that in any event. I too am not an acoustician, as you've heard already today, sir.
Okay, thank you. Anything else anyone wants to add? I think Mr. Faulkner.
All I'd say is reading the submissions, clearly the environmental health officer at the council was content with the variance between those two conditions, and we obviously as local planning authority are led by our environmental health officers on the approach to conditions with regard to noise. So no, I have nothing else to say apart from that.
Okay, I mean, if I agreed with the Rule 6 party, is it as simple as just amending condition 11 to read in a similar way to condition 10? Is that simply what Mr. Taylor you're kind of suggesting should be done?
Yes, sir. The same logic would apply.
Okay.
I think the key with noise is to make sure that it is imperceptible rather than there is a potential risk, and the planning harm to something that is at or about background noise suggests that there could be a risk. Therefore, you take it below where the risk might actually arise.
Okay. So it's really for me to decide whether or not the conditions should have the same wording or should be separate for the reasons set out by the appellant's email.
Yes,
is that fair summarisation to the appellant, Mr. Tugger?
It is, sir, and that's the logic of the position. Just in response to the point made by Mr. Taylor, perceptibility is not to be equated with harm to residential amenity. But sir, yes, in terms of the mechanics of it, Mr. Taylor's right. That's how you would achieve the same objective.
Okay, thank you. Anything else to add, Mr. Faulkner?
No, sir.
Okay. Well, obviously, if there's nothing more we can say on the matter, we'll have to leave it there. If that email could just be added to the inquiry documents, I think we'll be at ID 22 for that. given that ID 21 is already the appellant's closing submission. And I'm pleased to say, in the meantime, both the email has come through and the Google Drive has been updated. So I should, there will be one moment, should be able to have a copy on the screen of the closing submissions of the appellant. So yes, I do. So that's where we're at. So unless there's any other procedural points from anyone, Mr. Tucker, would you like to start the appellant's closings, please?
Yes, sir. Just one procedural point, sir. We've sent to the case officer a Word version and also a PDF version to you, sir, of the closing submission, given this is a reporting case. I don't know if my learned friends have done the same, but it may be helpful to the case officer to have Word versions as well as just PDF versions to the case officer. I certainly don't need to see them, but it may help assist you in terms of that part of your report, sir, which reports the parties' cases.
Okay. I mean, happy for Word versions from the other two barristers if they're able to provide that.
Yes, of course, sir. Very happy
Yes,
to do that.
no problem. Okay, that's fine. And yeah, if you want to send them through to my case officer, that'd be great. Thank you. Okay, so Mr. Tucker, if you're ready, please begin.
Thank you, sir. Sir, this is 27 pages at 1.5 space or 35 pages at double space, and I've double spaced it to make it easier to read out, sir. So it's probably about the hour and a quarter that I thought it might be, maybe a tiny little bit longer, so there are a couple of footnotes I need to read out. And so to let you know, I hope I won't tax your pen, because we, myself and Ms Hall have added in comments that we wanted to make about my learner friends closing submissions as we go. And where we do, I'll make that clear, sir. It's not my ordinary intention to read out footnotes, but so I'm going to start off by reading out the first footnote, which is entitled Basic Points, if I may. So basic points. First basic point. There is a dispute, sir, on some of the evidence which has been given to the inquiry. Where you identify that dispute, sir, we of course invite you to rely upon your own notes in that regard. And secondly, where there hasn't been cross-examination, especially of lay individuals, that should be, sir, not law individuals, lay individuals, it doesn't mean that the evidence is therefore accepted. This is not a court of law. There is no obligation to put your case to each and every witness who says something that a party disagrees with. And yet, sir, there is repeated comment about, quote, unchallenged evidence in my learned friend Mr. Ronan's closing, and an especially egregious example being that part of the not needed case of paragraph 85 of the closing, which relies upon Ms Dunford's statement about what was or was not said by someone who gave no evidence before you about the intention of the appellant. Her recollection of what was said is actually strongly disputed on my instructions, and indeed it's not even known if she was present at the meeting, but the point is that the issue goes literally nowhere. Either the evidence before you demonstrates a need or it doesn't. It isn't furthered or hindered by what might have been said at a coffee morning for a local MENCAP group. That's not to say there's no purpose of cross-examination, however. It's intended to test and scrutinise the evidential base of a party's case. A clear example of that being how Mr Falconer essentially conceded that the scheme would not fall foul of paragraph 155A in cross-examination, but that doesn't preclude Mr Sheikh from heroically putting his own instructions and closing on the basis of his client's case. But it does mean that he's doing so in the teeth of his own witness's concession and unsupported by actual professional evidence. So turning from that addition to introductory matters, paragraph 1.1. The starting point for this appeal is that it involves a major investment into the local and national economy at a time of substantial economic need. The figures are stark. Based on Mr Gunn-Jones' unchallenged evidence, once constructed, the appeal proposals will generate £4.4 billion worth of gross value added to the United Kingdom economy in the next 10 years, and 3,827 direct and indirect and induced jobs in the wider economy. What is proposed is therefore a major boost to the UK national economy. On the evidence, if Sky Studios are not able to expand their business here, then it will invest in an expansion in one of its other existing studios, most likely in the United States. At such an opportunity cost, in Mr Gunn-Jones's words, of the loss of such a substantial amount of foreign direct investment opportunities to the national economy is a matter that ought to cause the Secretary of State the greatest of concern if it is lost. Now, that's, of course, not to diminish the importance to be afforded to Greenbelt policy. Rather, that as and when one reaches the point where one has to weigh benefits and harm in the decision tree, there is a very, very large positive outcome that needs to be properly taken into account. After hearing the evidence, sir, you set out the main issues, which I think you've now heard read out twice, so I'm not going to read those out, sir. Paragraph 1.4, it will by now be apparent that the issues as between the council and the appellant are strikingly narrow. such that Mr. Falconer agreed in evidence that if you, sir, agreed with our position in relation to 155A of MPPF, i.e. the development would not fundamentally undermine the purposes taken together of the remaining greenbelt across the plan area, then in his professional view, that's it. The appeal should be allowed. There should be no other reason to withhold consent. The facts leading up to the position the council now takes are instructive. First, the development was recommended by officers for approval and informed by a detailed, carefully written officer's report, which considered that very special circumstances existed to justify the development. The officer's report did not go on to consider greybelt issues because it was written prior to the December 2024 MPPF at a time when the proposals were undoubtedly inappropriate developments in the greenbelt. Members took a different view, however, to officers based upon seemingly a different weighting. Following the refusal of permission by the council, as you know, sir, in December 2024, MPPF was revised, and happily all of the principal parties to this appeal now all agree that the site falls within the definition of greybelt within the glossary to MPPF, and all agree that none of the footnote 7 caveats apply. The council persists in its greenbelt reason for refusal, notwithstanding the recasting of national policy, which has resulted in a clear strengthening of the case for this development within the greenbelt. When that's added to the strengthening of MPPF economic policies, which underscores the national government's commitment to encouraging economic growth, it is somewhat baffling that the council did not remit the matter back to members with an invitation to reconsider their refusal in the light of those changes. So you, sir, have the benefit of Mr. Falconer's professional view on the issue whether the proposals fall foul of paragraph 155 of MPPF, but you are unassisted by the resolved position of the council itself in this regard. Judged sensibly, the balance should lie even more in favour of the appeal proposals now than at the time when they were recommended approval by officers. The only substantive difference between the council's case and that of the Rule 6 party, it turns out, relates to paragraph 155B of MPPF and whether there's a demonstrable need for the development proposed. We could, of course, turn to that in more detail below, but by way of introductory comment, it's difficult to see how this argument could ever have been sustained in the face of, 1, the council's agreement that there is indeed a demonstrable need, to the point that in the first iteration of the Regulation 18 plan, the council, actually proposed allocating an even bigger site to meet the need that it had identified. And 2, clear independent market evidence showing a requirement for grade A studio floor space in this region. And 3, the appellant's compelling expert evidence indicating the same, as well as the evidence from Sky Studios itself that their existing site is limiting growth and that there is an urgent need to expand onto adjacent land. The existing studio has been something of a runaway success, such that Mr. Davis's evidence is that Sky Studios South is currently running at 80% occupancy, which in the industry means it's fully utilised. So against that background, sir, I turn to your main issues. Main issue 1, the inappropriateness issue. Starting point is that all the main issues consider the site's grey belt within the meaning of the glossary. In other words, the site does not strongly contribute to any of the purposes A, B or D of including land within the greenbelt. Therefore, greenbelt is the only major policy of restraint applying to this site. There is no relevant harm to heritage assets, flood risk or indeed any other major barriers to development. In relation to how the site and the sub-area of the greenbelt within which it sits contributes to the purposes of including land in the greenbelt, the council's greenbelt assessment stage 2 assessed sub-area 47 as simply meeting purpose A, weakly or very weakly, purpose B, not meeting, forgive me, sir, that's A, weakly or very weakly, purpose B, and not meeting purpose D at all. There is no evidence before you, sir, to suggest that the site is even strongly performing against the purposes relevant to grey belt assessment. Any finding otherwise would be lacking in any evidential foundation, contrary to the position of the 3 professionally represented parties before the inquiry. Mr. Williams sets out in his rebuttal that the agreed position of the parties is that the Hertsmere Stage 2 Greenbelt assessment is sufficiently aligned with the methodology and guidance in the PPG that its conclusions as to the lack of strong performance of the parcel within the sub-area within which the appeal site sits supports a robust conclusion that the site comprises grey belt. The main parties to the appeal are agreed that paragraph C of paragraph 155 is met, the site is in a sustainable location, being located within an easy reach of the main Thameslink railway station, accessibility by bus, cycle and a walk from the station as well. It's agreed the golden rules don't apply, no affordable housing here, and it's only against paragraph 155A, rule 6 in the council, and 155B, rule 6 alone, that should be, sir, that there is any debate. Turning to those areas of debate within relevance to paragraph 155, turning to 155A. The first part of 155A is met, so it's the remaining part of 155A that's at issue. It's worth pausing on the proper approach to the latter part of 155A. The decision maker is here required to consider whether the development proposals would fundamentally undermine the purposes taken together of the remaining greenbelt across the area of the plan. The PPG says that this requires consideration as to whether the release of land would affect the ability of all the remaining greenbelt across the area of the plan from serving all 5 of the greenbelt purposes in a meaningful way. So can I deviate from text again to respond? I think my only substantive additional point to Mr. Shake's closing, and it's footnote 5. So paragraph 11 of the council's closing, Mr. Shake seeks to argue that the question of whether or not the rest of the greenbelt could still fulfil greenbelt purposes is to the low threshold of whether it's meaningful. With respect, he's fallen into something of an error of not reading the paragraph properly. The paragraph in the PPG is intended to be consistent with MPPF 155, i.e. would there be a fundamental undermining of the purposes of the rest of greenbelt? In other words, in the vernacular, does it have a big impact on the rest of the greenbelt? In that context, the PPG second paragraph is clear. Is the effect so gross that the residual greenbelt cannot fulfil one or more of its purposes in a meaningful way? It is not a sentence which asks whether or not there is a meaningful impact of the development upon the purposes of the rest of the greenbelt. It just doesn't say that. It is asking the decision maker to assess the function of what is left of the greenbelt, not whether there is any non-trivial impact on the greenbelt. And with respect to the inventiveness of Mr. Shake, the PPG and paragraph 15 of MPPF need to be read carefully and the words given their obvious meaning. If I may say so, sir, you need to read the PPG really quite carefully so you don't fall into the error that Mr. Shake has. Paragraph 210. It can be seen straight away that the vast majority of council's existing greenbelt assessments will not provide a complete answer to the question posed by MPPF paragraph 155A. Given the content of MPPF at the time of its preparation, this council's stage 2 greenbelt assessment understandably does not assess the effect of the loss of a sub-area on the whole of the remaining greenbelt, let alone whether or not any or all of the greenbelt purposes would be, quote, fundamentally undermined. The council's stage 2 assessment therefore cannot be used as a direct proxy for the assessment which is called for under paragraph 155A, but it's nonetheless a useful evidential basis upon which to draw professional judgment, provided that the judgment is applied with that caution in mind, as well as remembering that it deals with a parcel which is much bigger than the appeal site. The assessment, assesses the greenbelt by sub-area and considers each of the sub-areas' performance in relation to each purpose of including land in the greenbelt. That's step 4A. Step 4B is then said to be a wider impact assessment. The council clearly misconsidered that step 4B should be seen as a complete answer to the question posed by 155A, as Mr. Faulkner did no further assessment within his written or his oral evidence before you. At first glance, it does appear to be useful, but the detail of the study just doesn't support the view that it is a proxy. And indeed, by the end of cross-examination, Mr. Faulkner also agreed that the stage 2 greenbelt assessment does not answer the question posed by 155A. Step B sets out to consider the roles of the sub-areas as part of the greenbelt parcel within which they're located in the wider greenbelt. But the devil's in the detail. The third bullet in the methodology states the assessors pose themselves the question, would the potential release of a sub-area harm the long-term protection or integrity of the surrounding greenbelt? Also, when one reads what the assessor actually considers in relation to this parcel, it's clear that any reference to wider impact is related only to considering impact on greenbelt parcel 18 and at the most the wider greenbelt around Boreham Wood, which is a much smaller area than is covered by 155A. As such, and as explained by Mr. Williams in his oral evidence, there are two fundamental differences between the Stage 2 Greenbelt assessment and the questions posed by 155A. The study considers the loss of the sub-area. 155A asks the question as the effect of the development. Here, the development area is less than a third of the sub-area, so the effect of being considered is entirely different, with the Greenbelt assessment considering a much higher degree of impact on the Greenbelt. The Greenbelt assessment, in fact, only considers the effect on the surrounding Greenbelt and not the area of the remaining Greenbelt across the entirety of the local plan area required by 155. As such, the Greenbelt assessment considers a greater degree of change as against its effect upon a smaller area. NPPF 155A, by contrast, asks for an assessment of the effect of a much smaller area of change as against a much larger area, and then adds the higher test of fundamentally undermining rather than just adversely affecting. When viewed from that lens, and as agreed by Mr. Faulkner and as explained by Mr. Williams, whilst the Greenbelt assessment is a useful evidential starting point, it's nothing like a complete answer to the question facing you, sir, and the Secretary of State. In this context, that step 4B for parcel 47 should be read, and on a careful reading, it's clear that any conclusion as to significantly altering the performance of the wider Greenbelt cannot be simply read across when asking oneself the question as to the effect of the appeal proposals on the Greenbelt across the whole of Hertsmere. Firstly, that conclusion relates to the effect of an area of much greater change, the wholesale release from the Greenbelt of both all of SA 47 and all of SA 48, which clearly isn't what's proposed here. And secondly, the resulting harm of in-combination loss is primarily due to the release of SA 48 and not SA 47. SA 48 is plainly far more sensitive and contributes far more strongly to the purposes than SA 47. When considered in isolation, the Greenbelt assessment considers SA 47 only performs moderately against purpose A and performs more weakly against the remaining purposes than the Greenbelt parcel as a whole. Those are the magic words which were missing from the earlier part of the closing submission, sir. Performs only moderately against purpose A. Whereas SA 48 is described as meeting purpose A more strongly than the wider parcel, possessing an unspoilt rural character, and its removal would cause the unconstrained irregular outward sprawl, causing an impact on the wider Greenbelt. And thirdly, whereas the removal of SA 47 from the Greenbelt in isolation is said not to significantly reduce SA 48's contribution to purpose C due to existing built form on the boundary between SA 47 and 48. So accordingly, the findings that SA 47's removal would affect the wider Greenbelt in the assessment need to be seen in the light of: 1, it considers the release of the entire sub-area, whereas the appeal site is less than a third of SA 47, and 2, the Greenbelt assessment strongly suggests that any real harm to the wider Greenbelt issue arises from the in-combination loss of 47 and 48. Otherwise, the loss of 47 in isolation would presumably have a greater effect on SA 48 than is said to occur. So when it's properly understood, therefore, any suggestion that the loss of 1/3 of SA 47 has an effect on the Greenbelt in Hertsmere as a whole seems entirely in contradiction to the findings of Hertsmere's Greenbelt assessment, which states that even the loss of SA 47 would not even significantly affect the next door sub-area. SA 48's ability to meet purpose C, let alone the entirety of the Greenbelt in Hertsmere. In relation to whether the development would then fundamentally undermine, it was eventually agreed by the witnesses that a numerical and qualitative assessment was required. It is the appellant's case that it cannot be sensibly suggested that the release of what is a small proportion of the Greenbelt in the district could ever be said to fundamentally undermine the performance of the remainder of the Greenbelt across the entirety of Hertsmere. And indeed, were that not the last thread of argument open to the council, it must be seriously doubted that this would ever have been a dispute at all before you, sir. This part of the test was agreed by all parties to amount to a high bar to surmount. Mr. Williams' careful evidence explained that post-development, the remaining 99.8% of the Greenbelt in Hertsmere would continue to perform the purposes of including land within the Greenbelt. There would continue to be very significant tracts of land between Boreham Wood and Potters Bar, which are open to public access via the public right-of-way network. Urban sprawl is effectively contained by the A1 as a strong defensible boundary to the east, and the appeal scheme would not result in or even materially contribute to the merger of settlements. The site currently serves no role in respect to the setting of historic towns, and so would naturally remain the same, and Purpose E just wouldn't be affected. Yeah, that should be Mr. Faulkner, not NF. I do apologise. TF, not NF. Sir, did not undertake the same careful analysis, and it would surely be uncontroversial that large areas would remain, and the loss of a site which presently does not contribute strongly, which in itself to a wider area of wider parcel of land 18 and only contributes moderately, is very unlikely to result in a fundamental undermining of the purposes of Greenbelt across Hertsmere as a whole. Ultimately, Mr. Faulkner agreed sensibly in cross-examination that the appeal proposals would not fundamentally undermine the purposes taken together of the remaining greenbelt across the area of land, a concession which ought to have led the council revising its position in opposing the appeal had it chosen to act reasonably. Mr. Dingle agreed that his was not a robust position, given his agreement that there was no assessment before the inquiry to support his view that purposes A, C or E would all be fundamentally undermined by the proposals. Ultimately, sir, there is no evidence to support the position initially taken by the council, nor the Rule 6 party in this regard, we say, and notably the council's witness has now sensibly resolved from that earlier position. Little wonder then that the Rule 6 party have gone on to try and argue a further point under paragraph 155. However, based on the council's case, if the above analysis is correct, then as conceded in cross-examination, the appeal should be allowed. The proposals would amount to not inappropriate development in the Greenbelt, and there is no other basis for withholding consent on their case, save for that single reason for refusal. B, demonstrable need. Only the Rule 6 party takes issue with Part B of paragraph 155, but if they're wrong on this and wrong on 155A, then as with the council, it was agreed there is no other basis for dismissing the appeal. So on Mr. Dingle's evidence, the appeal should be allowed. At the outset, under this issue, it's crucial to understand the nature of the proposals, as explained in opening. It cannot be stressed strongly enough that this is not a speculative proposal for a new footloose studio. Rather, it is a proposal for the expansion of an existing successful studio operated by one of the largest operators in this sector, whose uncontradicted evidence is that the experience of the last 3 years is that this is a development which is immediately needed. The studio is operating at full capacity, and there is a commercial imperative to expand its operations as soon as possible. The Rule 6 party appeared to suggest, for the first time in cross-examination of the appellant's witnesses, that the development, which is the subject of this appeal, could somehow come forward theoretically as a standalone studio in its own right, for which there was no need. A stance which is directly contradicted by how its own statement of case understood the case, a stance not trailed anywhere in Mr. Dingle's evidence, oral or written, and which appears to have been made up partway through the inquiry. It is, with respect, hopeless kite flying and smacks of desperation and a lack of confidence in the strength of the arguments at that stage being propounded. As it is a thoroughly bad point. There are a number of significant issues with such a submission. I've added if it's to be made, sir, because I wasn't sure whether it would still be maintained in closing, but it is, so I'll read this, sir. 1. As explained by Mr. Goldsmith, the layout plans very clearly depict a site joined by 2 bridges into the existing Sky Studios site. The appeal proposals are patently designed as an extension and would require, on his evidence, a complete redesign if they were to be operated by a different operator. 2. Not only would the plans require amendment, the commercial reality of the situation is that, as Mr. Goldsmith and Mr. Davis explained, there is 100% no chance of a rival operator wanting to be located immediately adjoining Sky Studios. 3. Nor would a freestanding next-door studio work for Sky on the evidence before you, sir. The existing studio operation has found it essential to have a backlot, which is governed by the temporary consent. One of the benefits to Sky of the appeal proposals is the permanent ability to retain a backlot. The upshot of the Rule 6's suggestion is that a rival operator would locate next door and essentially be able to outcompete Sky because it would then have access to the backlot. A desirable feature, but Sky would not. That simply wouldn't happen. It is a bizarre suggestion to contend that Sky would fund an appeal for a scheme which would make its existing studio operation worse. 4. The proposed development isn't even designed as a freestanding studio in any event. Mr. Davis pointed out it was ridiculous to have a multi-storey car park as the first building to greet a visitor, and why on earth would there be a need for links to the existing studios on the layout? It is correct that there is nothing in the description which listing it as a quote extension, but even if there were, this would not realistically operate as a constraint as suggested in the manner of the Rule 6 party submissions. Such a constraint would need to be imposed by a condition or an obligation, and no one, and I'm including the Rule 6 party at any stage of this inquiry, sir, no one has suggested any such condition, as it is blindingly obvious that such a condition isn't needed. Finally, and importantly, the decision maker is to have regard to the probable outcome of granting planning permission and is entitled to have regard to the assurances made by the applicants, even if it's not formally passed the planning permission or not formally secured by an obligation. It is clear that the overwhelmingly probable outcome is that Sky would use this expansion land for exactly the purpose that they've said so. It is operating a successful operation, operating at capacity, which wishes to expand. There is simply no rational basis for assuming that it would give that up to a rival so as to commercially disadvantage itself. So as such, sir, the Rule 6 party suggestion lacks reality and should be rejected. It's no more than an ill-fated exercise in forensic kite flying to enable Mr. Ronan to arrive at a eureka moment in his cross-examination of Mr. Davis that a freestanding studio of 200,000 square feet would fall below the definition of a Grade A studio in the Knight Frank report. It is a straw man argument, not trail in the Rule 6 party statement of case. It's proof, it's oral evidence, and runs directly contrary to its statement of common ground. And I've no idea why that's still highlighted, so apologies for that. Not only did the point fall flat on its face, but it actually makes the contrary point if you think about it. Since an overall scheme of well over double the supposed minimum, it underscores that what is proposed is obviously Grade A, as Mr. Davis forthrightly explained, thereby snipping the string to the forensic kite. With respect, the appeal proposals should be assessed on the basis of what they are, the expansion of a successful business onto adjoining land. That's having been said, as Mr. Goldsmith explained in cross-examination, even if the appellant was wrong about that, and it just isn't, there's still ample evidence of need for a studio floor space more generally in the market. Mr. Davis's evidence is entirely based upon providing to the inquiry that the evidence of market demand against supply and concludes there is a large unmet need for studio floor space within the area which is not occupier specific. The other matter to address at the outset of this point, sir, is the definition of need. At times, sir, the Rule 6 party appears to suggest that need within the PPG should only be equated with essentiality or requirements. A very similar submission was made and roundly rejected by the Court of Appeal in the Cherkley campaign case, in relation to a policy requiring applicants for a golf course to demonstrate need. The court, in fact, rejected the contention that need meant necessity. As in Cherkley, there is nothing in the policy wording itself or in its context which suggests that need means anything near as high as essentiality. The wording just doesn't put the test that high. And so the Secretary of State is not coy about using the term essential. She does it 18 times elsewhere in the NPPF. So with respect to the Rule 6 party, where ordinary words are used in national policy, they ought to be read with their ordinary and natural meaning in context. Need has to be understood in that ordinary and broad sense, i.e. whether the requirement is capable of being met by establishing the existence of a demand for the type of development which is not being met by existing facilities. Interpreted properly, the appellant will satisfy this test where there is a demand for studio space not being met. Indeed, as Mr. Goldsmith explained, need is multifactorial in this case, since whatever the need position may be for the rest of the region or indeed the rest of the industry, this appellant, Sky Studios, has a specific, very real need to expand. The need to expand to accommodate the largest productions wasn't seriously challenged at the inquiry, and whilst Mr. Davis was taken down a thoroughly odd line of cross-examination as to whether he had been able to independently assess what he was being told by his client, that the Sky Studios South was operating at full capacity, there is precisely zero evidence before you, sir, to contradict that position, which Mr. Davis has sense checked with his professional judgment. And sir, I add, that's what experts are meant to do. So Rule 6, third party in the Rule 6 party have also gently questioned whether it really would be so unworkable to locate an expansion elsewhere. To which the answer is an emphatic yes, it would be unworkable. undesirable, and simply would not happen, as Sky explained in their tenant statement. In that scenario, the investment would be made elsewhere in the world and not an alternative site in Hertsmere. In cross-examination of Mr. Goldsmith, it was pointed out that operating a split site had been tried, and therefore it can be done seemingly with the inference that because if it can be done, it should be done. But with respect to the enthusiasm with which the point was taken, it goes nowhere. Sky has expanded rapidly. It has tried various innovative solutions to address a site which is bursting at the seams, a temporary backlot, the use of panettone over the road, and even during the filming of Wicked, the use of another studio for part of the production some miles away. And based upon that actual experience, it's come to this inquiry to explain to you, sir, it just doesn't work, either in terms of additional production costs and also, crucially, because of the logistics of how such a split site would and has operated. So had Sky come before you and simply assert that it didn't think a split site would work, then it would be rightly criticised for not having at least tried it. As it is, they are able to come before you and say it doesn't work based on experience. And it's telling that the other principal studio operators in the UK have also sought expanded operations and not studios operating from multiple locations. And equally tellingly, sir, no party before you has put forward or even tried to identify any particular alternative site which is said to be suitable, with the only site even being gently suggested by one third-party speaker being panettone. With respect, need is robustly demonstrated in the documentation. And then, sir, finally, the Council's own studies and published policies establish a picture of need within the area. So core document 6.9 is the Council's economic development strategy. It notes as an objective to maximise investment into the borough through the growing film and TV industry, ... help support other creative businesses and share the benefits across the supply chains. It is therefore a stated aim of the Council to grow the film, TV and media industry in this area, including specifically, like you can get a name check, Sky Studios. Growth here requires physical growth or additional sound stages, and there's no other land surrounding the existing site which could accommodate an expansion, given it's surrounded by existing development on three sides. The 2024 report notes the acknowledged turbulence in the industry, but then says, despite this, demand for content production in the UK in recent years has outstripped supply of studio space, while total UK film and HETV expenditure has grown by over 300% over the last decade. The provision of production space has not expanded at nearly the same rate. The report recommended that Hertsmere should respond to the demand for studio space in their area by, amongst other things, evaluating proposed studio developments proactively. The report says, proposed studio developments have the potential to help address the industry's immediate needs. That's the point, so you may wish to underline 4 times, but also enable Hertsmere to foster economic growth and cultural development in the region, further strengthening Hertsmere's hub. The Southwest Economic Study, sir, same year, whilst it says that it's not possible to provide a robust quantitative assessment of future requirements for studio space, notes a broad indication of potential requirement was the sector is likely to require between 2 million and 3.22 million square foot of studio space between 2022 and 2028. Secondly, based on this evidence, the Council's initial proposal was to allocate the appeal site together with a wider parcel of land to the north in order to meet that identified need. As you know, sir, the now withdrawn Reg 18 draft plan proposed an allocation in draft policy E6, which was designed to establish a special policy area for film and TV production, including delivery of a new film studio complex, ironically taking up much of Greenbelt parcel SA47. And whilst that allocation is not being pursued in the draft plan, the stated aim of the Council as at April 2024 was still in that plan to ensure, quote, there are sufficient sites for jobs and investment, recognise the importance of this sector, making sure we have policies to secure employment for our local people. And its aim was, quote, to expand the film and TV industry in Boreham Wood and Elstree. These plans were naturally written prior to the encouragement in the December MPPF, paragraph 85, to allow each area to build on its strengths, and paragraph 86 to positively and proactively encourage growth in line with national industrial strategy and local industrial strategies. I then quote, sir, from paragraph 87 of MPPF. which you'll be well aware of, sir, having had it read out to you a couple of times at the inquiry. And then, sir, this is plainly highly relevant given the stated locational needs of industry, both in terms of the cluster and Sky's own particular expansion needs to be on adjacent land. Thirdly, there is the objective evidence for the need for studio space generally in the UK and in the Southeast in particular. Knight Frank's analysis on supply presents a compelling picture of need, and they quote, sir, and again, I don't intend to read that out because it's already been quoted to you in short form, but I will read the words in bold if I may. Based upon the capacity utilisation rates for the region, this additional spend will, in their view, require an additional 1.28 million square feet of studio space by 2029. They go on to say, however, most of this space was delivered in the years 2021 and 2022, with more recent years falling far short of the required delivery rates. A significant shortfall in studio space development could hinder the West London cluster's ability to sustain its dominant position in the global production landscape, which is also likely to have a negative impact on the wider UK market. Suffice to say, sir, end of paragraph 240, that Mr. Dingle's view on spend in the industry being down are just not backed up by a review of the evidence, including wholly independent evidence from Knight Frank. Fourthly, Mr. Davis's evidence provides expert evidence to you, sir, on the topic of need, and is the only systematic analysis based upon actual experience founded in the UK and UK film and TV industry. His evidence shows the identified need by Knight Frank of 1.28 million square foot of studio space is actually unlikely to be achieved, and the estimate of 1.3 million square feet in the pipeline being deliverable has fallen dramatically since that report to practically nil, with two major schemes now having been pulled for reasons unconnected with the need upon which the appeal scheme now relies. Mr. Davis explains that Sky Studios is well positioned to be attractive in the market. It's very accessible to central London, within the West London cluster, and it's therefore able to take account of existing local supply chains which have established around that cluster, crew and other companies who've located themselves in or near the cluster to avoid excess travel and cost. The cluster is thought of as the most sought after studio location in the whole country. In terms of supply, Mr. Davis explained to you, sir, that a number of proposed developments aren't coming forward, are unlikely to come forward, or are not open market as they're already under an exclusive lead to a particular provider. As such, while the pipeline of supply appears at first glance to be promising, the reality is very different, particularly when looking at grade A supply, which is what Sky Studios undoubtedly will be. For instance, at Pinewood, the expansion land is now proposed as a data centre, and Sunset Studios' proposals have been withdrawn. There is practically no grade A studio space consented on his evidence, and it's therefore incredibly desirable for this key sector of the UK economy to have an operator on board, as with the appeal proposals, to ensure the success of any development. Available grade A space is therefore limited, and other proposals face real difficulties coming forward. As Mr. Davis concludes, the appeals proposals represent a unique opportunity in the sector, given the adjacency, the existing site, given credible funding, and given a media company wishing to commit to delivery. He also concludes the supply side of the equation is more nuanced than just looking at simple floor space. Quality is important. And in that context, he concluded the appeal proposals would, quote, sit at the pinnacle of UK studio facilities and would be highly desirable. In terms of market demand, that's been clearly demonstrated, we say. The council rightly agreed with the appellant on this point, and as such, given the proper interpretation of the term need in NPPF, there is palpably a demonstrable need for the development proposed. The evidence of demonstrable need, sir, we say is overwhelming with respect, and it takes a peculiarly blinkered view of the evidence to conclude otherwise. Main issue 2, the effect of the proposal on the openness and purposes of the Greenbelt. As set out in opening, sir, this is a main issue which in the real world would only take relevance if you, sir, and the Secretary of State conclude that the proposals are not in accordance with paragraph 155 NPPF and comprise inappropriate developments in the Greenbelt. So Mr. Williams provided clear evidence to you, sir, that in his view, the proposals would have a high degree of impact on the spatial openness, but a low degree of impact on visual openness. He was cognizant of the various elements of the appeal scheme, given that, as he explained in oral evidence, based on his assessment upon an expansion of an existing use. It's a real benefit, of course, sir, to those seeking to assess the effects of the proposal in this appeal, that the proposals represent an extension of an existing use which is already operational on existing land, and you can see it, sir. Mr. Williams' assessment therefore included the required degree of movement, activity, height, dimension of buildings, etc. Notably, of course, structures such as marquees, which appear on the existing Sky Studios site, are there pursuant to a local development order, not pursuant to the original grant of permission or any permitted development rights, which would be replicated by the appeal proposals. So as such, sir, when you saw the studio, sir, you actually saw a level of activity of existing use, which is actually more intense than the appeal proposals. One of many points not mentioned in the Rule 6 parties' comments. The appeal proposals include around 23% vegetation and landscaping. The sub-area would contain post-development, around 28% built form for an existing 6%. Mr. Williams considers that to be a high degree of effect. Given the acknowledged effects, understandably, that wasn't seriously challenged. As to visual openness, notwithstanding the impression given by cross-examination of Mr. Williams, the scale of visual effects is actually a matter of agreement with the council. Most of the visual effects are entirely agreed, and where there are differences, it's agreed the differences are not significant. It was agreed that the LVIA was undertaken in general accordance with Glivia, and the methodologies agreed between the council and the appellant. It was agreed the viewpoints assessed in the chapter of the ES are representative of visual effects, and the viewpoint photography has been presented in line with relevant guidance. It's agreed there are well-established trees and hedgerows on the site boundaries, most of which will be retained. It's agreed, as between the council and the appellant, that the mitigation planting proposed is extensive, and the appellant's taken up the council's recommended quantity of planting. It's agreed aftercare will be addressed by the suitably worded condition we talked about this morning. The mitigation will be in part a balance against the loss of existing trees and hedgerows, albeit there's an agreed residual adverse effect on landscape character. In relation to trees and hedgerows, as Mr. Williams explained in his oral evidence today to you, sir, the appeal proposals include planting 77 extra heavy standard mature native trees. In other words, a 220% net gain in terms of number of trees in relation to those needing to be removed. It's proposed there's over half a hectare of woodland to be planted, and whilst 637 metres of hedgerow will need to be removed from the interior, over 900 metres of hedgerow will be put back. There are no landscape and visual matters or matters going to the harm to openness of greenbelt, which are actually contained in the matters disagreed section of the Statement of Common Ground with the Council. Mr. William explained to you, sir, that the visibility of the scheme in the wider landscape is actually low, with most views of the scheme limited to glimpses around the site boundary. And of course, you'll have noticed this on your site visit, sir, and you've seen the photo montages. It should also be noted, as Mr. Williams explained, viewpoint 4 is taken from the public right-of-way, which operates as a de facto cul-de-sac, and until recent change in the vegetation at the eastern edge, it wasn't possible to walk onwards or under to the A1 to join the route to the northeast, which is shown on the OS map. Mr. Williams explained in his oral evidence that as a result, based on his visits to the site, it did not appear to be used to any real degree, and you'll have formed your own view on site, sir. Further, the viewpoints relied upon by the Rule 6 party are taken from the walking fields to the north of the site. There are no marked public rights of way on the OS map and no signage on the ground to indicate that this is publicly accessible land by right. Mr. Williams suggested it may be permissive, but as it is not publicly accessible in the true sense, this, in line with GLVIA 3, would diminish the weight to be given to the views from here. And so you've heard the discourse about that this morning. Notably, the site also sits within a parcel of land assessed as being the least sensitive to commercial development out of all the sites immediately adjoining Boreham Wood. So if one was going to place commercial development in Boreham Wood, it's therefore on the council's own assessment the best place for it in landscape terms. For these reasons, sir, as Mr. Williams concludes, the overall assessment on the impact of openness is medium, albeit, of course, substantial weight should always be afforded to any harm to the openness of the greenbelt. In relation to the purposes discussed above, the starting point is that the wider sub-area of which the site is a third only performs moderately against purpose of including land in the greenbelt, we say. Mr. Williams' assessment is that this would reduce to a weak contribution using the GBA's own methodology, given the percentage of built form which will be present in the sub-area afterwards. However, importantly, Mr. Williams considers that the balance of the sub-area would then still perform at a moderate level against relevant purposes. Importantly, the sub-area as a whole would still perform a role in the greenbelt due to the retention of Rowley Lane as an edge to the development of Boreham Wood and the A1 as a defensive boundary between Boreham Wood and Potters Bar. The balance of SA 47 would, of course, be retained in its rural character. Then turns to the need for the development, benefits of co-location and the availability of alternative sites. And apologies in advance, sir, that there's going to be a little bit of repetition in this regard, but I'll try and keep that to a minimum. So as set out above in relation to 155B, there is substantial evidence of need for the scheme and for the scheme being an existing extension, an extension by an existing operation, to be located on the appeal site as opposed to anywhere else. Contrary to the somewhat bizarre suggestion made by the Rule 6 party for the first time via cross-examination on day 3 of the inquiry, if the decision maker considers that the test of demonstrable need in the sense envisaged by MPPF 155B is not met, and so rejects the appellant's case on the meaning and approach to need in the context above, then it's not right that the evidence that it seeks to rely upon to establish that need would somehow then have no place in the overall planning balance, which seemed to be what was being put. Mr. Gunn-Jones has carefully set out the enormous economic and socio-economic benefits of the scheme, and Mr. Davies has provided market evidence of demand and lack of supply. Sky have explained at length their need to expand their existing operation, and even if you, sir, or the Secretary of State consider that fell short of demonstrable need for the purpose of 155B for whatever reason, there's still a clear market demand and evidence of need of a successful business to expand and a real requirement for development to be here, all of which, sir, will be important material considerations which would weigh into the benefits side of the assessment. Here, in the sense of the West London cluster, as would likely apply to any significant studio scheme of this scale and nature, but here, in the sense of this specific parcel of land adjacent to the existing operations. And despite the suggestions made by the Rule 6 in cross-examination, but not the evidence of its witness, the proposals are actually a joint venture and a joint application, including Sky Studios as occupier. As Mr. Davis explained, this is a key element of the proposals, especially its deliverability. If more evidence were needed, the tenant statement at Appendix 1 of Mr. Goldsmith's proof explains the unworkable nature of a split site, and the Sky Studios guide to their operation is also of assistance here. In short, sets are designed and then built carefully using a variety of materials, including wood, plaster, and sculpted polystyrene. You, sir, will no doubt have seen the large-scale yet intricate and skilled nature of the work that takes place on your site visit. The scale of the set build is sufficient to fill the entire volume of a sound stage. Such sets are entirely crafted on site within construction departments. The product of this skilled work then all needs to be transported to the relevant soundstage for filming. A feature film will require numerous sets to be constructed, moved and filmed, then replaced throughout the shoots, requiring numerous sound stages at any one time and sets at all stages of construction, use and being dismantled. It's clear that schedule and budget are important considerations in this industry. Anything adding time to a filming schedule adds significant cost to a production and decreases the commercial attractiveness of the film studio. In short, all department from props, costumes, set construction to filming needs to be on lot to reduce delays, to ensure that multiple construction teams can work collaboratively to correctly sequence the set build between carpentry teams, plaster shops and paintwork, for example. Predictability of the delivery to the soundstage or backlot of the element needed for a production at the right time is crucial to a successful production, and thereby to enable Sky to compete for productions that might otherwise be lost to the UK. The tenant statement, sir, provides a real-world example of the filming of Wicked. Significant additional cost was incurred due to the inability of Sky to host the whole production in time. Further, Sky has already sought to expand by renting space at Panettone directly over the road. This has not proven to be a successful arrangement due to the intervening public highway. As explained in the tenant statement, the various construction departments need to be located together. The set needs to be safely transported whilst protecting the delicate set design itself, as well as its intellectual property, to the soundstage. Transporting it via the public highway is a significant challenge for Sky, and one which creates additional cost and delay. As evidenced before you, sir, it's deeply unpopular with productions that would attempt to use it. Sky tells us, sir, in its statement, 4 productions that chose to go elsewhere and directly cited Panettone as the reason for taking their business somewhere else. It's clearly an existing negative influence on the business that Sky requires additional space and cannot provide it on site. The only rational solution to that is an expansion onto the appeal site. For all of those reasons, and as set out in the officer's report to committee, the need to expand the existing site is key and is fundamental to the appeal proposals. Any off-site solution is not a true alternative to the actual scheme proposed, as it would not generate a single composite site. Moreover, Sky and Comcast are clear. This works as an expansion. A second satellite studio would just not be brought forward, and in any appeal dismissed world, the investment would just go elsewhere, outside of this country, to a place such as the United States or Canada. Accordingly, without the specific appeal proposals, the entire investment would be lost not just to Hertsmere, but to this country. In relation to any suggestion that might be made that you, sir, or the Secretary of State would fall into legal error by failing to consider alternatives, our position as to relevant case law is contained within the appendix to Mr. Goldsmith's evidence, and you will have seen that and read that, sir. Taken together, the case law demonstrates that an error of failing to take into account alternatives can only arise if there's a legal or policy requirement to do that, or if the alternatives were so obviously material that it would be irrational not to take them into account. There is no express requirement in Greenbelt policy to assess alternative sites, and as explained by Mr. Goldsmith at his Appendix 11, the requirement in the EIA regulations is to set out alternatives that have been considered already. That doesn't amount to a requirement to consider alternative sites. It's a reporting requirement. There is no legal or policy requirement in that regard. In any event, our case is the very nature of the proposal as an extension is not sensibly capable of being located elsewhere. And so can I just add a response to my learned friend, Mr. Ronan's closing submission. So we've checked our notes and we strongly dispute that Mr. Goldsmith conceded, as he said to by my learned friend, that there was no locational imperative for the development to be located upon the appeal site. Mr. Goldsmith's entire case and his entire evidence were directed to precisely the contrary proposition, and it is strongly disputed that such a concession was made in evidence. Yes, the question may have been put in the abstract, but to put it in the way my learned friend has without qualification at paragraph 123A, I'm afraid, is simply not right. Paragraph 414. In relation to point 2 above, the most recent example of the court's grappling with the submission that alternatives were so obviously material is in the London Historic Parks and Garden Trust case, in which the court considered earlier cases and reached the view that whilst it wasn't essential for a claimed alternative to be a fully worked up proposal, the inspector took a lawful approach, concluding that, quote, in order to garner significant weight, the merits of such alternatives must logically be underpinned by a good measure of evidence, demonstrating their viability and credibility as such an alternative. Here, the Rule 6 party proposes no other specific alternative site, and accordingly, the decision maker could not reasonably afford weight to a generic suggestion that there might be some alternative site somewhere else. In the absence of a suggested alternative with credible evidence to support it as a genuine suggestion, there is no alternative site that could be said to be an obvious material consideration. This is therefore the same as any other case where objectors have simply suggested that the development should occur in an unspecified location somewhere else, should be afforded no weight. In short, it is fanciful for the Rule 6 party to consider that if the appeal were to be dismissed, the proposals might just be located somewhere else in the UK outside the Greenbelt. In an appeal dismissed world, the entire economic opportunities to the UK economy is lost. I next turn, sir, to whether, by reason of inappropriateness, any other harm would be clearly outweighed by other considerations, the VSC issue. So we say that this main issue only arises if you, sir, and the Secretary of State reach the view that the development is inappropriate in the Greenbelt, contrary to our primary case. Should that view be reached, our evidence, we say, demonstrates that even against that high policy bar, there is still ample evidence from which to conclude that benefits do indeed outweigh any harm caused, a view with which officers concurred. Harm. On the harm side of the equation, Mr. Goldsmith includes harm to the Greenbelt, substantial weight, which is comprised of definitional harm, medium harm to purposes and moderate harm to openness, and landscape harm, which includes the loss of trees. And so I just draw your attention to the footnote. It's our very firm case that Mr. Goldsmith did take account of definitional harm, notwithstanding Mr. Shake's submissions to the contrary. 5.3. In relation to tree loss, as set out by Mr. Williams and above, the trees and hedgerows removed are more than replaced by the proposed landscaping, and in this regard, policy SADM12 is relevant. We acknowledge that there is a loss of healthy, high-quality trees and hedgerows as part of this proposal, but as the Council acknowledged, appropriate and more than equivalent planting is proposed by way of replacement. The supporting text of that policy explains that the Council expects these to be retained. However, where a loss is proposed, the Council expects to receive a landscaping scheme as part of any application or pursuant to a planning condition. It is unrealistic to read that policy as mandating refusal where the loss of a single high-quality tree is proposed, without also weighing in the benefits against the harm, particularly in the light of the second paragraph of the policy itself and the supporting text, which clearly envisages the loss of trees and seek their replacement where that occurs. If the policy was read in the manner contended for by the Rule 6 party, a decision maker would never consider the second paragraph of the policy, or indeed consider whether the loss was justified or being required on their interpretation to just refuse the application. It's therefore not to be read as a complete bar on the loss of any high quality tree and should instead be read with realism. Plainly, that's discouraged, but it cannot be sensibly in isolation said to be capable of outweighing a 430 million gross value added per year to the UK economy benefit. Mr. Goldsmith, in any event, includes loss of trees expressly in his moderate weight in landscape harm. There is no harm from highways or transport effects to be weighed in the balance. Mr. Morris's assertion that far more traffic would travel to the north from the appeal site isn't evidence-based. As explained in the highways technical note on Mrs. Balboa's figures, they are evidence-based and crucially are agreed with National Highways. By contrast, Mr. Morris's figures are based upon a number of assumptions which she says does not reflect reality. In particular, a higher number of site occupants than predicted, an assumption that 100% of occupiers will drive, whereas the agreed figure is 60%, and that 35% of those 480 vehicles will rat run to the north. Mrs. Balboa's finding that on an extremely unlikely and worst case scenario, 64 cars per hour, 1 a minute, will take this route is based upon agreed traffic distribution with the Highways Authority and is not considered to be a noticeable increase, let alone a severe effect. On the benefit side of the equation, Mr. Goldsmith considers that a demonstrated need, economic and socio-economic benefits of co-location, sustainability, improved active travel measures and BNG are all worthy of at least significant weight. On our case, on need and co-location are summarised above. On the economic and socio-economic matters, you, sir, heard from the evidence of Mr. Gunn-Jones, who drew upon the Oxford Economics Report. His evidence addressed this specific issue and was searched unchallenged by any other parties to the inquiry. It should be accepted in full as robust and essentially agreed evidence of the nature and scale of benefits of the appeals scheme. The lack of challenge doesn't diminish the importance of his evidence. The context to his evidence is the government's Green Paper, Invest 2035, which highlights 8 growth sectors driving the UK's economy, includes the creative industries sector. The government's stated aim in this regard is to, quote, unlock private investment and, quote, ensure the UK remains globally competitive. The Invest 2035 strategy is expressly referenced in footnote 43 to NPPF, and in relation to paragraph 86A, which encourages planning policies to set out a vision which positively and proactively encourages sustainable economic growth with regard to this strategy. In other words, policies are meant to encourage and support economic growth in the 8 core industries, including this industry. And as previously drafted, the Council's emerging plan did just that, with a large draft allocation to support the growth of the studio sector in Hertsmere. That's something that any new version of the plan will, of course, need to grapple with, and it will also need to grapple with in order to be consistent with NPPF. The Chancellor is quoted as saying the creative industries are a, quote, crucial part of our economy, and she proposed to, quote, support growth in this vibrant sector. Permitting the appeal scheme would do just that, and it goes without saying that you do not support growth or encourage inward investment by a sector by turning down millions of pounds of offered inward investment. Hertsmere plans and policies are considered above. They too refer expressly to the need to support and encourage the growth of the sector, particularly within this region, and take advantage of local skills and businesses within the WLC. Hertsmere's policy is to, quote, maximise investment. In terms of financial contribution which will be brought to Hertsmere and the UK should the appeal be allowed, Mr. Gunn-Jones's evidence is during the construction phase, there will be a full-time equivalent jobs of 749 in Hertsmere, 787 in Hertfordshire and 1219 in the UK as a whole, including direct, indirect and induced jobs. The reason why Hertsmere and Hertfordshire's are so similar is that a substantial proportion of those jobs will be local. In terms of GVA during the construction phase, the same figures are £70.8 million per annum in Hertsmere, 73.8 million in Hertfordshire, and 127.5 million per annum across the UK. And these are the construction figures. But notably, sir, those are per year across the entire construction phase, which is projected to take 2.75 years. So those benefits in absolute terms should be multiplied by 2.75 to derive the total. Again, a very significant proportion of GVA is kept within Hertsmere. Any criticism, sir, such as that you heard on day one by third parties that there would be no local job creation or local benefit is just not borne out on the evidence. And as the operational phase, Mr. Gunn-Jones' evidence is there would be an additional 1,425 full-time equivalent jobs in Hertsmere, 1,500 in Hertfordshire, and an additional 3,827 full-time equivalent jobs across the UK as a whole during the lifetime of the scheme. Again, the figures for Hertsmere and the wider county are similar, as many of the jobs are created are largely local to the site. As set out at 4.2 of his evidence, 4.25 of his evidence, on the existing site, 60%, or approximately 60 of the total core staff, live within 10 miles of the site. There is no reason to suspect the same won't be true of the expanded site should permission be granted, i.e. it's likely to operate in exactly the same way. Third-party concerns, to the contrary, are not supported by the uncontested evidence provided by Oxford Economics or Mr. Gunn-Jones. As for the GVA during the operational phase, the Oxford Economics report and Mr. Gunn-Jones value this as follows. 203 million pounds per annum in Hertsmere, 211 million pounds per annum in Hertfordshire, and 443 million pounds per annum within the UK as a whole, addition to the UK economy. Again, notably, these figures are all per year for the lifetime of the development. As noted at the outset, over the course of the first decade of its operation, just the expansion of the existing studios will generate a colossal £4.4 billion of additional value to the UK economy. In the context of an economic situation where every penny of inward investment must be highly valued, a comment of particular importance on today, given events across the water. In oral evidence, which was not questioned by the Council or the Rule 6 party, Mr. Gunn-Jones stated that the jobs, the GVA figures, were very significant in economic terms, particularly in view of the pressing need to deliver economic growth, which is stated to be the central mission of the government, reiterated by the Chancellor in her spring statement during the course of the inquiry. And as for local benefits, Sky Studios takes local skills and training particularly seriously. Mr. Gunn-Jones' evidence describes their Future Talent programme, which has hosted 2,600 students and has a further 3,000 booked onto the course within the coming months. The Early Careers Trainees programme, which hosts 12-month paid traineeships at the site, has taken on recently 32 trainees, 70% of whom are from within 10 miles. After their traineeship, 70% of graduates took a permanent role at Sky Studios. These are not simply beneficial in general terms, they are to consolidate the workforce of this industry in the local area for the future. The inquiry also heard from Ms. Turner, who explained she'd had experience of Sky Studios' commitment to assisting local people into the industry, and that it was much easier to reach Sky Studios than other studios elsewhere in the southeast because of its existing and excellent rail links with London. She explained that Sky Studios often seek to hire local people and described the operation as being a community-orientated one. Mr. Mitchell, the head teacher of Elstree Screen Arts Academy, also attended on day one of the inquiry and explained 48 of his students had received specific training from Sky, and alumni of his school had taken up permanent roles there. He described Sky as authentic partners in the community and that they already had been meaningfully engaged with the community through workshops, open screening, networking events and collaboration with the Academy to deliver training and outreach programmes. Accordingly, it is clear that in addition to the very significant benefits in terms of full-time equivalent jobs and gross value added figures to the UK economy, a significant proportion of the benefits will actually remain locally to the benefit of Hertsmere as well as the UK. Additionally, Sky has and will take measures to grow the skill set of local children and others wishing to work within this industry. Both Mr. Faulkner and Mr. Goldsmith rightly afforded very substantial weight to the economic benefits and substantial weight to the socio-economic benefits of the scheme. And notably, Mr. Goldsmith stated in his oral evidence that in his view, the economic benefits alone would be sufficient to outweigh the harm. It's also agreed by the three main parties that the appeal proposals are in a sustainable location, a notable benefit given the need for workers and suppliers to travel there, agreed between Mr. Faulkner and Mr. Goldsmith to be worthy of significant positive weight. Mr. Turner was emphatic that such easy public transport links made the studio accessible to a wider proportion of society, whereas other more remote studios are inaccessible to those who don't own a car. Therefore, there is therefore a genuine social benefit to locating development here, in addition to the carbon and other emissions saved as a result of public transport accessibility. Furthermore, Mr. Mitchell described Sky Studios as being at the cutting edge of reducing carbon emissions in his oral evidence. Mr. Davies described the existing development as the most sustainable studios in the UK, possibly the world, and is award-winning in this regard. The proposals also include off-site highway works, which would improve pedestrian and cycle connectivity to the station, a significant benefit that will be felt by the wider community, as well as new, and I should add, sir, existing employees at the site. The proposals also provide the biodiversity net gain of nearly 13% in habitat units, which attracts, we say, significant positive weight. There is no sensible basis for down-rating the level of benefits to biodiversity net gain based on the adoption of an SPD requiring the same, a point rightly conceded at the outset of cross-examination by Mr. Sheikh of Mr. Goldsmith, despite his witness's rather odd contention to the contrary. A real-world effect of the benefit is felt exactly the same way, regardless of the existence of an SPD. And you, sir, and the Secretary of State can have confidence that that will be delivered. As the submitted BNG note explains, both the proposed condition, that's the wrong one now, sir, I think it's 18 from recollection, and the UU provide mechanisms to deliver the required net gain before the occupation of the development. Condition 18 is a Grampian-style condition restricting commencement until a management plan has been approved by the council, which demonstrates how the required BNG will be delivered. At present, the appellant has heads of terms agreed with an off-site provider and expects this will translate into a formal agreement post the grant of any permission. The 106 obligation proposes that this receptor site could be secured within 4 months of the date of the permission, failing which you've then got the cascade which takes place, the bottom tier of which is a financial contribution of £1.76 million. Development above slab level is prevented until an authority's approved details or the payments being made. So accordingly, whilst the appeal proposals aren't subject to the requirement for mandatory biodiversity net gain due to the timing of the application, there is nevertheless a robust mechanism to secure the delivery of that net gain. In conclusion, expansion of the existing Sky Studios, a business which is highly successful, is operating in a thoughtful, sustainable way within the community and is also operating at capacity onto the only available adjacent site is something of a no-brainer. The economic and socio-economic effects are expansive and result in an additional 1,425 full-time equivalent jobs and £203 million GVA per annum to this district. A staggering addition of 3,827 full-time equivalent jobs and £443 million gross value added per annum is the expected benefit across the United Kingdom. This will be in a sector which is earmarked both nationally and locally for growth, and which the Council's own documents consider should be expanded. If refused, this investment will be lost to the United Kingdom to the detriment of the local and national economy. This is, sir, the right scheme in the right place and promoted at exactly the right time. And so for that reason, we firmly commend and would invite you also to commend this scheme to the Secretary of State. So unless I can assist you further, those are our submissions in closing. Thank you, sir.
Thank you, Mr. Tucker. Yes, no, I don't have anything further points of clarification to add. So thank you for delivering those closings.
Thank you, sir.
Thank you. So we'll obviously come to the final points. Are there any other matters arising? Any other points that anyone wants to raise in relation to today? We'll obviously conditions and obligations. We are in agreement that we'll have an updated condition schedule by the 11th of April and the completed Section 106 agreement by the 16th of April with clarification on some of the points raised regarding BNG and that clause 115 in terms of the role of the council and county councils. So thank you. So in terms of next points, I think just want to double check on. I've not been made aware of any applications for costs, but I will do that now. So Mr. Tucker, anything from the appellant?
Sir, after careful consideration, we're not making an application for costs against the council.
Okay. Or the Rule 6, I assume.
Or the Rule 6 party, sir. I should have said. Not to make Mr. Ronan's heart stop at that moment. No, there's no application for costs by the appellant.
Okay, thank you, Mr. Tucker. Mr. Sheikh, any cost applications from the council?
No, thank you, sir.
Mr. Ronan, anything on the Rule 6?
No, no, sir. Thank you very much. There was just one point of clarification arising at my loan of friends closings. If I can address that at some point, could be now. We may have something else you want to address first.
No, go on. If you do that now, and we'll see.
It's just the point. It's just this point about locational imperative. So we have the benefit of the recording, and before I drafted my closings, I re-listened to Mr. Goldsmith's evidence, and I asked Mr. Goldsmith twice the question whether, or I put it to him that there is no locational imperative in planning terms for the development to be located on this site. He didn't answer first time. I asked him again. His answer was no, but what you will end up with is no scheme. So our position is that we have accurately recorded the concession. And if you want to check it yourself, sir, the video is day 3. The timestamp is 6 hours, 31 minutes and 32 seconds.
So 31 minutes. So.
And 32 seconds, yes.
Okay. Okay. Thank you, Mr. Ronan. Mr. Tucker?
Yes, sir. If you take that out of context, it creates an entirely misleading impression. You need, sir, to not just listen to the question and answers as put by my learner friend. You need to listen to the context. And so you need to listen to the couple of minutes before and the couple of minutes after to understand exactly what Mr. Goldsmith was saying. The way in which it's put out of context in my learner friend's closing was the purpose, was the burden of the point I was making. It is emphatically not accepted the way it was put in closing. But, sir, I do invite you also to listen to that particular part of the tape and also check your notes, which I think I said at the very outset of my learner friends, forgive me, at the outset of our closing.
Okay. Well, I've certainly made note of the time on day 3 when that was said, and obviously I can check my notes as well. But, okay.
Thank you, sir.
Thank you, sir.
Anything else on any other points of clarification? Sorry, I should have asked that before we got into costs and things. Okay, thank you. So then, all that remains for me to do now is to obviously say if any remaining documents can be added to the web page, both the council's and the Google Drive. I think we'd probably just I think we'd be up to date with everything apart from the last thing on my list was the email on lighting, which was inquiry document 22. We'll obviously add anything that comes in on conditions or 106 as necessary. And obviously, thank you to both the council and the appellant for having those websites available. And obviously, if those can be kept open until at least the decision is issued by the Secretary of State, and obviously beyond that, if appropriate. My intention is to obviously move on with drafting my report. I will hope to get on that over the course of the coming weeks, next few weeks, and hopefully that you'll obviously be notified when that report has gone off to the Secretary of State, and obviously then she will have a certain time frame to issue her decision. I intend keeping the inquiry open from today until I've received the 106 and the conditions, updated conditions, just in case of any last-minute queries, and obviously makes it more straightforward for me to accept things whilst the inquiry remains effectively open. Obviously, it's not an invitation for anything other than updates on conditions on 106, so I'm not expecting or inviting any further submissions or representations or anything like that. It's really only for the basis of conditions and the 106. Thank you. I think that's all I wanted to say. Obviously, thank you everyone for your efforts and all your time over the last 4 or 5 days, and for the council for hosting both today and also last week. Are there any final procedural queries? Anything from the appellant, Mr. Tucker?
Not for our part, sir, and thank you for clarifying that that's the sole basis upon which the inquiry will remain open. You're not permitting anything further apart from those points.
Yes, unless there's always a rider, isn't there?
There's always the possibility, yes.
Unless there is something unexpected that is material that comes to light, but it would have to be a change in policy or some decision that's been made that we weren't expecting. That's my only rider, but I'm not expecting that. I'm not inviting anything additional unless there is a very good reason for that. So
thank you, sir.
I'll go on record with that Friday. So thank you,
thank you, sir. That's helpful.
Okay.
And as we now know, it's on the record.
Yes, well, indeed, whatever timestamp that was. Yes. Thank you, Mr. Shake. Anything else from the council? Any procedural points?
No, thank you, sir.
Okay, thank you, Mr. Ronan. Anything else from the Rule 6 party?
No, sir. Thank you very much. Just to note, we have sent in a Word version of the closings following my learned friend's suggestion, so that should reach you in due course.
Okay, thank you, Mr. Taylor. You have a hand raised.
Yes, just a very small point. It's probably not a procedural point, but for the Rule 6 party, we are grateful in the way that the appellants and the council have accommodated the Rule 6 party. It's appreciated. Inquiries obviously can be a little bit stressful at times, but genuine thanks to everybody for accommodating us and to you, sir, as well, for the way you've managed this inquiry.
Thank you, Mr. Taylor. Thank you. Are any other points from any interested parties? Anybody else in the call? Any other points to be made? Okay. Well, thank you, everyone. We'll obviously the inquiry will close in writing once I've received all the outstanding documents, and we'll obviously write to you as soon as that's been achieved. But otherwise, thank you all again for all your time, and the inquiry is now adjourned. Thank you,
sir.
Goodbye now.
Thank you.
Thank you.